Yes. Yes. We're permitted to mention on appeal, where your lordship was pleased to direct the matter to appear as a to be mentioned, because substantially hard at that point of time, it was pointed out one of the parties died. My lord was pleased to direct to call for the records, and it was directed the matter to appear in the.
So why to be mentioned?
Yes, so for fixing the matter for hearing. My lord, I have annexed both the orders, earlier order and the last order.
Let it appear as to be mentioned. If you are satisfied, only then.
Is
It will appear as to be mentioned first.
And this is another order.
To be mentioned, Adina. Yes.
Application. Lord.
Application?
Out of 41.
Yes. What? Yes.
Your Lordship.
Lordship, may I be upgradation hearing appeal, Lordship?
Forget it.
Your Lordship application.
Valid application and one Lozima matter.
Yes.
Inclusion in the list, it's a 2017 matter,
2017 what?
FAT, but never moved after that, Your Lordship. And the urgency is that, Your Lordship, is that the execution petition has been filed, wherein 2 months timeline has been given to pay the amount, Your Lordship. A Union of India matter, the petitioner.
From item 42 to 116.
Your Lordship, it may be
Most are urgent.
included in the next monthly list, Your Lordship.
First, let us dispose of some matters. Be present when the appeals are heard out, and we will just. Yes.
Application included.
Application.
4 times I have mentioned this, but
Why is it not coming? Have you inquired?
I
The
have
file is lying
inquired,
where? The application was filed for this court.
filed for this. This was heard by your lordship on last occasion.
It আসছে না কেন দেখুন তো?
This file was sent down to the department. There was a FMAT number.
Now it is lying in the department.
Now it is lying in the department.
Department থেকে কথা রেকুইশন করে আজকেই আনি নিন যেটা
So she
যত
is
তাড়াতাড়ি
committed to mentioning this matter for this inclusions under the heading of application.
hearing of appeal no ma'am.
No, hearing applications.
Application here. Start with application and we'll take it. Application order 41 by default. Yes.
This matter appears at my instance, my lord.
Yes.
I filed a contempt application that should appear before your lordship, my lord, on 24th.
Why didn't you mention the contempt application directly?
Lordship granted leave. I think, my lord, something, my lord, mistakenly, my lord, contempt application is not there, my lord. Lord, I mentioned subsequently also, my lord, and lordship allowed my prayer. My lord, I filed my contempt application. That number is, my lord, 538, and this was filed, my lord, on 25th.
Paper books have been filed. Everything is ready.
Yes, my lord, may kindly see.
Is it appearing in the list for hearing?
It was in the list, my lord, since at my instance, because
Contempt
visitation.
application. Just mention the contempt application. Why mention it? It's to be mentioned.
Lordship,
Give the number of the contempt application. Learned you're for the appellant.
Lordship.
Learned counsel for the appellant submits that the contempt application filed in connection with the appeal may be included in the list. Full stop. The learned advocate is requested to furnish the number of the contempt application and the same be listed at the earliest. Let us hear the contempt first. First you go to jail and then yes.
Instead of that, it would be better to heard of the appeal.
Yes,
For you, not for us. Because other appeals are there.
Yes, my lord, I agree, my lord. If lordship kindly fix a date, my lord, can
Both of you agree, but
Then you have to not place your application.
although we are the Qazi, but we are not. Despite Mia Bibi being there. Next. Please give your names, both of you.
Lordship.
Application.
Lordship,
Yes, you are.
yes, Your Lord, no, it's not my application, other side application, but the fact
Other
is
side,
that,
sir.
yes, Your Lordship, they have suffered a decree. Your Lordship has upheld the decree of preemption in my favor. Now they are not executing the deed. Your Lordship remembers that this came from a city civil court decree. Now they are not executing
What is the application? What is their application for?
Application is that they want a clarification of Your Lordship's judgment, saying that one of the appellants herein who has suffered the decree is not in a position to come from Delhi. So she has executed a power of attorney in favor of her son so that the decree can be executed. Your Lordship, kindly come to the judgment starting from page 9.
No,
Your
they have
Lordship
to
has-
move the application, Mr. Banerjee, first.
But yes, Your Lordship, but the fact is that because of the pendency of this application, they are not even executing the decree in my favor. They are actually in contempt of Your Lordship's order.
We'll record, Mr. Banerjee, that let us first see the clarification. What clarification has been?
Yes, clarification if Your Lordship sees, kindly come to the prayer at page 6. There the clarification, they have stated what clarification.
They have asked that you have to prepare the transfer deed and pay the required stamp duty.
Yes.
So you are agreeable to do that?
No, not sure what has happened herein. I have deposited the entire money when I filed the suit in 2000. Your Lordship,
Mr. Banerjee will do this. Since none is moving the application, we'll say that none appears for the petitioner. And
Yes.
we'll say that this pendency of this will not be an impediment in the execution of the decree.
Your Lordship, the fact is that we are not able to execute before they are going before the city civil court, saying that the person who will execute the decree is not there. She is in Delhi.
You have to impress upon the executive court that there is a decree, they are not moving the application. Our order may help you.
Yes, Your Lordship will then kindly do it.
The present application has been filed for clarification of the judgment and decree dated December 24, 2024, passed by this court in FA number 67 of 2012. Full stop. Although the decree holder stroke opposite parties are represented through counsel, none appears to move the application on behalf of the judgment debtors. Full stop. Learned counsel for the decree holders points out that due to pendency of the application, the execution of the decree is being stalled. Full stop. Since the petitioners choose not to appear at the time of call, we make it amply clear that the pendency of this application shall not stand in the way of the decree holders executing the decree which was passed in their favor. Let the application stand adjourned for the day.
There's only one thing, if I may pray for. The executing court is saying that the appeal court has not said who will pay the stamp duty. Now, if I pay the stamp duty, the consideration price is 2,50,000. Now, if I need to pay the stamp duty, that is on the consideration amount, not the today's market value, because today's current market value is much higher.
That calls for an adjudication, Mr. Banerjee.
No, Lordship was already stated in paragraph page 23.
Place that before the executing
price is
court.
2,50,000.
Place that before the executing court. What can we do? We have passed our judgment. Yes, next.
I'm for the petitioner, Lordship.
Use the microphone, ma'am. Yes.
I'm praying for not today.
What is the application for?
Section 5 application, my lord.
No, not today. Either move the matter or we dismiss for default.
Lordship, Miss Advocate Patagastri Roy
You
is
just
appearing.
switch on the microphone. Yes.
Miss Advocate Patagastri Roy is appearing.
We can't hear you. Thank you. Yes.
Advocate Patagastri Roy is appearing.
We are not interested in that. We are interested in hearing the application. The second application of the day, we definitely won't grant adjournment.
Lordship,
Either move it or we dismiss for default. No adjournment. Sorry.
Lordship, I'm not briefed in this matter. So.
Nothing doing. What is the application number?
Can 2. And 2 is for section 5. My lord, near
What is the delay?
more than, my lord, 8 years.
We can't hear you
And
also.
8 years.
More than 8 years.
But in the application, they have stated 8 years. My lord, I suppose, my lord,
More than that.
it will be more than that.
An adjournment is sought on behalf of the petitioners, appellants stroke petitioners. Who's up next para? As a last chance to the appellants stroke petitioners to move the application, let the same stand adjourned for the day. Who's up, it is made clear that in the event the appellants are unrepresented and stroke or pray for any adjournment on the next occasion when the application is called on for hearing, the matter will be dealt with ex parte in the absence of the appellants.
Good.
Next. The order for the they will order us. Order sheet just দিয়ে দেবেন.
I'm for the petition. Out of 10 respondents, Lord, 8 have been delivered. Only 2 yet to be delivered.
2 yet to be delivered.
Only 2.
Those two. Those two are represented along with by the same advocate.
Yes.
Same advocate.
Yes. There is a section 5.
There are certain defects.
Yes.
This is section 5, so that is one defect cured.
Yes.
Valuation statement furnished in the memo does not tally with the certified copy of the decree. What about that? And several defendants' names are not there in the cause title of the memo of appeal. You rectify the defects, we are giving you leave. During the course of the day, we'll take up the application tomorrow. You are the advocate on record also.
Yes.
We find from the report of the additional stamp reporter that there are defects in the appeal in as much as the names of several defendants in the trial court are not appearing in the cause title of the memorandum of appeal, and the valuation statement furnished in the memo does not tally with the certified copy of the decree. Who stop the learned advocate on record for the appellants is granted leave to amend the cause title and valuation statement of the memorandum of appeal accordingly to rectify such defects during the course of the day. Full stop. Let the application stand adjourned till tomorrow. Do it during the course of the day.
Yes.
Just ascertain from the trial court's decree and implement them as part. And also the memo of the valuation statement.
Valuation statement.
It has to tally with the decree of the trial.
Decree.
But I have a
Yes. Yes.
The last.
I'm sorry, my lord.
Please to direct to serve the.
You are appearing.
I am appearing. Still, my lord, let the affidavit of service be kept on.
Yes.
My lord, in this matter, my lord, Advocate Mr. Pradeep Kumar Mandal is appearing for the respondent. My lord, he is in the stairs, my lord. Kindly, a short pass over, he is in
No,
the stairs.
he'll cross the stairs till your learned friend finishes.
Yes.
You remain. Yes. Yes,
Well,
what is that?
I submitted on the last occasion.
Yes.
I will draw your lordship attention to only 2 orders.
This is an alimony application by the wife.
Section
Acha,
24
the
application.
affidavits of assets, oppositions, these are all ready.
These are all ready. At one point of time, my lord, the coordinate bench was pleased to observe that the affidavit of assets filed by the husband is not satisfactory.
Acha.
But for the reasons I will tell you, lordship. My lord, the whatever statements.
এই শুনুন না, opposition আপনি এগুলো দিন সব, opposition, affidavit of assets এগুলো সব। অ্যাপ্লিকেশনটা বার করে দিন, তার অপোজিশনটা দিন, আর দুপক্ষের affidavit of assets লাগবে। Just find out the pleadings first.
My lord.
Why, in the meantime, tell us why was it insufficient?
But, it is a 2-storied building owned by my husband. But I used to stay at for last 25 years.
You have challenged the divorce decree or your
I have
divorce?
challenged the decree for divorce. I have suffered the decree.
Stay has been granted.
Stay. No, there is no stay.
There is no stay.
There is no. My lord,
You have just now crossed the stairs, so take your breath. Yes.
my lord, no stay was there. My lord, matter was heard from time to time by the honorable coordinate benches. Several orders were passed. Lastly, by Justice Tandon and Justice Madhuresh Prasad was pleased to record some orders. At some point of time, my lord, there are directions from this honorable court asking the local police station to ensure the presence of the husband.
Now they are present.
So whatever.
Yes.
But my application is that I have absolutely, my lord, I have no income. Totally at the mercy of my husband.
Is there any
Yet
child of the marriage?
there are 2 child, both are adult now, both have got married. My lord, husband did not spare a single copper. I have specifically on oath I have stated in my petition.
Son is
I-
unmarried.
The son is unmarried, the daughter is married.
We don't find the opposition of the husband. Affidavit of asset, your application and affidavit of asset is there on record. Affidavit of
Also
asset,
filed.
husband's affidavit of asset is there. You have not filed any opposition to the
No.
only the affidavit of
Only the
asset. Well, we will go by that. We will go by that.
Only the My lord,
Good.
at one point of time, my lord, I
Two
submitted.
children, both now adult and married, so no alimony for the children.
Son is not married. He resides in the same building.
But he's an adult now.
He is an adult.
So let us forget the children for the purpose of alimony.
Yes, for the purpose.
Yes.
Now, my lord,
You don't work.
I don't work. I am a ailing lady of 67 or like that. My lord, I have been residing, although in the same building, but at the order of this honorable court, my lord, one single room with a kitchen and attached toilet was accommodated to me by the husband.
It's a rented accommodation.
No, it's own building
Own
of
building.
the husband. 2-storied building.
He's residing there also.
He is residing there. I am also there, but the learned trial judge found that we have been, although in the same building, we have been residing separately for last about 20 years. At that juncture, my lord, I submitted before this honorable court that if a permanent alimony is granted to me.
Yes, we were thinking in that line also.
That's right. That is what I submitted.
What does the husband do? He must be also aged.
Husband is a retired employee of Punjab National Bank, erstwhile United Bank of India, then Punjab National
See, if you ask for something reasonable, we can convince them, try to convince them.
Bank.
Because they must be on pension now also.
From this honorable court that a lump sum of 15 lakhs should be given to me. To that, my lord, they oppose, his client oppose, he is not.
No, we cannot pass. If they don't agree, then we cannot pass an order without
Yes,
adjudication.
In that case, my lord, the court observed that from the date of the decree, my lord, there was an interim penalty light for 5,000. But I got it till the decree was passed. After the decree, since it is a continuation of the
At the same rate, at the same rate.
today I am asking for 10,000. I tell you, lordship, why? Lord, this decree was passed way back in 1993.
Has to be.
Today we are in 2025.
10,000 alimony you are asking.
10,000
As per their assets, what is their income?
Income is 22,000 and odd he is getting from pension from Punjab National Bank. He is Australian employer. 22,000 and odd sum.
So even 1/3 is less than 8,000. We'll grant 1/3 upon hearing your learned friend.
My lord, subject to your lordship, Lord, I shall be praying Lord, today. Not only for medicine, I require about 4,000. I have given this thing. I had to undertake a
No, we'll hear you.
I had
You'll
to
not jump.
undertake a knee replacement. For that, I had to spend more than 2.5 lakhs. That statement I have also given. Lord, nothing was paid by my husband. I am only praying, Lord, today. Let us forget about the alimony lump sum. My Lord, from the date of the decree till this day, at the rate of 5%, it was earlier directed. Let that sum be paid because it's a continuation of the appeal and 10,000.
No, cannot be deemed to be a continuation of the decree. When did you file the appeal and the application?
My Lord, the appeal filed in 2019.
An application?
Same time.
So we can consider granting from the date of the application, not from date of decree.
Date of the application before the trial court.
Here,
my Lord,
Calcutta you are getting.
2019 itself.
So we'll consider that. Let us hear the other side first.
The only thing, Lord, Lordship will kindly grant Lord 10,000.
We'll hear them. Yes. You please take your seat.
My Lord.
Yes, 10,000 is quite reasonable in modern days.
Yes, my Lord.
So let us grant 10,000.
My Lord, my Lord, I am the husband.
Obviously, you're the husband.
I mean, my Lord, very fast day, my Lord, conjugal life.
Our microphones are not working, or you are not using the microphone? Because we have got accustomed to this microphone. Before microphones were there, we were accustomed to ordinary.
My Lord,
yes.
Very fast during the marriage, my Lord, we are tortured. Thereafter, this.
So you have got a decree, we'll consider that in the appeal. But what about alimony?
Kindly, when the degree was passed, my Lord, he
can't hear you. Please use the microphone properly. Take
when
it
the
towards
degree
you.
was passed, my Lord, the first alimony was when the suit was running on 5,000.
5,000 was long back, 93.
My Lord,
we're in 2025
here
now.
is a file, my Lord, section 24. My Lord, section 24.
Why shouldn't you grant 10,000? Tell us that.
My Lord,
in one sentence.
20,000, my Lord. He, my Lord, produced before this court, produced my all documents.
22,000 you are earning.
Yes, 20,000. Bank report, my Lord.
Bank interest is included.
Yes, bank also filed report.
Including everything, you are getting 20,000.
Order of the honorable court.
Yes.
My Lord, the bank also present here before this court and submitted the report.
So you are getting 20,000 per month.
20,000 or now 22,000.
22,000.
My Lord, I don't know. My Lord, kindly say my respectful submission before your lordships when the my Lord 24, section 24, my Lord disposed of a degree was disposed of, then the petitioner my Lord can claim 25 alimony.
She could not claim 25 because she is challenging the divorce degree.
Yes, my Lord.
If she claimed 25, they
kindly
should have admitted there is a final degree of
My Lord,
divorce.
the divorce suit, my Lord, filed on my Lord.
Forget that. We are granting 10,000. 10,000 is very meager.
2013 till now they have not proceeded the divorce. My Lord, I am the 76 years old.
Maybe. He is also 67.
As per court's order, my Lord, I have given my Lord first floor, and my Lord, I have no money.
We are not giving you anything. We are not granting anything in lieu of maintenance regarding residence. No. But for maintenance, regular maintenance, 10,000 is nothing in modern days. 10,000 ask you come to court by what means?
Then
you personally come to court by what means? How do you come to court? You have a personal... No, tell us. You have a personal conveyance?
No.
How do you come to court? Tell us. No, how do you come to court? How do you come to court? No, tell us how do you come to court? Tell us, you have a car?
No.
Do you have a car?
No.
How do you come to court?
By bus.
By bus. What is your monthly expenses by bus? Tell us that only.
Actually.
And over and above that, food is there, other minimum, and she had a knee replacement, medical expenses. 10,000 is nothing. Nothing we are telling you.
From the date of order.
From the date of filing of this application, not the decree.
No, my Lord, kindly consider.
No. We are
my Lord, kindly consider, my Lord, from the date of first hearing 2024.
If you want, we can grant it from the date of the decree. If your junior insists, then we can grant from the date of decree also. We don't have any qualms. We'll be happy to grant that from the date of the decree. But if you say so, we will grant that.
Application filed on.
Yes, let us grant 10,000.
My lord, kindly consider. But 10,000 or 10,000, my lord, I am 76 years old. Well, kindly consider me. My illness.
Considered. You are considering hard illness also. Hard illness, not only illness, knee replacement.
As per court's order, lower court order, my lord, we have paid all.
In 1993, decree was of 1993.
Yes.
Then you were paying 5,000. Now we are in 2025. Let us add the inflation. Then you have to give more than what you earn. 10,000 is nothing.
Lord, would your lordship kindly excuse me to make only one comment? My Lord Justice Uday Kumar, sitting with my Lord Justice Sen, was pleased to pass diverse orders in this matter. My learned friend is saying 20,000 he is getting out of pension. That is what he has disclosed in his affidavit. My Lord, at the instance of the court, the bank was directed to produce the document what he is now getting. Your lordship will kindly look at this.
All things, all papers.
These are also part of the record. 21,000 and odd was the last.
So we'll proceed on the premise of 20.
And my lord, he received more than 21 lakhs at the time of retirement.
My lord, that's as per pressure by my wife. My lord, I have constructed after retirement. The money, my
But
lord.
this affidavit was erroneous. My lord, that was the finding of this honorable court. It is
I
unsatisfactory.
see my bank balance.
Bank balance.
Nothing.
Yes.
Nothing.
And your wife
For the
will be
sake of my
starving.
wife,
Your wife will be starving on the
For the
road.
sake
My lord, I'm sorry.
No.
I'm sorry, my lord.
For the sake of my wife, my lord, I have constructed second floor by residing there. After retirement, I have spent all the money, my lord, for my wife. I kept vacant with first floor, ground floor.
One room and one kitchen.
My lord,
At
I'll
under order of
direct
this
the
court.
bank to produce the all my records. Then your lordship kindly consider, my lord, 8,000, my lord. I
You rise a little bit more.
kindly
1,000 more.
no. I think my lord is consider my case, my lord. The husband here is before you.
Lordship will kindly dispose of the appeal, my lord.
Appeal.
If your lordship so desires, because I have stated that I don't want to proceed with the appeal. If this alimony and the monthly maintenance is granted, I am not interested.
At the rate of 10,000.
10,000 plus, my lord, this alimony at the rate of 5,000, either from the date of decree or from the date of application, whatever your lordship thinks fit. But I don't want to proceed with the
If you
appeal.
agree to that, then we'll do that right now.
That is expensive for both.
Well,
It will save litigation cost for your client.
my lord, yes.
And 20,000 I have asked for
Kindly
litigation.
direct my kindly, my lord, I am agree, but my lord, kindly I will sell my house because I have no money.
And she'll be on the streets. Then also we'll also have to include the right of residence. It will become much more.
Well,
Permanent alimony, see, we are not in a permanent alimony scenario. If permanent alimony is taken, then assets have to be considered.
assets.
Your assets.
Yes. Yes, only for
Let
my
us
house.
evaluate the assets.
Only for my residential house. Nothing, my lord.
No, they're not agreeable. We are not doing that. The present alimony application has been filed by the appellant wife in connection with an appeal preferred against a decree of divorce obtained by the respondent husband. Stop. Upon hearing learned counsel for the parties and going through the respective affidavits of assets of the parties, we find that the monthly income of the husband is between rupees 20,000 and 22,000. First up, next para, the husband is a retired person and a pensioner, whereas the wife is unemployed. First up, the wife is in her late 60s, whereas the husband is a septuagenarian. First up, next para, learned counsel for the petitioner wife argues that the wife had a knee replacement and has regular medical expenses. First up, on the other hand, learned counsel for the respondent husband also submits that the respondent has medical expenses due to age-related issues as well. First up, although the wife places reliance on the statement of the bank where the respondent has an account, which was produced pursuant to previous directions of court, that the husband received a lump sum amount of rupees 21,90,183.33 along with other pensionary benefits, learned counsel for the respondent argues that the husband spent a fortune in building a second story on his existing house to accommodate the wife on the ground floor separately from him upon obtaining the divorce decree. Push up next para. Thus, taking into consideration the fact that the husband had considered a second story with a substantial portion of the amount received on retirement, we do not lay much stress on the lump sum amount received by the husband at the juncture of his retirement, which was also long back in the year 2015. Full stop. Next para. Be that as it may, although there is no hard and fast rule as to the rate of alimony vis-a-vis the income of the husband, we find that in modern days, considering the life expenses of an individual and the other medical expenses to be borne by the wife, an amount of rupees 10,000 per month would suffice to cater to the needs of the wife, also keeping on balance the income of the husband. Full stop. Next para. Accordingly, Can 2 of 2019 within bracket old number Can 6346 of 2019 is disposed of by directing the respondent husband to pay alimony to the appellant wife at the rate of rupees 10,000 per month from the date of filing of the application for alimony, that is from the month of July 2019. Full stop. Next para. The current alimony for each month shall be paid by the last day of the said month, starting from April 30, 2025. Push up. The arrears of alimony, calculated at the rate of rupees 10,000 from July 2019 till March 2025 shall be paid by the respondent husband to the appellant wife by 6 equal monthly installments, payable by the end of each month. Full stop. The first of such installments shall commence from from the month of April, from April 30, 2025, and thereafter by the end of each succeeding month. Full stop. Next para. The paper books are ready? No. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal is dispensed with. Full stop. The trial court record shall be brought by special messenger to be deposited by the appellant wife within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who's of liberty to the parties to mention the appeal for hearing as and when the same is so ready. You did not claim any litigation cost?
No, 20,000 I have paid.
Over and above the above amount, the respondent husband shall also pay litigation costs of rupees 20,000 to the wife within May 31, 2025.
One more order only. This 10,000 alimony per month you will also be directed. Kindly ensure that
you give a bank account, they'll put it in your bank account.
Yes. Or else it can be deducted from the pension and directly to be.
That will be an attachment order, partial attachment order, not at this stage. If they don't comply, then.
Kindly in that case, in my account, it will be transferred.
Arakta line add kore dao, no orders to cost age. All the above payments shall be made in the bank account of the appellant wife, the details and particulars of which shall be furnished in writing by the learned advocate on record for the appellant wife to the learned advocate on record for the respondent husband by April 11, 2025. By Friday, please furnish it to your
yes, sir, I shall. But only the affidavit service be kept on record. I am extremely great.
Thank you. Next. এটা কি ভুল ছিল কোনো না ইনিশিয়াল করা হয় Yes.
And although my application for injunction has come up before your lordships, but now it appears
Section
from the report of the stamp report
time barred.
that the appeal is time barred.
So you'll file a section 5.
This is not my appeal. Appeal filed by I am for the some of the respondent 1 to 8, 1 to 5 and 8 to 15.
Who is appearing for the appellants, Mr.
Mr. Gopal Chandra Ghosh is appearing. Initially, Mr. Shona Bhattacharya was appearing, but after change, Mr. Gopal Ghosh is appearing.
The injunction application is yours.
Injunction application is of mine.
The appeal arises out of what?
Partition, preliminary
Degree has been granted.
Yes.
But the appeal, if the appeal is time, but we'll give them one opportunity. We'll record in our order that we give them time till for a week to file the section 5 application. We'll direct this application to appear after 2 weeks. If by that they don't take out don't take steps, we'll hold that the time appeal is time.
My lord.
It at the time of call, none appears for the appellant, although the none appears for the appellants, although all the respondents you are
No, I am for the 1 to 5 and 8 to 16.
Although the respondent numbers 1 to 5 and 8 to 16 are represented through their counsel. For next para, it appears from the office report that the appeal is time barred. However, we do not find on record any application for condonation of delay. Next para. Accordingly, we grant a week ' time to the appellants to file an appropriate application for condonation of delay in preferring the appeal. Liberty to the parties to mention the said application for inclusion along with the current injunction application of the respondent. Next para. The application shall next be listed on April 28, 2025. Mr. Rai, what
I
will...
shall
Yes. Just with a server copy of this order, just ask your junior.
My lord, I shall.
So that we, on the next day we can pass an order.
My lord.
Item number 7, my lord, I am for the appellant.
Yes.
My lord, it's my partition suit before the learned court below.
Right.
My lord, there is a deed executed in favor of my client's predecessor by one Dilip Laha. Learned judge below, learned court below did not consider such deed, and
your application does not contain any caption as to what application is this. Only the name of the parties.
Stay application, my lord.
What sort of an application is this? Should not have been accepted.
Stay of the impugned order.
At least you should have the time to write that on at least. What stay? What degree has been? Your suit has been dismissed.
No, suit has been dismissed. Well, the learned court below held that since DBC is a necessary party, and we have that is the thing. Kindly see.
Why DBC is a necessary party according to the chart?
Because DBC has vested some proportion later on, so we have to make them parties.
No, they are co-owners then.
The co-owners, but we did not have that information. Well, and it is a partition suit between the brothers.
You said the suit has not been dismissed. So what did the court do?
Court held that.
Court passed a decree for partition.
Court, my lord, no, my lord. Page,
after holding that, court had to...
comes to the page 11. That DBC was a necessary party who should not have added as a plaintiff in the category of the because he was adduced by both the parties, and hence the court light of discussion the plaintiff failed to purchase foreigner property and hence are not entitled. So the instance suit fails.
Suit was dismissed. You don't know you are challenging a suit, a degree for dismissal. Don't even know that.
Suit was dismissed.
What is the effect of a stay of a dismissal suit?
Stay of the impugned order, my lord. Otherwise,
dismissal. If you stay the dismissal, the suit revives. What will be the effect of dismissal of? It is not a positive direction. A positive degree can be stayed. Something has been directed to be done. Suit dismissed. What will the stay mean? Nothing.
This order
will dispose of the stay application. Will not grant any order on stay. There is no scope of grant of stay, but will direct you to put in the requisites and all those things.
My lord, actually,
will expedite the appeal.
DBC is not a necessary part. DBC is
that will decide in the appeal. The present application for stay has been filed in respect of operation of the impugned decree in the appeal, comma, by which the partition suit of the appellants was dismissed. Full stop. However, comma, there is no scope for grant of stay of a decree dismissing a suit, comma, since no positive decree has been granted in favor of the respondents. Full stop. Accordingly, can 1 of 2021 is disposed of without grant of any stay. Full stop. No orders to cost. Full stop. The appellants shall put in due requisites within a week from date for service of notice of the appeal on the respondents. Full stop. The trial court records shall be called for by special messenger at the cost of the appellants, comma, also to be deposited within a week. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Sub liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. There are certain defects. Somebody is appearing for the respondents. Respondent number 1, but there are defects in the vakalat. You better put in requisites for service of notice on all the respondents. Thank you. বলছি ডিসমিস করে চলেছেন না নন্দনের ধরুন রিভিউটা অ্যাড করে রিভিউ করে দেবেন আপনি জানেন না চলে আসছেন
I am for the
yes
appellant petitioner, my lord. This is an application for substitution of the date of the appellant number 2.
Can 2 is that application?
Yes, yes.
Filed within time?
Yes, yes, within time. I have annexed, my lord, certified date certificate 15th May 2023 died, and my lord, it is
so within time.
Within time. And living behind his widow and only daughter, Rimi Sadhuka. They should be brought on record. My lord, appeal is otherwise ready for hearing. My lord, paper book.
Mr. Poddar, where have you stated the names of the particulars?
My lord, page 3.
Widow, daughter. What about their addresses?
My lord, same address. Number
not
2,
stated
that the
that.
legal heirs of the deceased are residing in the address given in the cost status of the appeal.
Oh, yes. The present application has been filed for substitution of the original appellant number 2, Tapos Kumar Sadhu Khan. Full stop. Next para. Upon perusal of the application, comma, we find that the same is in time and in form. Full stop. Accordingly, can 2 of 2023 is allowed, comma, thereby directing the heirs and legal representatives of the deceased appellant number 2, comma, the particulars of whom have been given in paragraph numbers 1 and 2 of the application, comma, as appellant 2 series in place and state of the said deceased appellant. Full stop. The learned advocate on record for the appellant paper books are prepared.
Yes, yes. Prepared, filed.
We'll give you leave to correct the paper books also and the memorandum. Paper books have been filed in the department, so we'll direct the department.
Yes.
The department shall carry out the necessary consequential amendment to the memorandum of the appeal as well as to the paper books which have already been filed in the department to that effect at the earliest, no orders to cost.
My lord, matter will be district for hearing. My lord, this is my lord, cancellation of my lord, deed of kit, my lord, allegedly executed.
No hearing right now.
My lord, kindly, my lord, did.
No, sir. Next. Yes.
Well, I appear for the husband.
My lord, I am appearing for the appellant.
Appellant.
Wife. My lord, kindly.
You are for the
Police Commission, Chandanagar Police Commissionerate, my lord, there was an attachment of the salary of the husband. Now, my lord, in February, my lord, he has retired. Now, the difficulty is, my lord, your lordship directed that the current maintenance to be paid so long as 2,56,000 arrears is realized, and thereafter subsequently as and when necessary, the matter will be. Now, kindly see the order dated 13th of January, your lordship's order.
No, but he has retired when?
Yes, in February.
So you have to modify that order then?
Yes. And my lord, my maintenance has been stopped because now, my lord, the retirement.
Naturally, because there is no scope of it.
After the order of the Honorable High Court Calcutta, the Bank Authority has realized rupees 2,56,000 from the salary of the respondent is Sikanta Bokshi from month of December 89 so and so, January so and so, February so and so. The same amount has been credited the newly created.
Yes, what did you receive on retirement?
Like 50,000, 56,000, that has been already been paid, my lord.
No,
No, that is the, my lord.
I have
can
specific
produce the,
instruction.
I can also produce the salary slip, my lord.
No, it has been deducted, maybe.
My lord, it has been deducted, my lord, from the salary, my lord.
The entire arrears have been cleared.
My lord, it has been already deducted, my lord. It has already been deducted, my lord.
I make this statement, bank statement also.
My lord, the confusion, my lord, maybe my lord, my client went to the my lord office, my lord, a week ago. Maybe, my lord, but since they have created the separate account, they have, my lord, remitted the.
No, they say that the bank authority has realized that amount from the salary
But
already.
not remitted to my account. Nothing has been, my lord, only 3 months maintenance I have got. 60,000.
They say the said amount has been credited to the newly created bank account.
Yes, to the newly created bank account in the name of the Chandanagar Police Commissionerate.
20,000 per month has been transferred
To the in the name of the Chandanagar Police Commissionerate.
A separate account. Your lordship's direction was clear.
Sir, Banerjee, let him argue first.
The lordship's
Yes.
direction was, my lord, that a separate account should be created in the name of the my lord, Chandanagar Police Commissionerate. The entire salary will be deposited in that account.
We will direct that Chandanagar Police Commissionerate to transfer it to your account right now. That
As your lordship directed.
that will in any way.
Now, my lord, what is the impasse at the moment, my lord? Your lordship's direction was that 2,56,000 cannot be, the entire arrears cannot be credited to me because, my lord, his salary is 89,000 and odd. So your lordship's direction was the entire salary will be deposited in the separate account, but 20,000 per month, the current maintenance to be paid to the appellant.
That was being paid.
That was paid for 3 months. Now, my lord, he has retired. So his salary has, my lord, now stopped. Now the question is, my lord, the retirement benefits.
Current alimony order remains. What is you pay 20,000?
My lord, it has already been given, my lord.
Current alimony, how can it be already given? It
20,000,
accrues every month.
My lord, April 20,000, my lord.
Up to date, you have paid.
My lord.
So thereafter, you will continue to pay that. And you direct the police commissioner to transfer that amount to him because you are not bothered with that. It has already. So he will pay the 20,000.
My lord will kindly direct the.
We'll do that.
And the bank also. And my lord, so far as the retirement benefit is concerned.
My lord, it's not disposable.
Because now there is no salary. So the entire retirement benefit has to be deposited in this separate account.
No, retirement benefit, you don't have any locus standi to seek that direction.
I'm only concerned with the maintenance.
You are concerned with 20,000 per month?
And the
direct him to go on 20,000, paying 20,000. And Chandanagar, the bank will direct the bank to transfer that entire amount of 2,56,000 to your account.
I understand. Yes.
Your account number has been funded.
Yes, yes. They have paid me for 3 months. Everything.
Oh yes, they are paying that. Yes. You are for the police commissioner.
Yes.
What do you have to say?
That is the amount, which
2,56,000.
20,000 per month has been transferred to the account of the applicant. Lord, the copy of the bank statements 30th December to 28th March 2025 is enclosed.
Yes,
that's the current alimony.
Up to March, we have given.
Yes.
Rest amount which is lying, my lord, we shall transfer.
That modification is required. Yes.
Modification is required.
Whatever amount is lying, you have disclosed in your account statement. So whatever, this is the closing balance 1,96,836.
Yes.
That is the amount which is lying there.
1,90,000.
96,836. So that will direct to be transferred to your account.
Yes.
1,96,000. After deducting 60,000, from 2,56,000.
Yes, that is the amount because
I'm entitled to 2,56,000 and the current maintenance.
Current they have already deposited.
3 months.
Oh, you say that the current has been.
Only I have got the current. I have got current maintenance for 3 months. Now, my lord, your lordship can do one thing, my lord, subject to.
Yes, yes.
2,56,000 minus 60,000 becomes my area. And the current maintenance to go on.
Yes, that amounts to 1,96,836.
The calculation will not have.
Very well. A report is submitted by the Chandanagar Police Commissionerate, that is the ex-employer of the respondent husband, full stop. It is disclosed from the account statement annexed thereto that pursuant to the order dated January 13, 2025 passed by this court, the said employer of the husband has been depositing the arrear amounts, depositing the salary of the husband to a special account created for such purpose bearing number 43664106208 after remitting 20,000 per month, rupees 20,000 per month as current alimony. Full stop. From the bank statement, comma, it is evident that the closing balance thereof is rupees 1,96,836. Full stop. It is also found from the submission of parties and the report filed by the employer of the husband that the husband has since retired from service on February 28, 2025. Full stop. Next para. Thus, comma, there is no question of further deduction from current alimony, from current salary of the husband in lieu of arrear maintenance. Full stop. The purpose of justice would be subserved if, in lieu of the remaining arrears of alimony, comma, the closing balance lying in the aforementioned amount is transferred to the personal account of the appellant wife. Full stop. Next para. Accordingly, the Chandanagar Police Commissionerate is directed to transfer the amount of rupees 1,96,836 lying in the aforementioned amount to the personal account of the appellant wife within a week from date. Full stop. Next para. The respondent husband shall go on paying alimony, current alimony at the rate of rupees 20,000 as directed earlier by the last day of each current month, comma, starting from up to April you have paid.
Up to April.
Up
No,
to
no,
April.
March, my lord, March.
March, probably.
December,
March.
Up to March.
Up to.
Up to March.
April, my lord,
Cannot
have
be
to-
April because you
no,
retired.
my lord, sorry. Up to March.
Starting from April 2025. Full stop. Can 3, what is can 3 for?
Attachment.
Attachment of
Can we will dispose of
This
can
is the
3?
application.
Can 3 of 2023 is disposed of in the light of the above observation.
That amount will the husband.
My lord, the appeal is otherwise
Husband
ready
will
for
pay the amount, current amount is direct to the.
Yes, yes. Acha, the husband shall go, respondent shall go on paying the amount directly to the bank account of the wife.
I mean, so far as the commissioner is concerned, your lordship has decided for this purpose, your lordship can.
We will direct personal appearance of Mr. Shapun Banerjee on every occasion so that you earn your fees.
No, we have no.
No, you didn't ask you to, we only directed you to file a report. Nothing else. You have no further involvement in it.
Record there. Otherwise, every matter, every day, I have to appear.
Needless to say, comma, the Chandanagar Police Commissionerate is not required to appear any further in the matter.
Give them your lordship. And report
For
The
the time,
report filed today.
my lord,
be
for the
kept
time being.
time
Because
for the time.
because my lord, your lordship has directed, my lord. Now the
Whatever orders are passed by court is always for the time being and subject
lord, the appeal is
to appellate court.
that, my lord, the
Appeal is ready for hearing. Earn some more alimony, then we'll hear the appeal.
my lord, only as your lordship, my lord,
Appeal hearing is difficult. What is Mr. Banerjee saying? Deal with him outside court. It has to be stopped at the inception.
Mr. Banerjee loves me very much.
His father loves me very much.
No, obvious. 10, yes.
10 is my appeal and application, my
Yes,
lord.
Mr. Mukherjee, what is it?
There is a money suit which has been dismissed. Lordship on the earlier occasion directed me.
What are can 1 and 2 for?
Can 1 is for
Appropriate order calling for the records and all.
calling for the
No, that is
records.
can 1, yes.
That is can
We have
1.
directed.
No, Lordship has
We'll
not
direct that and can 2?
Can 2 is, I think, for acceptance of the late
Yes.
submission of the
Section 5. What is the delay?
delay of 3 days, I think.
3 days. So long. 3 days cannot be gone. We have a prestige. We are the apex court of the state. 3 days is beneath our dignity. So we won't condemn it.
I will add some.
Mr. Mukherjee, have you served a copy on the other side?
Yes, I have served.
File your affidavit.
Affidavit of service is here, my lord. It's not affirmed.
Can you do it today?
Yes, right now, it's ready.
Good service effected?
Service affected.
Very well.
It's received it on.
So we'll dispose of both the applications.
Right.
The present appeal has been preferred against the dismissal of the appellant's money suit. Full stop. Can now it transpires from the submission of learned counsel for the appellant that service has already been effected in respect of both the applications on the respondent. Full stop. The appellant shall file an affidavit of service to that effect during the course of the day. Full stop. Can 2 of 2024 is an application for condonation of the minuscule delay of 3 days in preferring the appeal.
As per the report, 1 day.
Oh, ওখানে বলছে 1 day. Oh, 3 days. Full stop. Upon a perusal of the averments made in the application, we are satisfied of the sufficiency of the reasons for the delay. Accordingly, can 2 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT number 144 of 2023, full stop. The appeal shall now be deemed to stand admitted and registered and admitted, full stop, no address to cost. Next para, can 1 of 2024 is an application for expeditious hearing of the appeal, full stop. Accordingly, we dispose of can 1 of 2023 by directing the appellant to put in due postal requisites for service of notice of the appeal on the respondent within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is made ready for hearings. Meghnad babu, দুটো জিনিস, একটা হচ্ছে যেখানে লাস্ট অ্যাপ্লিকেশনটা অ্যালাউ করলাম ক্যান 2 অফ সার্টেন Yes. None appears for the parties at the time of call. As a last chance to the appellant to move the application, the same is adjourned for the day.
I am for the appellant, my lord. The respondent wife in the trial court below is the appellant before your lordship. Suit under section 25 of the Special Marriage Act, my lord. Declare nullity on the ground of willful refusal to not consummate the marriage. That is the my lord matter. Not before your lordship passed an interim order
For the wife.
I've served, my lord.
He is appearing. Yes.
Now, what I am praying, my lord, usual order for my lord, calling for record would be, my lord, possibly suffice. But, my lord, I am praying, my lord, if mediation can be directed, because the wife, my lord, is willing to not go back to the marriage. If my learned friend, my lord, takes instruction, if mediation is possible, because both of them are very young.
Depends on you.
Instruction, but she filed a 490 case.
That shall be with.
No, if there is mediation, everything can be taken care of.
It can be, my lord, because the
498 has been filed.
Under wrong legal advice, my lord, the marriage stint was very short, my lord.
No, Mr. Banerjee, obviously, if it goes to mediation, then everything, because that will be beneficial to you also. 498A goes.
If the parties can.
But nullity, if they can, anyway.
Because
if both of you agree to mediation, we'll say refer it to mediation right now.
So that one kindly go through my request, paragraph 13 and 16 of the injunction. Only this. It is possible, my lord, I shall abide by, definitely I shall. In admitted position.
This is credible. This happens.
Lord, fear psychosis, my lord, is the lord, term used by the doctor. So if it is fear psychosis, then it is not willful. But I am not going into the merits of the matter.
No, fear psychosis has various shades, Mr. Banerjee. As you know, I mean, there can be, regarding consummation, there can be specific fear psychosis.
And the doctor prescribed that.
And otherwise also it has been established that biologically we don't want to go into that.
There was no consummation.
No consummation.
And it was only 2 months of marriage.
What is the use of going back, Mr.?
2 months of marriage.
This is trying to revive a dead tree.
In my humble submission, what I could not gather, my lord, from February 18, my lord, to April 18. This is the 2 months of the marriage where, my lord, there was non-consummation.
So there was a scope that it could have been.
Could have been.
Very
So a doctor prescribed fear psychosis and, my lord, repeat, my lord.
Understood. It could have been cured.
Could have been cured, my lord. On the first day of medical examination, my lord, the next day the suit, within 15 days suit is filed. They could have tried.
So we are referring it to mediation. Let us have a chance. You will record your
Possible
concept.
otherwise, Lord.
The affidavit of service filed to be kept on record. Full stop. The present application is one for expeditious hearing of the appeal by passing necessary directions. Full stop. However, comma, at this stage, comma, learned senior advocate appearing for the appellant submits.
Advocate, Lord.
Not. Learned advocate for the appellant submits that the matter might be resolved if sent to mediate.
Application for stay, Lord, not expeditious.
আচ্ছা
Stay returnable, Lord.
এটা কেটে দিন মেঘনাথ যা বলো can 1 of 2025 has been filed for stay of operation of the impugned judgment and decree whereby the alleged marriage between the parties has been held to be a nullity. Full stop. Next para. At this juncture, comma, learned counsel for the appellant submits that the matter be sent to mediation. Full stop. Upon hearing learned counsel for both sides, comma, we are of the opinion that the parties are agreeable to take a chance of mediation. Full stop. Accordingly, let the matter be sent to the High Court, Calcutta High Court Mediation Committee, for the purpose of mediation between the parties. Full stop. Next para. The file be sent to the said committee at the earliest. Accordingly, full stop. Next para. Liberty to the parties to mention the matter before the court in the event mediation fails.
Notice should be served by my learned friend.
Yes, Mr. Banerjee, take appropriate steps. Yes, interchange notices and then.
If it can be saved, otherwise we'll have to.
Otherwise, the mediation committee will give you a notice. No difficulty on that. This order has to be placed before the committee by other of the sides. They will call both of you and they'll sit on a table, make you sit on a table, and you know, should be. In other matters also, you must have been having this. You are a trained mediator.
I have faced mediation. My clients have faced.
Much obliged.
Thank you. 13 to 16. Mr. Mukherjee? Yes. You for one side and Mr. Jishnu Shah for the other side.
Yes, Lord. This matter and
release on personal.
Lord, I'll try to make it Lord brief and Lord to the point, but
yes,
it might be such that I cannot complete it today. Lord,
is sufficient warning, Mr.
Lord, that is Lord on instruction, Lord.
Instruction.
I'm fair to the court, Lord. I'm fair to the court.
No, Mr. Mukherjee, we rely on your good office, your and Mr. Sen's good offices.
But I tell you, Lordship, Lord, for the purpose of Order 7 Rule 11.
It should not take much time apart from the plaint.
Look, there are not 4 matters before your Lordship.
We directed the appeal to be heard analogously.
Lordship. No,
there is no direction, but this appeal was heard for all.
We are heard by the trial court analogously. We direct the appeals and the application, details of which are furnished to be listed along with the present applications. Order dated 1st of April. Although the date is very conspicuous, but still it holds good.
No,
it's an order of the court. The April Fool chapter does not apply. So the order is exactly was since learned counsel for the appellant submits that certain other appeals are also pending, which arise out of different suits which are heard by the trial court analogously with the suit. We direct the said appeals and the applications to be listed along with the present applications. But ultimately, it was applications were fixed for hearing. Application is for
as
what?
Of today, Lord,
Yes.
there is one application, Lord, the appeal, which is the first one appearing in my Lord's list at number 13.
Mr. Mukherjee, there are 4 matters before.
But I tell you, Lordship, there are Lord, 2 suits filed by my client, 1 suit by my learned friend's client. In his suit, title suit number 314, I filed a counterclaim. The counterclaim was dismissed only on Lord, 2 grounds, order to Rule 2 and Lord, limitation. Now, Lord, that is Lord, the first appeal that is pending before your Lordship. Now, Lord, the other ones, Lord, that is also Lord, Order 7 Rule 11, Lord, taken out in my suit, which was also Lord, equally rejected by the trial court.
Similar grounds.
Similar grounds. Almost similar grounds. The facts emanate from Lord, the similar set.
Why 3 suits? Different properties.
No, my lord, this is not there
One
was
after the other.
one after the other, yes.
When it dawned that some reliefs were no missed out, the second suit.
Oh.
Again, when it dawned that some other thing should have been challenged in the third
Oh,
suit.
no.
So this is
We
the
grow wiser. You cannot complain about it.
Unfortunately,
if
by
you-
that time the limitation had taken place.
Oh, limitation, right. Oh, acha. Order to rule to and limitation.
Now, my lord, it's happened that in
Money suit
2000
or what?
No, my lord, in 2003, there was my lord, a sale that was effected pursuant to the order of this honorable court in favor of my properties, but unto my learned friend's client.
Bank sale?
No, that
Court
was
sale?
not a private sale. In 2010, my lord, there was an agreement that they are supposed to, my lord, take, my lord, the compensation money which, my lord, payable to my client out of the acquisition of the property by the state government. My learned friend was, my lord, is an agreement holder to that effect.
Tripartite?
No, my lord, it was between, my lord, no,
State, you and him?
state was not.
No,
My lord,
state
it is
was
a
not
bipartite.
between
My lord, the vendor and, my lord, the purchaser of the property. Now, my lord, following that agreement, there were, my lord, two power of attorneys. So, my lord, in this entire proceeding, your lordship will find, my lord, there are four, my lord, initial documents, interpretation of the document, what it intended, a division bench's order, thereafter, my lord, a Supreme Court's order concerning how, my lord, the proceeds of, my lord, the acquisition will be dealt with, and, my lord, it emanates here. So, my lord, the first appeal that is appearing before your lordship, my lord, is arising out of rejection of the counterclaim. Now, my lord, in that, my lord, I am praying for an order because, my lord, they are proceeding with their suit. In the event of my success, my lord, I will be prejudiced. So, my lord, if your lordship wants to hear this matter, I can, my lord, I am prepared.
Only
But-
thing, my lord, I just also want to point out.
But it is not a consolidated matter.
Yes,
Lord,
this
I-
application for stay, which is now before your lordship, even in this suit and counterclaim has been dismissed. That was also stay application was heard
4 days.
on 3 or 4 days. And at that time, since my witness was being cross-examined, so a limited order was passed by the then division bench. So ultimately,
Limited order to the effect that
extend that we will proceed
Only on
with
one
the cross-examination. Now the cross-examination, but they did not ultimately get a stay, or they did not even press that stay application at that stage. Because your lordship will see the order is quite long.
now the evidence is complete.
No,
No,
and
no, it is
The
not
other
complete.
witnesses as
My witness is complete.
DW1 is complete. DW1 is about to start on instruction. I see.
আমাদের কি আরো witness আছে?
Mr. Chen, unless you stay the proceedings, it will become infructuous. You can direct paper books to be prepared.
But even without the paper books, I can assist your lordship because I'll be very brief in my submission.
Yes,
Although
Right
the
now, if you
papers
take
are
up
all
the hearing of the appeal, the difficulty, Mr. Mukherjee and Mr. Shen, is that the other applications will be suffering order for 12 matters are also there.
So that is why I thought, but how they got the application, but the appeal listed.
No, not that.
No, because
you
of
were
the
wrong there.
urgency, Lord, Mr.
All
Banerjee
the
must
applications
have-
shall be listed together as the last. I was wrong.
But the prayer for stay was not pressed at the time when they had argued the matter.
But at that point of time, it was only a limited order was granted, you were saying.
No, kindly see when the last order was granted. If your lordship kindly have a look at
It's a
17th of September.
continuing cause of action because the suit is proceeding.
Kindly see the order.
If it is decreed finally, then Mr.
Then
Shen,
On that, I am not there. Your lordship will kindly say, well, that they let their witness come and your lordship will fix a date. Kindly do not grant, because that stay they did not get in September. And after September, my lord, the matter was not mentioned. Not once, only this April, my lord, I see it was mentioned. So if they had an urgency that the suit is going to proceed, it should not be rendered infructuous.
the very fact that the suit is proceeding, that itself is the
Yes,
urgency.
and
It's
that
a
is
continuing
not
urgency.
in order
My lord,
at 17th
my lord, the
September.
prudence, my lord, demanded that they will mention before the division bench which was hearing the matter.
Session,
So, my lord,
suit is proceeding. I mean,
well, your lordship will kindly
that's
have
a continuing cause of action.
my lord, kindly have a look at the last order once, my lord, when they got
17th
it, my lord.
September
Yes, my lord,
2024.
17th September, when it was being heard. One should not take advantage of this order and just sit back and then, my lord, after 5 or 6 or 8 months will come and mention and say that now please stay. Parties will, paragraph 2, your lordship will says, Mr. Mukherjee, that since the suit is proceeding, rights of to which Mr. Senior Counsel. should the cross examination be assured should the parties will make a joint prayer for adjournment before the trial?
No, on that assurance only it was.
In the last week of
Mr.
November.
Mukherjee Learned Senior Counsel appearing, this is an apprehension that since the suit is proceeding, the rights may be protected. On which Mr. Shah Learned Counsel for the respondent was submitted. As of today, cross-examination of PW1, he assures that.
Yes, we will make a joint prayer for adjournment.
Yes.
So that was in
That was the plan.
in
So
the
there was
last week of
So on that assurance, they have not placed the stay application.
No, that is not in the last week of November 2024.
You cannot hold them up for that because that assurance was given by you. That assurance still remains.
Then, my lord, let us do one thing. Your lordship will fix the matter, and my lord, all the documents, everything is in this stay application. But it is not that your lordship will have to look into something else.
No, but what about the other appeals?
But all are not self-complete. These are with the
Other
applications.
appeals may not be so urgent because there the suit has been dismissed. So that urgency is not there in that case.
Acha, this present appeal arises from the last suit.
First suit counterclaim.
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 Counterclaim was filed before the other suits were filed by them.
No, it was.
Then no, Mr. Shen, Mr. Mukherjee may be insisting on the other appeals also.
In fact, it will be convenient for all, my lord. Why I say
No, because the last date has to be order to rule 2 and limitation date to be read together.
Yes.
So
I'll give
a
you
question arises whether they can lose on both counts.
I'll show your lordship the sequence. First is my suit, 314.
Your suit is for what?
My suit is only saying this, that they should not close the bank account which is a designated bank account in the agreement where the compensation money will be deposited.
So that's a declaratory and permanent injunction suit.
Yes.
What is their counterclaim?
Their counterclaim is for challenging the agreement of 2010.
On the basis of, on the strength of which you asked for that account opening and all these things.
Yes. Agreement
2010. Achha, what about the subsequent 3 suits?
Yes. Next
two
suit
suits?
in the point of time is my learned friend suit.
What is that for?
614. There they are saying
613.
We are entitled to.
Whatever be the number.
Sorry, they were entitled to operate the bank account themselves.
Directed against the bank.
That is
not
their
my
suit.
learned.
That they did not
My
include me as a party because first I got an injunction that they should not close that bank account. So, my lord,
They filed a suit against the bank without impleading you?
a party got an ex parte injunction. Then, my lord, I preferred an appeal, leave to appeal.
That they would be able to operate that account. That was the injunction.
Yes, they would be able to. So that was against me.
You filed 711.
And then no, first I got myself impleaded. That appeal court set aside that order, gave me liberty to be impleaded. I got myself impleaded. Then the injunction application was finally disposed of. Both the injunction
Dismissed.
Injunction in no, I'll give you a lordship. Injunction in my suit and injunction in their suit. Both were heard analogously. Disposed of. Court came to the conclusion that they have no right to seek an injunction, and it is based on some fraudulent documents, etc., etc. And but status quo with regard to operation of the bank account.
So basically they cannot operate.
Yes, they cannot operate. I cannot operate also.
That none can operate.
And Supreme Court said that there was a.
Thereafter, my lord, we preferred a miscellaneous appeal.
Achha.
During the pendency of the miscellaneous appeal, when the division bench was questioning them about whether the 2003 conveyance was challenged or not, they have accepted the conveyance. During the pendency of the appeal, the second suit of my learned friend was filed challenging 2003 conveyance. So these are the 3 suits. And then came the counterclaim in my suit of 2010 challenge to the 2010 agreement. So this is the sequence, my lord. First is no challenge to any agreement, simply a perpetual
But then
injunction.
all the suits were being heard analogously.
Only the injunction application. Now there are no suits only except my suit is there.
But the 3 suits were being fixed together for hearing.
Only the injunction applications were being fixed.
They are hard
Now there are no only my suit is remaining.
No, if the 3 suits were being heard analogously, you have to take up the appeals together.
Yes.
Because the
But
711
it
applications
will be convenient for all, my lord, because the same set of facts, my lord.
Mr. Mukherjee will direct you to prepare a composite paper. You incorporate whatever is there in the stay application. But because there are 3 places.
There are 3 appeals.
Because when we
4 appeals.
when we hear the appeals, otherwise you have to skip from file to file and take all these matters and skip from file to file and just see. You refer to the plaintiff of one suit we'll take up that file, and another suit, then we take up that file.
Then again,
make the
also it will be in
counterclaim.
multiple volumes.
No, multiple volumes has to be there. But if one set of paper books need not annex the stay applications,
Yes, but only
the
the
documents will be sufficient. Need not annex the stay application before this court. You can annex the injunction application annexures must be almost same in all the matters.
Order 7, Rule 11, Lord, the plaint, Lord, there, Order 7, Rule 11, my objection. And Lord, there will be 4 documents which your Lordship will need to produce, one division bench order and a Supreme Court order.
So therefore, instead of
Accepting that, anything else is required.
all of those are here in this.
All of these are here.
All the 3 plaints and order,
Yes.
all 3 Order 7 Rule 11 applications are annexed to this stay
Yes.
application.
Yes.
Regarding the other appeals also.
Separately.
Then file it compositely. That paper book will contain the 3 plaints, 3 suits total, or 4 suits.
3 suits.
3 plaints, your counterclaim, Order 7 Rule 11 applications and objections, and whatever documents, common documents. Why? Because each of the stay applications contain all the
apprehend that,
documents.
Lord, if I annex those documents, my learned friend will say these are the pertinent documents. This should also be, Lord, appended to the paper book. That is what I
You
apprehend.
can have an interaction between yourself, the learned advocate and record, so that there can be a common set of papers.
Because my scope of argument will be limited to, Lord, these documents. Because Order 7, Rule 11, I have a very limited argument.
We can look into only the documents which you relied on in your plaint or their plaint. Nothing else.
Exactly.
Either annexed or even relied on,
Lordship.
referred to. That we'll look into.
Lordship.
So, my lord, the division bench order or Supreme Court order will not come here.
That has got certain, those are not certain, Lord.
Plaint.
If you feel those are relevant, we can look into those, but those will not affect.
Subsequent to plaint. So
711 is 711.
There is one appeal which emanates from an injunction order. But that is item number.
Second item.
The second item, Lord.
Injunction order passed in the present suit, which is still subsisting.
Yes. That is, Lord, my learned friends, Lord.
That is
suit,
also kindly have a
and in favor of my learned friend.
Almost, my lord, we will be reaching 1 year from the date of the order.
That is
So I will have to
18th June.
file an affidavit in that, my lord. 18th of June order, 2024.
That appeal has been admitted.
No, that has not.
That is not appearing before us.
Yes, that is appearing. Lord, the second item, item 14. Item 14.
That is an never moved.
Item 14, we are admitting the appeal to be heard on all the questions taken in the memo and direct affidavits to exchange. And regarding the your suit, we have to stay, Mr. Mukherjee, Mr. Chen.
But may I say this, my lord? Kindly do not pass an order of stay, my lord. Let at least, my lord, the evidence be go on, my lord. Otherwise, my lord, kindly.
No. Otherwise, the evidence will go on without his counterclaim. Because his counterclaim has been rejected.
Yes, counterclaim.
If the evidence is completed again, if you allow his appeal and
may I say this, my lord?
That will be a double exercise.
Whatever document he is relying on in his counterclaim are already part of the plaint.
Maybe.
No, I have to give evidence in support.
Without
in counterclaim, he will be the plaintiff, so he'll be entitled to lead evidence separately.
But that evidence, let him tender the evidence without prejudice. It will be
tendered.
kept on the record. If otherwise, my lord, the entire procedure
Get
comes to
complications.
And my lord, may I say this only thing, my lord? If they were interested in this,
No, because of your assurance, they are not interested.
no, that is only
till
November.
Only for November.
Only for November, because just before Puja vacation, this order was passed.
No.
Because the Puja vacation will continue, we
We
said.
cannot castigate them for that.
I am not saying, my lord, but still kindly see December.
We'll record your submission, but we'll say that this was on that premise. Well, definitely, because we have to record that. That is your opposition also.
Yes, my lord. Otherwise, but difficult.
Can 1 will dispose of right now? We'll dispose of can 1 right now. We'll admit FMAT, that FMAT right now.
FMAT 297. 297.
Achha, since these are appearing together, there will be a common cost title in our order. So we are admitting FMAT first. If you want, we can direct you to file opposition to the injunction application.
Yes,
But is it against an ad interim?
Fine. That is fine.
What is the use of? We'll say that you are not admitting any of the allegations. If they annex written objection and everything there,
Appeal can be
we will fix that also along with these, because that will be just only a consequential order.
And my submission will be that that was in the nature of a consent order, the order also records that they will have no objection to the operation of the bank account. That is what the impugned.
Injunction we cannot grant at this stage, Mr. Mukherjee.
But injunction, my lord,
Your Lordship,
That will
I am
complicate.
praying for my lord stay.
No, in the FMAT.
In the
Injunction
FMAT,
was
my lord.
refused there. You have challenged the refusal of injunction.
No, my lord, it was in the
Grant of also, in any event, you cannot grant stay.
That is, my lord.
Let us proceed with the chronology as you said. The present 4 appeals have been listed together, since they arise from suits which are being heard together. Full next para, FMAT 297 of 2024 is an appeal preferred against the grant of injunction in favor of the respondents. Full next para, since questions of both fact and law are involved in the appeal, FMAT 297 of 2024 is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. In view of the connected stay application containing having annexed all the relevant documents, we feel no necessity for directing affidavits in the matter. Full stop. However, it is made clear that it will be deemed that none of the allegations made in the said application are admitted by the respondents. Full stop. The appeal and the application shall be heard together along with FAT 127 of 2024, FA 8 of 2025 and FA 81 of 2025. Full stop. Next para. Insofar as FA 127, FAT বললাম কি 127 টা FA হবে. Insofar as FA 127 of 2024 is concerned, the Can 1 of 2024 has been filed in connection therewith, praying for stay of all further proceedings of the suit from which the said appeal arises. Full stop. The first appeal has been preferred against the rejection of a counterclaim filed by the defendant stroke appellants in the said suit. Full stop. Learned senior counsel appearing for the appellant submits that in the event the main suit is heard out and disposed of, the appeal might be rendered infructuous. Full stop. Next para. Learned senior counsel appearing for the respondents opposes such contention and submits that the appellants showed no urgency at any stage regarding moving the stay application. Full stop. Next para. Learned senior counsel appearing for both sides place reliance on an order dated September 17, 2024, passed by a coordinated bench in connection with the appeal. Full stop. We find therefrom that the learned senior advocate appearing for the appellants had raised an apprehension before the court on the said date, which was recorded in the order, that since the suit is proceeding, the rights of the appellants may be protected. Full stop. To the said submission, the learned senior advocate then appearing for the respondent number 1 had submitted that as of that date, the cross-examination of PW1 was in progress. Full stop. He also assured the court that should the cross-examination be completed, the parties will make a joint prayer for adjournment of the matter before the trial court for consideration of the pending suit sometime in the last week of November 2024. Full stop. Although the said concession was given by the respondent number 1 only relating to the last week of November 2024, we find that merely the factum of not pressing the stay, the prayer for stay at that juncture could not be held against the appellants insofar as urgency is concerned, since the prayer was obviously not pressed, despite an apprehension in that regard being raised, due to the assurance given by the respondent number 1 at that stage. Full stop. Next para. In any event, even independently from the said order, we find that in the event the suit is heard out and disposed of prior to hearing of the present appeal, comma, directed against the rejection of a counterclaim filed in the same same suit, comma, the present appeal might be rendered infructuous. Full stop. Accordingly, can 1 of 2024 is disposed of by granting stay of all.
Have your lordship permits that if we have a witness, another witness, he can be examined, and thereafter the suit may not proceed.
You don't have any other witness.
No,
It's
the
not in your
DW has
witness.
started, but I am on instruction.
DW has
They
started.
have not started. No, tomorrow is the date for DW.
It is a date, my lord.
They have submitted, they don't have any witness.
Dispose of granting stay of all further proceedings in what is the suit number?
But, title suit 314 of 2021.
Title suit number 314 of 2021
pending
before the learned Chief Judge, still
Yes.
Chief Judge, City Civil Court at Calcutta, till disposal of the appeal. Push up next para. The appellants in FA 127 of 2020, you are the appellant in all the appeals. The appellants shall prepare and file composite paper books in respect of all the 4 appeals, comma, thereby incorporating relevant papers, and serve an advance copy of the same on the learned advocate on record for the respondents. Full stop. In the event the respondents are of the opinion that certain other papers should be incorporated, comma, the learned advocate on record for the respondents shall intimate the same to the learned advocate for the appellants, upon which such additional papers shall also be incorporated in the paper book. যেখানটা বললাম serving an advance draft copy of the same, shall serve an advance draft copy of the same on the learned advocate for the respondent. You prepare a draft copy of the paper books.
But in respect of 3 appeals, Lord, that is arising out of Order 7, Rule 11. But can we make a composite one? And in respect of Lord, the appeal arising out of the injunction, we make a different Lord,
Yes,
because the
that may be
papers will
better.
be different.
Very well.
But may I only say this, my lord? My lord, since your lordship is granting a stay, my lord,
Let's just complete this. Composite paper books যেখানে বললাম সেখানে হচ্ছে কম্পোজিট পেপার বুক ইন রেসপেক্ট অফ FA 127 of 2024, comma, FA 8 of 2025 and FA 81 of 2025. তারপর যেটা বললাম ড্রাফট কপিটা দেওয়া। Push up. The appellant shall also prepare paper books with regard to FMAT 297 of 2024 and serve an advance copy thereof to the learned advocate on record for the respondents. Push up. The appeals shall be, all the appeals shall be heard analogously along with the rest of the pending applications. Yes, Mr.
but it may be heard analogously, but each Order 7, Rule 11 has to be taken up separately.
Because we say this, because these are connected, because the all the suits have been filed. We have to take all the suits together in a bird's eye view fashion.
But the 3 separate orders are there. Orders are separate.
Grounds
But
are
the
separate.
grounds are also separate for each Order 7, Rule 11.
Oh, grounds are separate.
Grounds are separate.
Because when I am challenging
almost.
a conveyance, they are challenging a conveyance of 2003. My ground for the conveyance to be challenged is also
correct.
different. Then, my lord, 2010
In
agreement.
composite, then we
Then, my lord, may I let's separate paper.
I'm joining.
Or, my lord, may I say this stay application contains the plaint, it contains the Order 7, Rule 11, it contains the written objection. So, lordship can treat this stay application as a paper book and can have the matter can be disposed of. It will be very
in each of the matters.
separate. Just as it is appearing in the list today, the lordship takes up one matter to the item number 13. The stay application can be treated as an informal paper book, and your lordship will have all the papers.
No,
So
but
my
the
lord-
suits were being heard analogously.
Was not heard each one after the other.
One after the other.
One after the other. It is just like this, my lord, the matters are appearing.
এখানে একটু আসুন। বলছি যে পেপার বুকস এর জায়গাটা কি বললাম মনে হচ্ছে the appellant shall prepare paper
My lord, that we have to.
no এখান থেকে যে শুরু করুন এখান থেকে তাহলে কম্পোজিট পেপার বুক ড্রাফট এগুলো হবে না লাস্টে না আমি বলে দিচ্ছি লাস্টে কি পেপার বুকস এর পরে আর কিছু বলেছি the 3 appeals will be heard analogously বললাম ওইসব পুরোটা কেটে দিন তাহলে ওই পেপার বুক পর্যন্ত প্রোডাক্ট
পেপার বুকসে অ্যাডিশনাল যদি পেপার থাকে
ওই সব হবে, সব বাদ যাবে, বাদ যেতে তাহলে পুরোটা বাদ দিয়ে দিন, আমি ওখান থেকে বলে দিচ্ছি। The appellant shall prepare and file the requisite number of paper books in respect of each of the appeals within. Oh, you are not prepared paper books. That's very well. এটা কেটে দিন, হ্যাঁ। Since the relevant documents are annexed to each of the connected applications in respect of the appeals, comma, formal preparation of paper books and calling for the trial court records are dispensed with, full stop. The appeals shall be heard on the basis of the papers already on record before this court. Full stop. Liberty to mention the appeals for inclusion in the list.
Kindly do not give this liberty more kindly because one analogous.
The appeals shall be listed for hearing in the monthly list of May 2025. Obviously, not before May. No, Mr. We are refusing everybody.
Sequence of year, my lord, we will go down.
Yes.
The analogous is there. All the 4 appeals to be heard.
তাহলে analogous থেকে কথা add করি। Hard আচ্ছা analogous না, hard together.
Together.
Hard together. Yeah.
But that's some precedence, my lord. Otherwise, my lord, the suit will.
Nobody is special in this world.
Absolutely correct.
Everybody is unique. So let us have a hearing of the other unique matters first.
Well, the facts may be unique, my lord, for some cases. My lord.
For each case,
Extreme
facts are in.
interest.
For each case, facts are in. But none is special.
Great.
Difficulties, then we cannot make some kind of a.
We have to balance the
Concession.
difficulties.
It is very difficult, my lord, to make a concession.
We have not done anything on concession.
On the last order. If my concession was not there in
They would have pressed the stay application.
Yes, as a matter of right, I could
Pressed
have.
the stay and got a stay.
Yes.
3 days. This is the.
Mr. Shen, you failed to appreciate. If you did not give that concession, that concession was not a charity. That was to save the stay from being granted. If you did not give that concession, they would immediately get an order of stay before any
Would
bench.
you oppose that speaks of your mind.
They did not give this, they did not move that press the stay on the first. This is after the 3rd or 4th day this order is passed.
Maybe.
And that only because there was the vacation.
But they expressed an apprehension, court records that, and on basis of your assurance only, court does not. So if your assurance was not an act of charity, so you cannot complain that one cannot give a concession. You did not give a concession of charity, out of charity. It was just to prevent that stay order, and we have to read it as that. And they did not get the stay order because of your concession. You saved that, saved the day, but not the month.
Coming, they will not get a date now. It will go after vacation. That is
What can be done, Mr. Shen? In every matter, at the time of mentioning, there is a bevy of lawyers. While hearing is taken up, none appear. Not none. Many of you are appearing and doing matters fully.
It's very difficult now.
You just keep anybody here. Just watch the proceedings of the court any day. This is an appeal bench.
But there are
Just
practical difficulties when we are
practical
appealing for a
difficulty
client,
means
we
people
say
are not doing appeal matters, and people are not cooperating. Particularly, some of the generations are not cooperating.
It is only when we are.
Now we don't have any
spokesman of a
complaint with
particular-
your generation, but our generation. But
Well, we have.
some people are not cooperating, Mr. Shen. 5-minute appeal is being drawn over days, despite we are just on the verge of folding our hands.
That
But
is our
nobody.
fault. That is our fault. I know, my lord.
If everybody cooperates, comes prepared with nutshell points in a nutshell, it will be done in a flash, Mr. Shen. All these appeals would be over in no time.
Especially things like order 7.
So order 7, rule 11, order 14, rule 2, so many applications, preliminary degree appeals, appeals against preliminary degree do not take much time. And final degree appeals all the more so. Nothing, only commissioner's report does not allot me a plot, and
From 0. That is the problem.
we start from 0, not even 0, negative.
Yes. That is the problem.
Thank you very much.
Your Lordship, in this matter, I'm not pressing the stay application. In a connected matter, Your Lordship, which is appearing as item number 106 of today's list, Your Lordship has already passed this order, Your Lordship. This is the issue whether I'm covered by the West Bengal Premises Tenancy Act or does the court have subject matter jurisdiction. The question of occupational charge was to be determined, and it was a Park Street property, Your Lordship recalls.
No, there also did not press the application.
Yes, we argued, but Your Lordship was of the view that 50,000 rupees would be the appropriate occupational charges. At that stage, we said that.
After conclusion of details hearing, they have placed, don't want to place this stay application.
Yes, on the
because
last occasion,
in the
that is
same
what
building, Your Lordship,
If you don't want to press this, then we'll record that just and dismiss.
And Your Lordship, similarly, the appeal let the appeal be expedited.
because 1/6
The appeal, you are appealing for all the respondents, both the respondents.
yes. Because in the same building,
So we can direct paper books to be filed.
Absolutely, Your Lordship.
Paper books to be filed, and
Your Lordship's one
this
earlier-
is the issues involved here are similar to that.
Identical.
same building but different.
It's just different
flat.
lease.
Same
No,
building.
the issues involved in the suit are same.
Same, identical, Your Lordship. Identical.
That is item number 106.
106.
Learned counsel for the appellant submits that the appellant does not want to press the stay application. So accordingly, IA Can 2 of 2024 is dismissed as not pressed without any orders to cost. So next para. Learned counsel for the parties also submit that the issues involved in the present appeal are identical with FA 118 of 2025, which is appearing in today's list as item number 106. Pushed up. In view of the appearance of the respondents in the present appeal, service of notice of the appeal is dispensed with. Pushed up. The records must come. These are different records or the same suit.
They're different records. Different suits.
The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Pushed up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Upon the appeal being ready for hearing, liberty to the parties to mention the same for inclusion in the list. When the appeal is ready for hearing, mention that it is similar to that, and if that is still pending, then we'll return.
The Lordships kindly to vacate the stay application and execution
There
case.
was
I'll
no
report
stay.
it, Malad.
No, they don't. There is a subsisting stay.
Yes. Because the executions, I have already obtained positions in respect of flat number 3.
2 is dismissed as
Similar
not
order,
pressed.
Your Lordships can have to see
Dismissed as not pressed করলাম.
dated 26 February 2025.
Interim order, if any, stands automatically vacated.
And the execution case has proceeded. Earlier occasions, Your Lordships passed the order. By order dated 26 February 2020.
যেখানটা can such and such dismissed as not pressed লিখেছে এখানে এই অর্ডারটি হ্যাঁ তার ঠিক তলাতেই এটা ঢুকবে interim order if any stands vacated full stop it is made clear that there will be no impediment in the respondents proceeding with the connected execution case.
I'm deeply obliged. Thank you.
Yeah, please, Your Lordship. But
Copy served.
Lord, served, Your Lordship, but Lord, the service.
You're enjoying an interim order?
No.
What is the application for?
Application, two application is there.
One is condonation.
One is condonation and
Unless
one
you
is.
serve properly, how can you take up the above?
Yes, Your Lordship. We served soon after passing of Your Lordship.
Who has not been served?
All three we served.
Served means they have received. Sent means you have sent.
Sent. Thank you.
None of them have received as yet.
No. The track report is still showing that.
When did you send?
On 8th, I think. No, wait.
8th?
28th of March. 28th of March.
So should we wait for some more time?
Yes, Your Lordship. Because Your Lordship passed an order on 26th, we submit on 28th.
No, that you did.
Yes, Lordship.
Learned counsel for the appellant submits that the service has not yet been completed on all the respondents. So accordingly, let the matter stand adjourned till April 21, 2025.
Obliged, Your Lordship.
You file a composite affidavit of service when track reports come. We are not taking the affidavits.
For the respondent.
Respond.
Well, I have the
defendant
Mr.
appellant
Chattopadhyay.
in this matter, my lord. My lordship will
You
kindly
are appealing
take-
for both the respondents.
and my
File your
lord-
affidavit of service also.
Yes, my affidavit of service is here. Kindly excuse me, it's only one copy has been found, my lord.
Affidavit of service, you are very good.
I should be with 2 copies, my lord.
Very good. Yes, what is the matter?
Section 5 is pending, my lord. With a suit for eviction, my lord.
Can 1 and can 2. Can 1 is the section 5.
The can 1.
What is the delay?
No, my lord, can 1 is, my lord.
Yes.
Can 2 is section 5, my lord. There is a delay of.
No, can 1 is section 5. You have mentioned it wrongly in your copy. Because in our file it's can 1.
Can 2, can 1, my lord, there is a delay of 150 days, my lord. My lord, the grounds has been given at page 3, my lord. It starts from paragraph 4.
Ex parte degree.
Ex parte degree, my lord, suit was filed. This is a previous an eviction suit was filed, my lord. After that, my lord.
Was filed by them?
Yes, filed by them in 2016 against the original, my lord, our predecessor father. Now, my lord, he died during the pendency.
Okay.
My lord, they filed an order for order 22 rule 4. Then that has been, my lord, dismissed. It's too diabetic.
Order 12 rule 4 dismissed.
Yes, because my lord, they did not take any steps. As far as my instructions are concerned. Subject to correction by my learned senior friend. And after that, what has happened, my lord? They have filed a fresh suit only against the 2 sons, not imputing the wife of the original tenant as a party. Now, my lord, got a decree ex parte without being service has been done, my lord, against on the ground of 2G. Now, my lord, on that, the basis of that, my lord, we are preferring this appeal before your lordship.
2G, what remains?
Nothing, my lord. My contention is that my mother is a necessary party, my lord. She has not been implemented. Even while I have a right to resident,
So your section 5 is based on you not having notice.
Not having notice, and also I have also mentioned that mother is ill, my lord. So for that,
So you're allowing the section 5.
My lord, should I allow the section 5? But only one thing, my lord, that all these things were within his knowledge and only one submission.
Why do you say that?
Because just come to page 4, my lord. Your lordship got it. Just last paragraph. After the service return dated such and such, the learned trial court fixed the ex parte hearing on such and such, and on the very next date, matter fixed for argument, which your petitioner came to know of the order passed by from out of neighbors. So they know all these things. They waited.
Subsequently.
And no, thereafter, thereby petitioner filed an application for certified copy on 24.
Yes.
Thereafter, they obtained the certified copy. But they didn't take any steps in the trial court. And the degree has been executed.
No, that was in November 2024.
Yes, my lord. And the degree has been executed.
They filed the appeal in February 2025.
25, my lord. 150 days delay thereafter.
So when did they obtain the certificate copy? Let us see.
24, my lord. 13/11/2024.
13/11/2024, they obtained the certificate copy. What were you doing for these 3 months?
I have specifically made
Mother ill. Come sharp. Previous telegraph language.
And another thing, my lord, just for the, I know that this point will be taken up in the appeal. Nobody resides here. The father died in Mumbai Thane. Yes, that is the thing.
Let them have some fun before they are evicted under 2G. Yes.
Now, in the meantime, what has happened? Well,
What has
after the
happened?
filing of this appeal, the execution case proceeded on that
We have
date.
not yet allowed the section 5.
Yes.
Wait for that. Can 1 of 2025 is an application for condonation of delay of about 150 days in preferring the appeal. Full heard learned counsel for the parties. Learned counsel for the respondents points out that despite having obtained the certified copy of the impugned judgment and decree in November 2024, the appeal was filed only in February 2025. Next para, learned counsel for the appellant points out that the reasons for the said delay have been furnished in paragraph 5 of the application, inasmuch as the petitioner's mother, who is a senior citizen, was suffering from acute respiratory problems and had to be taken to Mumbai for treatment, for which the appellants could not get in touch with their advocate. Next para, being satisfied, we are satisfied of the sufficiency of the reasons for the delay in view of the averments made in the application. Accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 69 of 2025. let the appeal be deemed to stand registered and admitted, no address to cost. Yes, can 2 is for stay.
Now, my lord, this is the order, my lord. After that, my lord, during the pendency of this application, my lord, this order was passed. The trial court.
Give a copy to him also.
This is a sir, apni order ta to janen. এই যে 20th February. I need mobile টা নেই?
Yes.
They have what they have said, my lord. Today is fixed for issuance of deed of delivery of possession.
Police help has been granted.
My lord,
Possession has been taken.
Yes.
Possession has been
During
taken.
the pendency of this
So
application.
this has become infectious.
Now, well, only, my lord, Lordship will kindly read once, my lord, what has happened, my lord.
We won't read the entire thing. You
No, no,
place the important-
I'll just point out. But decree holder files an affidavit stating that there is no application for stay in connection with any appeal has been filed or pending at the instance of opposite party judgment.
When did you
letter.
serve on them the copy of
My
this?
service, my lord, there was, my lord, we have filed this application in February, my lord. How many date was? 12th February.
But they didn't serve on us.
12th
Service-
February.
Yes, my service was effected after that. My Lordship has passed an order on
Then-
after 19th March.
Then
Well, I am on the specific one. They could have the search report from the site, and they could have, because they are filing an affidavit on that. Filing an affidavit on, but today, everything is online. It's not that they are unknown of that, any matter is pending. Even we instruct somebody to do this, we check it personally so that, there is no impediment for them to proceed.
that
with
is
the exploit.
correct.
But my lord, on 12th February, when they have filed, they didn't inform it either in the trial court nor even serving.
No, before you, when did you file that affidavit in the trial court? On 20th of February, saying that there is not that you don't have any knowledge. You have said you have said that there is no application for stay,
Yes, my lord, that's
nor
right.
any appeal pending.
That's
You could have taken an information from this court.
Yes, my lord, that's right. But
So that was a misstatement before the court.
And
No appeal pending. Anyway, we at this stage, stay has become
Only I'm praying, I know your lordship. I am
only praying for restoration of possession, and
I'll be coming with that.
the appeal should be allowed.
Appeal should have the necessary
have.
party.
2G, nothing in your appeal.
My mother has not been implicated as party. Even she has also been outstated, my lord. Lordship will think of in a different way.
What are the mother's rights?
Well, she is a tenant, my lord, because Lordship knows.
5 years? No, mother dependent.
Yes, dependent. 2G doesn't come on her. That is the first point. Second point is service. Lordship will call for the records. Well, there is no service. And third point is that
Records will in any event come.
that will come. And entire thing has been done in a span of 1 year, and execution thing has been done in a span of 4 months.
Diligently taken.
Very diligent,
Unlike
my
you.
lord. And Lordship.
That you have planned.
Too much of diligence, man. Well, not to change nature and character, and not to create any third-party interest, man. Because I am out of the position now.
You have not even prayed for that.
But that I cannot pray because at that point of time, this order was not.
Now you
there.
could have prayed.
Well, I can pray. Well, your Lordship will
We'll give
kindly-
you liberty to pray for that. There has to be an apprehension expressed in.
Kindly records that, so that he doesn't make any third party, create any third party
already
interest.
there is the tenant. Already there is a leave and license agreement being executed
Then
on 1st of March.
much prompter than you, your client.
Yes, really. That I have seen, man. This should be the example.
That is the risk of Mr. Chattopadhyay passing these blanket orders without any affidavit on record. That's why we desist from passing such orders. You maintain status quo, go and maintain status quo. No, why? You have to express an apprehension on oath that they are trying to do that, and they have to have an opportunity of
I'll
controverting
be
that.
only praying before Lordship, let this appeal be hard, and I'll be also coming with the documents so that I'll praise before Lordship that let this appeal be hard on merits.
Can 2 of 2025 is an application for stay of operation of the impugned decree and the connected execution case. Who's the next para? However, learned counsel for the appellant hands over a server copy of an order dated February 20, 2025, passed by the executing court, indicating that writ was issued in the meantime, during pendency of the present application and appeal, for possession, pursuant to the said writ, possession has in the meantime been taken by the decree holder / respondents from the appellants. Learned counsel for the appellant argues that the appeal had already been filed along with the stay application and the connected Section 5 application on February 20, 2025, when the decree holders filed an affidavit before the executing court stating that there is no application for stay in connection with any appeal, or that any such appeal is pending, was pending at the instance of the judgmentator stroke appellants in any court of law. Full stop. Hence, comma, it is submitted that the said statement was a misstatement. Full stop. It is argued that the the respondents could very well have taken an information from this court which would reveal the pendency of the appeal. Full stop. Next para. But unless there is a caveat, there is no scope of such, the number will be shown. There cannot be any information whether any appeal has been filed against this. We don't have that mechanism.
Yes, by name you can, my lordship can get it. Even if your lordship, and this one on that date only the execution was done.
No, anyway, give it to you. Here. Next para. Learned counsel for the respondent submits that on the date when the order was passed, that is February 20, 2025, comma, no copy of any application or intimation of any appeal had been given to the decree holder stroke respondents, and as such, comma, the statement was correct. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that there is sufficient substance in the contention of the respondents that in the absence of service of notice of the appeal, comma, the respondents, comma, true to their knowledge, could have stated before the executing court that no appeal or stay application has been filed. Full stop. Another aspect of the matter cannot be overlooked. Full stop. Since the appeal was filed at a belated stage, comma, and was accompanied by an application for condonation of delay, comma, strictly speaking, the appeal was non-est in the eye of law, and as such, the statement that no appeal is pending at the relevant juncture could not be said to be incorrect. Full stop. The appeal has been registered and regularized only today, comma, with the application for condonation of delay in preferring the same being allowed earlier. Full stop. Thus, comma, we do not find any gross illegality on the part of the decree holders in taking possession in execution of the impugned decree during pendency of the appeal. Full stop. Be that as it may, comma, as of today, there is no scope of passing any stay order since the decree has already been satisfied. Full stop. Accordingly, Can 2 of 2025 is dismissed as infructuous without any orders to cost. Full stop. In view of the appearance of the respondents to their learned advocate, service of notice of the appeal is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the party as and when the same is ready for hearing. যদি না বলে থাকে শুভ্র, তাহলে প্রথমে এফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট অন রেকর্ড।
Not 20 for the defendant.
Yes.
Or post appeal is there, my lord. Yesterday, my lord submits.
Yes, yes. You had got a copy of the application. Yes, yes. What is the matter?
Lord, this is a partition suit which was dismissed on the ground of misjoinder and non-joinder of parties, my lord. And
You have a cross appeal, you said?
Yes, my lord. I have a cross appeal.
That is also appearing today, no?
Yes, my lord.
You are appealing?
No, not appearing in the list, my lord.
Not appearing in the list.
I have given the number to yesterday, my lord.
ওই নাম্বারটা আসেনি কেন ওটা?
The last occasion, your lordship directed both the matters to be appearing together. So, yesterday, I have also mentioned, my lord, that
এই তো অর্ডারই তো রয়েছে আমাদের, অ্যাডভোকেট দিয়েছেন। নোট করেন না কেন? যখন হয় তখন লেট দ্য ম্যাটার বি লিস্টেড টুমরো আন্ডার দ্য সেম হেডিং বলেছি ওই অন্য অ্যাপিলটার সঙ্গে। ইয়েস।
So we study your lordship, follow from your lordship, my lord, that's absolutely correct. I vow on, my lord, dedicating the non-general party, it can be demanded. But my lord, the counter appeal is there, my lord. So both the
yes, yes, you are right.
Analogously, and let them direct to paper book. And the LCR.
Very well, will direct the. There is no appeal in no application in connection with that cross appeal. Obviously, there is no scope. What is the number of that appeal? সেটা নাম্বারটা
মানে
FA 94 of 25
That is my lord, present appeal.
Present appeal,
Yes,
acha.
my lord, and the counter appeal is FAT 94 of 2024.
No, FAT 94 of 2024 is my appeal, my lord.
25 is mine.
25,
Yes,
yeah, 94.
FAT 94.
No, I apologize.
FAT 94 of
It was renumbered, my lord.
Yes,
It was FAT 67, then mine was renumbered as 94 of 2025.
What is their number?
FAT 94 of 2024. That is our counter appeal.
94 of?
2024. FAT.
No FA number has been given
No.
to that. Your FA number and their FAT number are coincidentally the same. We are disposing of the injunction application, granting injunction. Your partition suit has been dismissed for non-joinder.
Yes, my lord. And the injunction was granted to me.
But all the other issues were held in your favor against which they have filed an appeal.
Yes.
Issue number 7.
The present appeal arises out of the dismissal of the appellant's partition suit primarily on the ground of non-joinder of necessary parties. Full stop, next para. It is informed to the court by the learned advocate for the respondent that an independent appeal bearing FAT number 94 of 2024 has been filed, which is in the nature of a cross appeal, against the findings of the learned trial judge on the other issues in favor of the appellants in FA 94 of 2025. Against Pullam? Na in favor of Pullam. Findings, sir?
My findings of the learned trial judge on the other issues in favor of.
In favor. Okay. Full stop. Next para. Thus, we are of the opinion that both the appeals are required to be heard analogously. Full stop. Next para. Can 1 of 2024 is an application filed for temporary injunction in respect of FA 94 of 2025. Full stop. In view of a prima facie case having been made out, we are granting a status quo with both parties.
Milord, on the last occasion, on 12th March, your lordship was pleased to pass a stay order in our favor in respect to Can.
Injunction order or what? Oh, no.
Yes, an order of injunction.
Oh, then we'll continue that order. Accordingly, the Can 1 of 2024 is disposed of on contest by passing an order of injunction restraining the respondents and/or their men and agents from selling, transferring, alienating, and/or encumbering the suit property in favor of third parties in any manner till disposal of the appeal. Full stop. There will be no orders to cost. Full stop. The appellants shall put in the in view of the appearance of the respondent through their through her learned advocate, service of notice of appeal is dispensed with. Full stop. Next para. The appellant shall the trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellants shall prepare and file the requisite number of composite paper books in respect of both FA 94 of 2025 and FAT 94 of 2024 within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention FA 94 of 2025 and FAT 94 of 2024 for inclusion in the list as and when the said appeals are made ready for hearing. You prepare composite paper books. Include their memo basically.
Yes, madam. Well, the stay application more or less covers everything, all the records.
So you can get those documents from
Only stay application mention the grounds of appeal.
No, they have to annex your memorandum and mainly your memorandum. All else are the same.
Beseeching your lordship, subject to
give a copy of your memo to him. Yes. We are not recording that, just hand over a copy. Yes, please. Good service has been affected.
7% are received.
Right.
And 6% are return addressee left without instruction. And 1% the Manwara Bibi, who is in the decree, her name is there as she is dead, my lord.
Oh.
Well, can you see?
Then we'll keep those on record, but you have to take steps for substitution then. In the name of dead person, we cannot. The affidavit of service filed today indicates that 7 of the respondents have been served. Push up insofar as 6 others, comma, the envelopes have returned with the endorsement addressee left without instruction. Push up next para.
On Manwara Bibi.
Insofar as Manwara Bibi is concerned, comma,
Her name was
no, her name was expunged in the trial court.
expunged, my lord.
Yes, that's the office report.
My lord. Then, my lord.
Insofar as Manwara Bibi Bewa is concerned, comma, it is found from the report sent by the learned civil judge, senior division, Kollani district, Nodia, dated April 2, 2025, that she had died during pendency of the suit and her name was expunged since her heirs and legal representatives were already on record at plaintiff numbers 2 to 12. Push up next para. Accordingly, no steps are required to be taken. Manwara Bibi is a party here. According no steps now. Accordingly, the learned advocate on record is granted leave to delete the name of the said Manwara Bibi as a respondent in the memorandum of the present appeal during the course of the day. So, but you have to serve on the others also. What is the application for?
Application for stay of the.
Are you enjoying an ad interim order?
My lord,
So you serve, you have to ascertain the address of these persons and serve again.
Yes.
So next para. The appellants shall ascertain the address of the unserved respondents at the earliest, whose leave is granted to the learned advocate on record for the appellants to carry out the necessary amendments to titles of the memorandum of appeal and the connected application for stay by incorporating the current addresses of the said absentee respondents. Pushed up. Upon effecting such correction, comma, the appellants shall serve fresh copies of the application on the said absentee respondents, unserved respondents at their current addresses and file a fresh affidavit of service on the next returnable date. Full stop.
But very difficult. As per plaint I serve. As per plaint address I serve. And current address, my lord, is very difficult for us. I served as per.
Acha, very well. In the event, the current addresses of the said respondents cannot be traced out by the appellants within a week from date, comma, liberty is granted to the learned appellants to serve copies of the application on the learned advocate who represented the plaintiff stroke unserved respondents in the trial court and to file an affidavit of service to that effect on the returnable date. Whose of the application shall next be listed in the monthly list of May 2025. The affidavit of service যেখানে বলেছি affidavit and envelopes. Thank you. You can serve along with a server copy of this order. Otherwise, the learned advocate will say, I don't have any connection. But the other plaintiffs, their co-plaintiffs have been served.
7 is already received.
But on the next occasion, if he does not receive also, just file an affidavit of service. Just remind us that the other co-plaintiffs have
already
received. They appeared together, so we'll treat it to be good service. For the time being, enjoy this day.
2 to 13.
Deleted case. সব যদি plaintiff থেকে থাকে তাহলে আপলোডটা ঠিকঠাক হয়েছে?
হ্যাঁ, আপলোড এটা আপলোড করেনি।
করেনি তো?
না।
ওয়ানটা উড়ে যাবে?
ওয়ানটা করেনি। এখানে
ওটা দেখে নিয়ে যাবে?
না, এখানে
এখানে কিছু নেই। ওহো, ভিতরে তাই আছে তো? ও এটা হ্যাঁ, রংলি নাম্বার যেটা, হ্যাঁ এটা 193 ছিল। আগের দিনের একটা অর্ডার। হ্যাঁ, কল করুন।
Your Lordship said the occasion to decide an appeal in this from another application in this suit. Now, may I straight away draw your Lordship's kind attention to that order? Somewhat similar we are wanting. That was an injunction. This is a receipt. Kindly comes to page 352 once, my lord.
The pagination by pen. Those are the
Yes,
paginations
yes.
will follow.
But 352, your lordship.
352.
352.
Yes.
Now, there's an order dated 10th of February 2025.
Right.
Now, this was from an injunction application being dismissed on contest. Your lordships were pleased to reverse that and confirm the injunction order till the disposal of the suit. But may I place it? The present.
So what is the present impugned order?
Present impugned order is the dismissal of the receiver application on the ground that the injunction application was dismissed.
Oh.
So this is after that.
Oh.
So, my lord,
We have admitted the appeal. This appeal,
yes,
present
yes,
appeal.
yes.
You have served on the other side.
I have served. But
They have been appearing also, Mr.
No, they had not. They had not.
Last time affidavit. Oh, yes, we dismissed
No,
with served.
yes, yes. Your lordship kindly sees this order. My lord. This would give your lordship
But
a bird's
interim
eye view of-
receiver can we appoint even if we are satisfied? You are asking for receiver now.
Yes. My lord, your lordship will kindly have a look at what order your lordship was pleased to pass, which permitted us to do.
No, receiver was as a very. Let us see it. Place it.
Yes, my lord, may I paste it from the start because your lordship will get the overall view of it. The present appeal has been preferred against the dismissal of a temporary injunction application filed by the plaintiff appellant in a suit for identical reliefs by way of permanent injunction and other ancillary reliefs. Learned counsel for the appellant submits that the learned trial judge failed to consider the title deed of the plaintiff by virtue of which Schedule B property, which is the suit property, was purchased through a court sale. The property was subsequently let out to a third party, however, later on merged with the plaintiff. Thus, the plaintiff is the exclusive owner of the suit property, that is, the Schedule B property marked with green hatches in a plan annexed to the plaint. It is contended that the defendants produced certain documents before the trial court at the time of final hearing of the injunction applications, copies whereof were not handed over to the plaintiff at the relevant juncture. However, by virtue of the order of this court, copies of those have now been handed over to the plaintiff appellant. Even from the said documents, it is found that the name of the defendants do not find place to be in the occupation of the suit property. Learned counsel further contends that although the names of two persons appear as Borgadars in respect of one of the plots of the suit property, there was a paper publication of the pendency of the suit and the injunction application pursuant to the direction of the trial court by way of substituted service, and none has come up to resist the suit or injunction or implead themselves in the present suit. That apart, although the names of one Kanuria jute mills and one Hanuman cotton mills find place in the LR records, it is the Hanuman cotton mills, the predecessor of which was Kanuria jute mills, from which the purchase was made by the plaintiff. The learned trial judge, it is argued, failed to consider that the defendants have not been able to produce any document in support of their contention that they are in occupation of the suit property by virtue of an irrevocable license granted in their favor by Messrs. Hanuman cotton mills. Learned counsel appearing for the defendant contends that it is not clear from the schedule of the title deed produced by the plaintiff in support of its case as to whether the suit property is described in the plaint and depicted in the plan annexed here thereto is the exact property which is, according to the plaintiff, lying vacant. The plaintiff itself has admitted that some portions of the property have been encroached upon, and as such, it is doubtful as to whether the property marked by the green lines is vacant or not. Moreover, the grant of present temporary injunction would tantamount to granting final relief of permanent injunction sought in the suit itself, which is not permissible in law. Learned counsel for the respondents further argues that as per the finding of the learned trial judge, the materials on record, some portions of the property has been shown to be doba or pond, which is contrary to the case of the plaintiff. We find, upon hearing learned counsel for the parties and a perusal of the impugned order, that the learned trial judge proceeded inter alia on the premise that a portion of the property has been depicted in the record of rights as pond or doba. However, we are of the opinion that the said factor is not germane at all for the present consideration, which is whether the property in question belongs to the plaintiff and is lying vacant or is in occupation of the defendants. The learned trial judge has also proceeded on the premise that it is doubtful as to whether the Schedule B property extends to the Hooghly River, and as such whether there is a bank which would substantiate the case of inundation of the said bank requiring boundary wall to be created as made out by the plaintiff. However, irrespective of whether there is any inundation or caving in of any bank of the river, the plaintiff has also made out an independent case of title and vacant possession of the suit property, which by its very nature requires the property to be protected by a boundary wall. The defendants even, this is the relevant portion, then paragraph 13, the defendants even from the documents produced by them in the court below have utterly failed to substantiate their case of irrevocable license. In any event, the concept of irrevocable license flows in Indian jurisprudence from the Easements Act, which is not applicable in the state of West Bengal. Mere applicability of the principles incorporated in the said statute by way of justice, equity, and good conscience is not a strong enough justification to import the specific doctrine of irrevocable license in terms of the specific provisions of the state statute to the state of West Bengal. Moreover, there is precious nothing to record to substantiate the defendant's case of irrevocable license and or the defendants being in occupation of the Schedule B property. In the written objection to the injunction application in the trial court, the defendants have sought to make out a case that they are running a security agency over the disputed property and it has its own office there. However, the records of right produced by the plaintiff, that is, the RS records, clearly show the occupation and possession of the plaintiff exclusively. Even from the LR records sought to be produced by the defendants' respondents, there is nothing to indicate occupation of the defendants on the said property and the plots comprised of the same. Insofar as stray names of two purported Borgadars in one of the plots comprising the suit property is concerned, there is substance in the contention of the plaintiff appellant that despite paper publication, if none has come forward to contest the suit or implead themselves herein, it cannot lie in the mouth of the defendants to espouse the cause of third parties. Also, if a decree is ultimately passed in the suit, it would only bind the parties to the suit and not third parties. Moreover, we find from the materials on record that the title of the plaintiff to the suit property has been established beyond doubt by virtue of production of title deed in their favor pursuant to court sale. The RS records, which carry a forward presumption unless rebutted, also indicate that the plaintiff is in possession of the property. The LR records, if they subsequently bring about a change in such position by incorporating the name of the predecessor of the plaintiff, thereby turning the clock back, cannot be lent credence in the absence of foundational documents or proof to justify such alteration in the names of the occupiers from RS records. In the absence, in the present case, of any document which provides the foundational premise of such alteration of the names of the occupants from the plaintiff to someone else, we are of the opinion that the plaintiff's case has to be accepted as a sufficiently strong prima facie case for grant of injunction. That apart, we also find that since names of the recorded occupiers of the property in the LR records are substantially the predecessors of the plaintiff itself, there is no scope of disputing the plain case by holding that those predecessors are still in occupation even after the court sale being effected in favor of the plaintiff and the plaintiff's name being recorded in the RS records. Thus, palpably, such recording in the LR records is erroneous. In such view of the matter, we find that the learned trial judge has completely misdirected himself in relying on irrelevant yardsticks to refuse injunction to the plaintiff in view of the plaintiff having substantiated its case of title by virtue of producing the concerned title deed and also possession by furnishing the extracts of the RS records, which could not be rebutted by the defendants at the injunction stage by showing any document whatsoever in support of the defense case of being in occupation of the said property by virtue of any license, irrevocable or otherwise. Hence, we are of the opinion that the learned...
What is the receiver now you're asking for? Receiver application has been dismissed by the impugned order or ad interim.
Before answering that query, could I only show the plan why we are apprehending?
Yes.
If your lordship kindly takes a look at 168. Page 168.
We granted you injunction virtually permitting you to construct the
boundary. Not only the boundary wall and also other constructions.
No.
Inside the suit property.
Yes, right.
So, my lord, what is happening now? My lord, we have prepared. My lord, this.
No, we directed them, restrained them from entering. Or interfering with the construction of all.
Yes. Now, your lordship will kindly have a look at page 168 once.
Yes.
Well, the suit property is only restricted.
Green.
To, yes, now here it is, I think, in blue. I don't know why there's a change now, but this portion is a suit property.
Men are mostly colorblind, so your green may be actually, your blue may be actually green.
Your Lordship will kindly see page 168 once.
I'm more of a woman than a man, so I can see green here.
Well, there is one green, one blue, and one red.
Red, I can't see.
Well, may I?
This is our copy.
Well, this portion is the suit property.
That red is not appearing in our.
But red is the encroached. Those are the other portions.
We don't have a red here. We have black instead of red. You can see, look at it.
Your Lordship need not be troubled with that. May I indicate? Well, this entirety was purchased by the deed. Well, we are only concerning the suit property where our factory is and the precincts of the factory.
Which is the suit property?
Which is, Malud,
The bold boundary. or
the
what?
bold boundary. Yes. The bold boundary.
This bold boundary.
Yes. Yes. So this bold, we want a boundary wall along this bold boundary.
So you've already got that injunction.
We have got the injunction. Now what is happening is the entire other portions, which your Lordship would see from the map, are all Malud trespassed portions, which is not the subject matter of the suit. But they
receiver
are
for what purpose? What will the
for the
receiver do?
purpose of construction. It's really Malud receiver to
Ask
get a
for
police help.
before court.
It's really Malud receiver with
Why
the
should a
police help.
receiver come in?
A receiver can appoint also an agent, but with unless the
Why should
property
a
we can.
receiver be there in the first place?
But otherwise we are unable to proceed with anything.
Go to
But
the
may
police
I-
will give you that liberty. Ask for police help from the trial court. Police will
Before the lower court, my lord, the proceedings are, my lord, I have prepared a list of dates to indicate your lordship what plight we are suffering before the lower court, why we have also been constrained to file a clause 13 application for the suit to be transferred.
So that we cannot.
No, that kindly sees, my lord, your lordship will kindly see the list of dates.
No, but how will this help you? This may
No,
prejudice us against the trial judge.
No trial, the trial court is not passing any order whatsoever because of the locality. So, my lord, what we are wanting humbly, your lordship would kindly consider that.
You have already got an injunction.
I've got an injunction.
So you can have it implemented by a police help application before the court below. Why? What is the question of a receiver? Receiver is not appointed at the drop of a hat.
But receiver to appoint an agent and to get the police help, because if your lordship sees my prayers, in my prayers I've also
Why
paid
go
for
in a
police help.
roundabout way? Just ask for police help.
But I've also paid
We'll
for
make
police
it clear in our order that you will be at liberty and that if so filed.
But if the receiver is not appointed,
Receiver we don't find it.
There's a threat of encroachment every day which we are facing.
What will the receiver do? Who will be that receiver? An advocate?
An advocate receiver?
What will he or she do?
but with-
Remain there 24 hours?
No. With a liberty to appoint an agent, and the advocate can also communicate to the police, because if your lordship knows that practically, if an advocate's letter goes as the receiver of this honorable court, then my lord, the effect of that with the police authority is something
Client
else.
has extra
There
money.
are 12 complaints.
The client has extra money. Will direct your client to pay that to their counsel.
No, my lord, I'm not.
to receiver.
But I'm not saying that. There are 12 complaints to
Receiver
the
come in between.
There are 12 complaints to the police who do not do anything. There are several rounds of litigation.
What will exactly a
no
receiver
order-
do?
But a receiver
The receiver will act as a middleman.
to take charge of
Whatever
that.
you can do, the receiver has to do that only. He cannot have more powers than you.
I understand, but because of the situation, I'm compelled.
Suppose this situation prevails, the police is not acting. What will the receiver do? Approach the court, asking for an order?
Yes.
You can do that. Why the receiver in between?
There are only two things. Otherwise, I would not. I'm completely.
How will a receiver improve situation?
But a receiver being there in respect of a property and putting up a signboard, something of that sort, creates a better footing for us than only we being there. First. Second is a receiver communicating.
Don't appoint receivers for putting up signposts. Advocates have better things to do.
Or anybody else then, if not an advocate. Well, may I indicate one thing? A receiver communicating to the police for the police. If there, well, in the list of dates, I've indicated.
Communicate will give you liberty. It will be a court's order, trial court's order.
Kindly do not send this back to the trial court. Well, kindly do not send.
No. You cannot.
Well, kindly do not send it back. But this is the fourth time we have to come up before this honorable court.
We cannot grant police help from here.
But I have prayed for that in the trial court's application also. In the trial court's application also, the receiver to get police help. Your lordship can always mold it, modify that.
Appeal is
So lordship kindly sees the prayers.
The appeal is pending here.
Yes.
We are on an interlocutory application.
Which has been disposed of finally on contest.
That receiver, but before us, it's only an interlocutory application. Appeal has been fixed. This is the application.
This is the application. Appeal.
Application for receiver.
This is the application for receiver.
Receiver in any event. We can give you liberty during pendency of this appeal also. We'll make it clear in an order that if such an application is filed, the trial court will
kindly do not send it back to the trial court. The plight which we have suffered, that is why I have prepared the list of dates.
Just because you don't like the trial court, you cannot use up the jurisdiction of the trial.
But may I only say this? If your lordship can seize my receiver application, where I've prayed that. I have prayed for police help to be get by the receiver. Your lordship can always, my lord, give a if your lordship kindly seize my receiver application once, my lord, there I've also prayed for police help. Your lordship would then restrict it to the plaintiff praying for that police help.
Plaintiff?
Plaintiff praying for that police help.
Yes.
If not the receiver. Because we have
If a receiver does, if the court is biased, how will that be special?
No, if your lordship kindly
If you
seize my
if you appoint a receiver, that receiver comes to court, to the trial court and says that the receiver will also have to go to the trial
before
court.
the trial court, the order 40 application is gone. It's not no
No,
longer.
no, even if the receiver approaches the trial court, your apprehension will come true. If the court, according to you're indicating bias of the court, which we are not looking into,
Right.
but even if the court was for the argument's sake to be biased, then if the receiver files an application asking for police help, how will that make a difference?
No,
It will be easier for the court.
But I am not saying the receiver is asking for the police help. In my
What will the
prayers,
receiver do? Physically stand there with a
at least some
the
appoints
bamboo
agent.
pole or something like that and then
at least-
shoo away the intruders.
No, with the police.
Receiver
with the
doesn't
police
have it.
authorities when the construction is started.
We can appoint the local OC as the receiver.
The situation there is, my lord, we are
You can appoint the local OC as a receiver and he'll earn more than you.
situation which prevails there. We are unable to, my lord, even get the measurements done. We have appointed, my lord, the architects or the surveyors to carry. We are unable to even do that. That is why the entire apprehension. Otherwise, what is falling from your lordship is absolutely, my lord, correct, my lord. Otherwise, I would have never, my lord.
Let us see the trial court's receiver application, which has been.
Yes. Kindly comes
the
to
prayer.
page 382. We are unable to do anything, my lord. That is why we have said even the construction receiver to appoint the contractor also.
But if you allow that application from here, it will be allowing the appeal, Mr. Gupta.
Will
be allowing the appeal.
Your lordship has already permitted the injunction application permitting us to carry out the construction.
Mr. Gupta, at this stage, we cannot allow the receiver application. We cannot appoint a receiver because we are hearing an appeal against the refusal of a receiver application on whatever ground.
So they are not appearing despite service. So
Their
my lord,
service was only regarding the application. The appeal
not
notice has not yet been served.
Yes, not the appeal.
This will tantamount to allowing the appeal itself if you appoint a receiver from here at this interlocutory stage, which is unheard of. And receiver, this is not an injunction. Injunction is a prohibited order.
I understand.
Receiver is a positive assertion. I mean, we are appointing somebody, and that is precisely what has been refused by the trial court on whatever ground.
But that ground is now no longer it's
no longer.
Subsequently, your lordships have already.
We cannot allow the appeal at this stage without hearing the other side and without giving them a notice of the appeal.
But we can give a notice of
notice and come back next week. We'll take up the appeal application together.
Yes.
And we'll hear it on the basis of these papers.
Yes.
And just for before that.
And your lordship would be astonished to see that we had to couch this prayers that way. Kindly comes to page 409.
You have asked the receiver to construct a
by
boundary
appointing not receiver, by appointing a contractor. Not the receiver to
proper
construct.
Person be appointed as
by
receiver.
engaging a contractor.
And the receiver so appointed be directed to construct us.
By engaging a contractor. So we are unable to do anything. Our people are unable to even go there.
We don't still understand. Suppose your people can't do that.
At least a receiver with police can go.
You also can do the same thing with police. That is precisely what we are saying. Ultimately, it is muscle power that matters. Muscle power can be provided by the police only. A receiver, suppose I appoint you a receiver, and we can actually do that, Mr. We are thinking about the learned advocate and record for the appellant. We will appoint him as a receiver. Let him go and do whatever he can. Why jeopardize somebody's life and limb? We'll appoint your advocate and record because it's your brainstorm. We'll appoint him as a receiver and let him go there and do whatever he likes. Let him resist the intruders. For the time being, we'll do that. No, definitely. We are allowing your prayer. Ad interim prayer, the receiver we are appointing your advocate and record. We have full faith on our officers. You go there and do whatever you want. We won't jeopardize a third learned advocate. You go there, resist the intruders, and call the police and supervise the construction of a boundary wall. And in the meantime, your litigations will be handled by some other advocate.
That is what you are precisely saying.
Including this matter. To ensure that this is not mentioned before this construction of the wall is done. We'll appoint your advocate and record as a receiver.
But may I?
What will the receiver do, Mr. Gupta? You don't understand. You will only understand if your advocate and record is appointed as a receiver.
Then could
We'll
I-
grant you police help. In the meantime, we can't do anything.
Yes, your lordship will grant
When the
police help
final
after
order
serving.
will be that. We will grant you police help. We still can, at this present moment also, we can direct the appeal and the application to be taken up together.
Yes, we shall serve.
Give another
fine.
notice.
We shall do that.
And we shall treat that as a notice of the appeal.
Right.
And in the meantime, we give you leave. You approaching the trial court at the first instance.
That is the only thing.
No, you
Otherwise, I'll
approaching
bow
the
down to every order.
Let us complete the sentence. You approaching the trial court at the first instance, and you approaching the trial court with the help with a server copy of our order makes a difference.
No, there are 3 orders passed by the division bench. The trial court says extension of interim to go to the division bench. I will not extend. This is the audacity of the trial court. The division bench extended that for a period of 7 months, directing the trial court to hear out.
Rightly said. If the division bench extended, if I was the court, if you obtained an order of extension,
Granting
from
the trial court to hear,
See.
granting the trial court to do the hearing and so we file an application because of the non-appearance of the other side. The hearing could not be done. The trial court said, go back. This is the 4th appeal which we had to come on from the injunction only. 4 times we had to approach this honorable court. This is the plight which we are suffering because of the local influence. But whatever order your lordship passes.
Police will act on the server copy. We'll grant you liberty to approach the police from here, and we'll
Whatever
direct the
order,
police.
I bow down whatever order.
Police to, now you will bow down, obviously.
Yes, I don't want to go to the trial court. That's the only thing.
No. We are at this stage. We are granting you liberty to approach the police directly to take police help. And if you approach the police will act on the server copy of our order to ensure that the injunction order is implemented.
Yes.
We'll grant that
Yes.
at this stage.
Yes.
Learned counsel for the appellant contends that a receiver may be appointed immediately to implement the order of injunction passed by this court in a previous appeal, which was preferred by the appellant against the refusal of an injunction application. Previously, ad interim was refused. Injunction or final?
Previously, ad interim refused, then contest refused, then
Refusal of an injunction application of the appellant. Push up next para. It is the present appeal arises out of an order whereby the appellant's application for appointment of a receiver for the purpose of supervising the construction of a boundary wall and seeking police help if necessary for such purpose, in order to implement an injunction order, was refused. Full stop. It is contended that the very premise of the impugned order was that previously an injunction application of the appellant had also been refused by the learned trial judge, which position, however, was subsequently reversed by virtue of the order dated
10th February 2020.
which page?
352, my lord.
By virtue of the order dated February 10, 2025, passed in FMAT 213 of 2024. Full stop. Next para. Despite service of notice, none appears for the respondents. Full stop. However, at this juncture, in the event we pass an order appointing a receiver in connection with the present interlocutory application, the same would tantamount to allowing the appeal itself before final hearing of the same. Full stop. Next para. Hence, we decline to grant such order. Full stop. Next para. However, since the appellant has made out a reasonable apprehension as to the injunction order passed by this court in FMAT 213 of 2024 not being complied with, we hereby grant liberty to the appellant to approach the officer in charge, inspector in charge of the local police station for police assistance to implement the order of injunction dated February 10, 2025, passed in FMAT 213 of 2024. Full stop. Next para. In the event such approach is made by the appellant, comma, the officer in charge, stroke inspector in charge of the local police station shall act on the server copy of the present order, comma, coupled with a server copy of the order dated February 10, 2025, and a communication in that regard by the learned advocate for the appellant, comma, without insisting upon prior production of a certified copy of any of the said orders, and grant adequate police assistance to the appellant in order to implement the order of injunction by constructing the boundary wall in question around the periphery of the Schedule B property as reflected in the plaint of title suit number 147 of 2021. Full stop. Next para. Can 1 of 2020. We are disposing of the can with this.
The records would be there. So, there's nothing else. So, if it could formally be there, subject to what falls.
That's very well. Can 1 of 2025 shall be heard along with the appeal, full stop, in view of the papers, relevant papers being substantially annexed to the injunction application, comma, substantially annexed to the receiver application before this court, comma, the calling for the trial court records is dispensed with for the present. Full stop. The appeal along with the application shall be heard together on April 28, 2025, when the matter shall be listed under the same heading. Full stop. Further notice, comma, along with a server copy of this order shall be communicated to the respondents. Are they represented by advocates in the court below?
Yes.
By the on the respondents as well as their learned advocate in the court below, indicating that the appeal and the application will be taken up for hearing together on April 28, 2025. Full stop. An affidavit of service to that effect shall be filed by the appellant on the returnable date.
Great. Okay.
Great. Thank you.
My lord, I appear for the appellant. Sir, I am for the plaintiff respondent. My lord, in this case, my lord, kindly see the order dated 26th March 2025. There are deficit code fee I have to put in, my lord, and section 5 has been, my lord, filed, but it is appearing from the stamp reporter's report that there is no section 5 application. But my lord, I have filed it and it has been numbered as can 1 of 2020.
Section 5 is appearing today? No.
No, my lord. It is stated.
Please give the can number. We'll just
can 1 of
call for that. Give a copy to your learned friend and you have got.
He has been served, my lord.
We'll dispose of the section 5 application, and if you allow it, we'll take up the appeal for order 41 hearing. But what are the other defects?
Other defect is, my lord, deficit court fee, that is of 40 rupees. I shall put in
20 rupees.
20 rupees.
The proper court fees is 420. You have deposited 400. So you can appreciate that sensitivity.
Yes, yes. And that one, my lord.
But you will have to deposit the rest of the 20 rupees.
Yes,
one.
I shall put. I will put in.
By this week.
Yes, sir.
Name of appellant not in decree of appeal.
Rectification required from the, my lord, learned trial court. It is to be transmitted.
Very well. Under LTI of appellant seen the Vakalatnama does not tally. With that, either in the decree or in the cause title. So you'll have to file a fresh Vakalatnama for appellant number 3. Can you do that within this week?
Yes. Not my lord. Next week, my lord. Kindly give
next week. So we'll give you 2 weeks.
Bakura.
Bakura, then we'll keep it on 22nd Tuesday. Any difficulty on that? No. Very well.
So far the other respondents, my lord, respondent number 2A, 2C, and 6, my lord.
We directed you to serve the section 5 on them?
No, my lord.
Oh, the section 5 has not yet been.
Yeah, I have served. I have sent, my lord. But what happened, my lord? They are not available in their address.
But that send.
So I am.
But that service, we cannot look into that service, Mr. Bhagwati, no, unless we direct.
What I am saying, my lord, that I may be given liberty to serve upon the learned advocate appearing in the trial court.
Unless the application comes before us, we cannot pass an order in that application. It cannot be uploaded.
My lord, the
Can 1, we cannot pass an order on Can 1, directing service. Yes, and Mr. Bhagat, you know, this is a substitution of the issuance of rule. So unless we pass a direction, if they appear, then it's all right. We can take note of that. Without our direction, you cannot, that service is not proper.
then I shall serve, my lord.
Let that application come first. Can 1 ache kane?
Stamp reporters to
No, Can 1 is appearing, yes, right? No, section 5 is before us. So we can pass that order. Yes, that is before us. That is appearing in the list. In the next column, that's why probably it missed it. What is the delay? 9 days.
9 days only.
Anyway, you have to serve copy. On the trial court's advocate will.
For my
You
lord,
are for which respondent?
My lord, I am for the all respondents.
no, all respondents. তাহলে ঠিক আছে।
একজন বাদ।
কোন কে বলে?
2A.
So my lord, I shall serve upon
Where is the question? Why did you waste so much time?
Yes, yes. I don't want
No, we wasted also this time because of him. But he did not say that he is not appearing.
Yes, my lord.
2A, you are not for 2A.
7 except 2A, my lord.
C.
You are not for 2ABC.
Nah.
They were represented together with 3, 4 and all in the court below.
Yes.
Then there is substantial service affected already. You take Vokalata for them also.
নিয়ে নাও 2A, 2B, 2C আর 6
Yes, what do you say? Can you take Vokalata for them also?
My lord,
They appeared together in the court below.
Yes. They appeared.
Affidavit of service, you are ready with an affidavit of service. Learned counsel for the appellant seeks a day's adjournment for filing the affidavit of service. Push up. Although substantially all the respondents are represented through counsel, comma, respondent numbers 2, series and 6 are not so represented. Full stop. However, comma, we find that since
2 ABC, only 2 ABC.
6 you are appearing.
Yes, yes. We are appearing for respondent 1, 3, 6, 7, 8.
What about 4 and 5?
4 and 5 not appearing.
না না 4 সার্ভ হয়েছে
আমাদের কাছে নেই
4 has been served, my lord.
আমাদের কাছে নেই
শোনো এসব কেটে দাও The appellants shall serve copies of Can 1 of 2023 as well as Can 2 of 2023 along with a copy of the memorandum of appeal on all the respondents and file an affidavit of service on the returnable date. Full stop. However, comma, service on the respondent numbers, give the numbers please in a slip of paper.
Yes,
Such and such, jeta deben uni, are dispensed with in view of appearance of the said respondents through their learned advocate.
My lord, 4 has
The
4 has accepted the service.
No, that service you cannot look into. But the matter shall next be listed under the same heading on April 28, 2025. উনি দিলে ওটা ওই থেকে
But Malad, can you take the matter 23rd?
Why?
Because Malad, 21st to 22nd, Malad, I have been certificate.
We have fixed it on 28.
28
Please ensure that the correct numbers are given.
Yeah.
Yep. Mr. Chatterjee, deficit court fee has been cured.
It was paid on 4th of October 2024. Kindly accepts.
We'll just record
These
that.
days, they don't give an A number, I don't know, there's something online or something.
Oh, they don't give a
They don't give an A number.
Just check
right?
up. There are other defects also. First name of the respondent in the that has to be done by the trial, the court below. Surname of the respondent number 1 in the memo does not tally with decree of both the courts below. We will give you liberty to correct that.
Correct.
Respondent number 1, Kundu, Purnima
Purnima Kundu,
Yes.
wife of late
Kunda. It should be Kunda.
Kundu no. Kindly glance that.
Deficit court fee will record. When was it?
4th October 2024.
Learned Senior Counsel appearing for the appellant submits that the deficit court fees were deposited on October 4, 2024. Full the office shall give a revised report in that to that effect. Full next para. Leave is granted to the learned advocate on record for the appellant to carry out the necessary correction to the surname of the first respondent in the memorandum of appeal during the course of the day. Even if you dismiss the appeal, then also please make that correction.
Yeah, definitely.
Number 2.
Defense
Respondent 2.
The first name of
No, no. ওটা respondent 2 হচ্ছে trial court যাবে correction. 1 to yes.
Defendant's appeal in a suit for eviction on the ground of reasonable requirement.
Affirmance.
Judgment of affirmance.
On all grounds, nuisance.
No.
Only requirements.
All other grounds were dismissed only on reasonable requirement. That too, my lord. Lordship need not even open my lord's. It's not on that at all. It's not calculations again. The ground of reasonable requirement was only, my lord, that they needed a garage for their car. The room which they say, my lord, that I am in possession is the garage. The advocate commissioner, my lord, who went, he has found that from the pavement to the room which I am in occupation of, my lord, there is a difference of 3 feet and 6 inches. So it cannot be a garage in any manner. This is my only point before your lordship. But the
Culvert
not there.
can be constructed.
There are staircases. One. The second part is they don't have a car.
Staircases is reflected from the commissioner's report.
Their admission, commissioner's report, everywhere. Staircase.
3 feet difference.
3 feet, not 3 inches, 3 feet. Secondly, my lord, they admit also that there is a place where they used to rent out, my lord, for car parking, which was never considered by any of the courts, my lord.
They have a rented accommodation.
In their premises, they rented out to other people to keep their cars there. That can be this way or that way, whichever way, my lord, but it's an admission that they have made. They said that it's only a temporary arrangement. This cannot be a, my lord, your lordship knows those age-old decisions, cannot be a ruse to evict the tenant. Not fanciful, my lord, if it's a room, if there was anything on record to show, my lord, that this was convertible into a garage, I would have understood.
What are the specifications of the room?
Yes. Kindly have a look at the report, which your lordship will find at page 9 of the stay application, my lord.
Here 91.
90, I'm sorry, 90. Basically takes up 91. My lord, it's 8 feet by 10 feet, 8 feet by 10 inches, and height is 7 feet by 10 inches. Then it was also pertinent to mention
8 feet by 10.
Yes,
Point number 2.
Point number 2.
Hmm.
The
Yes,
length
8
of the
feet
room
wide.
in occupation
Yes,
of
yes.
defendant. The height of the said room in occupation was 7 feet by 10 inches.
Right.
It was also pertinent to mention that the floor of the said room in occupation of the defendants was 3 feet 2 inches below the footpath level.
Below.
So it's downwards. So this can never be a garage.
Front of the room.
At the front of the room, there were 5 steps, your lordship was looking, from pedestrian path to the floor of the said room. This itself, not in my respectful submission, clinches it that it's not a garage. Then there was an iron rod framework with transparent shed abutting on the footpath just in front of the tenanted room. I ascertained that no obstruction would be caused for thoroughfare of a car from the road to the tenanted room due to construction of the shed. This is an advocate commission, my lord, he could not have gone through it. The learned judge has come to a finding to that this was beyond his gamut. And then, my lord,
But is that admission that they have another, they have
kindly first looks to
another garage space?
page 118 once. This is the money receipt, my lord, which was exhibited.
Yes.
Sees the second paragraph, parking space within my premises in regards of the car number such and such.
This was given to you.
This was given to somebody else.
No, you are Purnima. Purnima is she, sorry.
Fortunately, unfortunately, my lord, this gentleman was a member of our institution. That's why we've got this evidence.
Who was a member of yours?
The person to whom, my lord, it was rented. So that was also proved. And she admits that at page 49. Bush.
When was this given out? With effect from 1st May 2000?
Yes, sir.
No, this is for that
period. So this was used as a car parking space. I'm on that. Alternative accommodation.
Page 49.
49. Your lordship will find that, Lord. It is second line. It is not a fact that open space on the southern side is used by me as my garage. It is not a fact that we do not give rent to third party for keeping the car in that garage. It is only a temporary arrangement for some day. It was for a year, my lord, that the receipt was granted. Then the floor of the...
Do not give rent, not a fact that double negative.
Yes, sir.
So
After they say that it was given, but on a temporary arrangement.
No, the plaintiff says that they give rent to third party for keeping the car.
It
They
is
give
not a
on
fact
rent.
We do not give rent. I am not too technical on that, but
Give rent to very
not too technical on
temporary
a
arrangement for some.
temporary arrangement of for some day. So they admit that it's given there. That admission. Then the floor of the suit property is below the level of footpath at the entire of 3 feet. So this is their admission as well. So the car doesn't just will not go down. One. Secondly, my lord, they don't have a car. That's also, my lord, an admitted position.
That
they could have shown income tax return. They said that I have
like a
only
business, Mr. Chatterjee, the same principle applies. You need not
have
show that you have a license.
Their plaint is that I want to keep my car. It
Then-
is not
then-
that he wants to
then
use it
buy
as
a
a
car.
business purpose.
No. Business, we try to draw an analogy.
My lord.
For starting a business, if requirement is that, then you need not show you have an existing.
Even
So
the
that
rebuilding part, my lord, also your lordship remember that they will have to show some sort of, my lord,
building will may, but there are.
to do that to
But
whatever.
they need not show that they presently have a car. They can't keep the car. There's no space. That's why they may not
I am
have.
not even on that. But I am saying, my lord, that this is not a garage if it's a 3 feet long, my lord. If it's 3 feet,
So there's a gradient.
cannot be a garage.
How did the
That's-
courts deal with it?
Courts they never dealt with it at all.
Did you raise the point?
It's on record, my lord. Kindly have a look at the appeal court, trial court. Your lordship need not trouble my lord self. Appeal court kindly takes it and then takes up page 15. Second paragraph. The plaintiff respondent filed the lordship's kindly got it.
Yes, got it.
It's a longish paragraph. The learned trial court framed the issue number 5 on this ground. The plaintiff respondents in para 3 of their plaint stated that the family such and such, your lordship may skip over, my lord. For the convenience of them, one family car is very much essential. Lordship again skips over. I'm not on that at all. sketch map is, my lord, considered. Then the size of the room is considered. Then it further appears on the next page. It further appears from point number 2, Lordship's kindly got it, 4 lines from the top. Of the suit below the footpath level, and at the front of the room, there were 5 steps from the pedestrian part to the floor of the room. From point number, that is it. From point number 3 of the report, it appears that the learned commissioner has mentioned therein, I ascertain that no obstruction would be caused for the thoroughfare of a car from the side of the tenanted garage due to construction of the shed. It therefore appears from the report of the learned commissioner that the suit room can be used as a garage. This is the fine.
You also produced DW3, who is an
Yes.
engineer.
My lord.
He said it is not feasible.
It's not feasible, but that the learned judge says that I do not get into that because he was not appointed by the court. This can be taken, my lord, both ways. My lord, I have given a piece of evidence. That evidence they have cross-examined it. The learned judge says that since he was not appointed by the court, I am not giving any credence to that report. So this is where, my lord, I say, my lord, that this is really being used as a ruse to evict me.
It's a ground floor room, Mr. Chatterjee.
It's a ground floor room.
This will be a reappreciation of the facts.
My lord,
This is not perverse.
Appreciation, perversity, my lord, is that if there is a 3 feet gradient, it can never be, my lord, a garage.
It's not
And
proved
they
to be
want it
impossible.
only
I mean,
for garage.
it cannot be said to be impossible.
Lord, your lordship,
They can create a ramp
that
there.
ramp also, my lord, there's a staircase there. That's not their
Staircase
case.
can be demolished and a ramp be created.
Not their case. If it was their case, I would have still
No question
understood.
of the case. I mean, it depends on the plaintiff how they want to use that.
If they want to use it as a garage, then it should be a garage. It is not something, my lord, that a room they want to convert into a garage.
It depends on him how he wants to use.
This
আর অন্যটা আরেকটা কোশ্চেন রয়েছে যে আরেকটা যে টেম্পোরারি রয়েছে কিন্তু সেটা একটা গাড়িকে ভাড়া দিয়েছে টেম্পোরারি ইউজ হচ্ছে Mr. Chatterjee, we are not with you on 2 counts because this, first of all, regarding this space, that the gradient that can be taken care of by certain small engineering jobs. And
I tell you, lordship, why it can't be. That's because, my lord, from the footpath level. From the
yes,
footpath level, if it goes down this way, my lord.
there are so many buildings in Calcutta where it is done. I mean,
with greatest of respect, my lord,
gradients are created.
even that, my lord, is there must be some.
It will be a steep gradient, but there are so many places.
Then the cars do not go down in that fashion.
Go down to basements, yes, much less than 3.
That is a different thing altogether. My lord, I'll show you.
No, from the footpath level, you travel to near the Kakurgachi crossing from your home. On the right hand side, there is a gradient, steep gradient, and it goes down. Cars are parked there.
That's a different. That's to the basement level. This is a room on the side of the, my lord, in our rate by
Level, it is on the level only.
It's on the, my lord, it's on the road. On the road, there is one room. That room, my lord, is below. My
That
lord,
exercise can we do in second appeal? Both the courts have
this is
applied their mind.
Not even considered it.
Yes, trial could also consider.
It's there's from the advocate commissioner's report. He doesn't have any expertise. It is his. My lord, kindly looks to the appellate court judgment. He says from the report of the advocate commissioner, it can be. I think this can be used as a garage.
And regarding the other place which is being space,
No consideration. Nothing.
No, regarding that space, I mean, it's already in use. Although it's a temporary thing, but some other card is being used.
Or it is vacant. Nothing.
It is their choice whom to evict.
Absolutely. There is no consideration to that effect. It's in their possession right now.
No, it's not in their possession
It is in
because
their possession.
they admit in their evidence that it is already rented to somebody else. Although it's temporary.
It was a temporary arrangement at that point of time.
They don't use the past tense.
My lord, that's an open space.
That's an open space. Page 17, appeal court has dealt with it.
Yes, yes.
That alternate, my lord, what my lord
Yes,
said is
yes.
talking about.
Absolutely. But that space, my lord, can be used as a garage.
Let us come to page 17 once, Mr. Chatterjee, because that he deals with that.
Apart from the same, no other alternative accommodation for keeping the car has been shown or suggested. I mean, I go a little up. But an open space cannot be substituted of a covered garage when the plaintiff respondents own, but it is in possession of the defendant appellant. the open space can be used as a parking space temporarily, but it cannot be used as a permanent place for keeping the car. This, I think, Milord, is a little.
In the middle of the page, the another point raised by the defendant appellant that the plaintiffs have enough open space
Yes, Milord.
to
That's
park their car.
That's what I'm.
So an open space cannot be a substitute for a covered space.
Milord, there is a space for parking a car. Now, if you want to convert that room into a garage, I would have still
Court has said that an open space cannot be a substitute of a covered garage.
Milord, that's why I did not even want to, Milord, get into it. I told your Lordship, Milord, the learned judge, probably, Milord, in my respectful submission, that room, if that could be converted into a garage, was not open for the advocate commissioner to find. Milord, if your Lordship sees page 16 once, top, this is his finding. Learned Commissioner has taken measurements of the suit premises. Now, taking measurements is not within the scope of Local Inspection Commission. Yet, from this point, the report, it appears that the length and breadth of the suit room is such and such. But the problem is, if Milord, any room today.
What was point number 2 of the commissioner's? What was the charter of the commissioner? I mean, what was it?
Kindly have a look at page 91, I'm sorry. The length of the room in occupation. But exact charter, Milord, I don't.
2 is not there.
I don't have
point number 2.
It is probably the measurement.
Appears to be so.
Measurement. No, my submission, Milord, is a little different.
The commission's application is not with you.
Application is not with me, Milord. No, my problem is a little different. Milord, my respectful submission is, if they had made out a case that they wanted to convert this room into a garage, the entire adjudicatory process would have been different. But they are saying, Milord, it's a garage. Your Lordship will see everywhere, Milord, room within brackets garage. Milord, now, for a room to be converted into a garage, there needs to be, Milord, some sort of, Milord, evidence before your Lordship that this room can be converted into a garage. Not there. Not there. He says Advocate Commissioner cannot do it. And it is absolutely correct, Milord. The Advocate Commissioner doesn't have the expertise of what would be the gradient, with the gradient, whether the car will go in or not. There are lots of things to see. Milord, I remember once, my father was appointed, Milord, as a special officer to go and see if the car can be, because he knew how to drive, appointed by Justice Banerjee, P.K. Banerjee. If he had to go and see if the car could go into the garage.
You remind me of Justice Basu's comment regarding your car.
Do not.
So if that be the standard, then no space would accommodate. So you are inviting the court to do that.
No.
We can take judicial notice of that comment.
I do not. That comment, Milord, I have said that I will sue him in whichever way I can.
You should.
I will sue him. Especially the person who actually operates the, Milord, so this is where my perversity is. It's a very short premise, Milord. I completely bow down to that. It's on a short premise, but it's interesting. Milord, if your Lordship finds that any room can be converted into anything, a drawing room to a garage, Milord, I am out of court. But for this room to be used as a garage, there is no evidence on record. And you can't use this to evict a tenant who is otherwise, Milord, protected by law. There is no evidence. I can't just come up and say that, look here, I have this space, I will convert this into whatever I like. Cannot. Even the sanction, Milord, has to be shown. Milord, they haven't even shown the documents of title. In a suit for specific performance, they will have to show the document of title.
116 comes in.
By a reasonable requirement, Milord,
reasonable requirement.
I think this is a better point. They said that I'll bring in, Milord, the title deed, but they haven't, Milord, brought the title deed.
Question of title was dealt with.
Yes, the evidence.
Now, how did the court deal with that?
Nothing.
Did you raise the issue of title?
Milord, it was cross-examined. She was cross-examined on that. But rent receipts were she admits that rent receipts were given by the husband, by the grandfather. I was inducted by the Milord, the father-in-law. Those were all gone into. But kindly appreciates this part, Milord, this perversity, that the Advocate Commissioner could not have commented, Milord, that this can be used as a garage. My lord, even under the Kolkata Corporation Act, the sanction has to be given to a garage. The entire sanction plan, my lord, will be based on a garage. So it cannot be converted into something else.
No, Mr. Judge. Tried your level best. It was a very good
Arguable.
point.
That's why
We were in doubt, but no, does not mean it's arguable. We were in doubt.
Under Order 41, my lord, if your lordship is in doubt, is admissible.
Not nowadays, because of the legacy we are carrying due to this. The present second appeal has been preferred against a judgment of affirmance. So both the learned courts below granted a decree of eviction on the ground of reasonable requirement of the plaintiff's respondents.
Lord, may I once try and
Yes.
have a look at it?
যে পর্যন্ত বললাম থাকবে। Yes.
This is the rule.
These are not part of the evidence.
In the Order 26 Rule 9, it was in the appellate court. Lord, may I ask this question to myself if this is a garage?
We won't look into it.
This is a part of the record.
This is not exhibited.
It is a part of the Order 26 Rule 9 in the appellate court. Even the application is there. Kindly be, Lord, very biased after looking into it.
We don't like to be prejudiced. No.
This cannot be used as a garage. This is basically a ruse, Lord, to evict the tenant.
No, both the courts below.
Right.
Push up
This is not bona fide.
The judgment or
No, this is not. This is completely, my lord, if your lordship sees.
They have their armchairs.
They're not even an armchair, even used as a room.
No.
With 3 feet gradient with stairs. As I had said.
No. The suit. The suit room, the suit premises is comprised of a single room on the ground floor of the concerned premises, measuring about 16 feet 9 inches by 8 feet 10 inches, having a height of 7 feet 10 inches, as apparent from the Commissioner's report, which was filed in the court below and annexed to the stay application in connection with the present appeal. So, next para. From the Commissioner's report and from the admission of the plaintiff's witness, it is evident that there is a difference of 3 feet 2 inches between the footpath, which is above the suit room and the suit room itself. Also, at the front of the room, there are 5 steps from the pedestrian pathway to the floor of the room. Learned senior counsel appearing for the appellant argues that it is evident from the above facts that the purported requirement of the plaintiffs is a ruse, RUSE, for obtaining a decree of eviction on the ground of personal requirement, whereas it is not feasible, architecturally or otherwise, to convert the said room into a garage. Next para, it is contended that the steep gradient between the adjacent footpath and the suit room, is itself a deterrent to user of the said room as a garage. Next para, that apart, it is pointed out from the evidence of the plaintiff's witnesses that admittedly there is an open space at the suit building, which is being rented out temporarily to a third party for user as a car parking space. As such, the reasonable requirement ground, it is argued, should also fail on the ground of availability of a suitable alternative accommodation on such count. Apart from the fact that the plaintiffs have not shown to own any car at present, the above factors clearly lead to patent perversity, which is argued to be a substantial question of law for the purpose of admission of a second appeal. Full stop. However, comma, upon a careful perusal of the judgments of the courts below and the documents cited by learned senior counsel for the appellant, comma, including the commissioner's report and the evidence of the parties, comma, we are of the opinion that the ground sought to be raised is at the best a mixed question of law and fact and cannot be labeled outright as a patent or palpable perversity requiring interference by the second appellate court. Full stop. Both the courts below have entered into the question and upon an independent assessment have arrived at findings that the suit room can be used as a garage. Full stop. Next para. The trial court found, comma, inter alia, that the plaintiffs have got the option to make adjustment unless it is shown by the defendant that such adjustments are totally impossible due to some structural constraint. Full stop. That apart, comma, it was found, comma, the suggestion that the plaintiffs can conveniently park car in the open space inside the premises cannot be accepted. Full stop. The learned trial judge further found that the structure of the suit property indicates that the same was built to park car and neither court nor the defendant can suggest that the plaintiffs should park their car in open space and that there is no evidence as to the incapacity of the plaintiffs to buy a car or maintain the same. Full stop. The learned first appellate judge found on the said issue that although it appears from the commissioner's report that the floor of the suit room is 3 feet 2 inches below the footpath level and at the front of the room there are 5 steps from the pedestrian path to the floor of the room, comma, the commissioner also mentioned that he ascertained that no obstruction would be caused for thoroughfare of a car from the road to the tenanted room within bracket garage due to construction of the shed. Full stop. It was found by the appellate court, first appellate court, that it appears from the report of the learned commissioner that the suit room can be used as a garage. Full stop. The first appellate court also took into account that an open space cannot be a substitute of a covered garage, comma, which the plaintiff stroke respondents own, but is in the possession of the defendant stroke appellant. Full stop. The open space, comma, it was found, comma, can be used as a parking space temporarily, but cannot be used as a permanent place for keeping the car. Full stop. Next para. We do not find any reason for interference with the concurrent findings of fact by both the courts below on such count. Full stop. First, comma, it is well settled that the court has to sit in the armchair of the plaintiff, of the landlord while assessing the requirement for a premises. Full stop. Secondly, comma, by use of certain small architectural measures such as creation of a ramp to cover the gradient upon removal of the staircase, comma, it is not altogether impossible to use the suit room as a garage. Full stop. Next para. In fact, comma, the second appellate court does not have even the liberty to enter into such factual aspect of the matter in the teeth of the concurrent finding of fact of both the courts below. Full stop. Insofar as the availability of an alternative open space is concerned, comma, we are ad idem with the opinion of the learned first appellate court that the open space cannot be a substitute for a covered garage. Full stop. The argument of the appellant that the plaintiffs had not prayed for eviction on the ground of rebuilding does not hold good, since the mere change of gradient is not of such a stature that the plaintiff had to specifically take a ground of building and rebuilding, comma, for the purpose of conversion of the room to a garage. Full stop. Next para. As such, comma, in view of the above findings, comma, we are of the view that no substantial question of law has been made out by the appellants sufficient to admit the present second appeal. Full stop. Accordingly, SAT 208 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, can one of 2024 stands dismissed as well. No orders to cost. Is the correction? Yes, thank you.
But just the corrections he made.
Yes, that is what. Thank you. একটু correction করে দেবেন উনি ওই
Item number 25, my lord, I'm appealing for the appeal.
Yes. 25 বোর্ডে দেখাতে হবে হ্যাঁ give us half a second. যে এনেছে তাকে দিয়ে আবার পাঠিয়ে দিন yes yes please.
Yes, my lord, on the last occasion, your lordship directed to correct memorandum of the appeal.
First name of plaintiff 1B. Oh no, that has to be transferred. Deficit court fee has been put in beyond limitation.
Not beyond limitation, my lord.
That is the app.
Yes,
we accept that. We'll accept that. What are the other defects? Let us just check up. One of the corrections has to be effected by sending it down to the trial court, so that we can do later. And we'll hear you now, and we'll accept the deficit court use first.
As you lord.
We find from the office report that the deficit court fees have been put in by the appellant beyond the period of limitation, full stop. On the oral prayer of learned counsel for the appellant, comma, we condone the delay in putting in such deficit court fees and accept the same. Full stop. The defect in that regard is deemed to stand cured, full stop. Insofar as the transmission, as the required transmission of the certified copy of the impugned degree of the trial court to the said court is concerned, comma, the same shall be done after the matter is heard under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Accordingly, we take up the appeal for admission hearing. Yes.
Yes, my lord. The fact is that this is a case of the eviction of trespasser, but I am the son of the actual tenant.
2G.
2G.
Affirmance. Both the courts.
No, the learned code, this learned code below has not affirmed it, but
there was a restoration application allowed.
Restoration of yes, allowed. This is 2G, my lord,
2G,
and
yes.
And my lord.
For 1 second. When was the restoration allowed? Do you have any idea? Our orders are nowadays kept very in a slipshod fashion.
4th March 2024.
4th March it was.
Right. Sorry for disturbing you twice.
No, my lord.
Yes, 2G, right.
Yes, my lord, 2G.
So this is a 2G scam.
This is a 2G scam, my lord.
Yes.
The scam is that, my lord, the I was
trial court dismiss the suit.
Trial court not dismiss the suit, allowed the suit.
You are the plaintiff.
No. I am the defendant.
Then how is it a judgment of reversal then? The trial court
dismissed the suit.
That is what we
the trial court dismissed the suit, allowed us, and
why did the trial court dismiss?
The trial court dismissed the suit on the ground that the landlords had not shown their true title before the learned trial court.
How did the appeal court deal with that?
Appeal court dealt that is not required at all, because I have admitted that they are my landlord.
116 of Evidence Act comes.
116 of evidence.
So what is your argument on
my argument is simple, that before filing the suit, there was a previous suit where I have been admitted as a tenant. Then suit was taken away, withdrawn on a technical ground, not citing that there is technical mistakes, not citing any reason except that this is a technical mistake.
But then there was no conclusive adjudication if it was withdrawn.
It was withdrawn, no
Could not-
conclusive
there
adjudication.
was-
My
it's
point
not
is,
barred by res judicata.
it's
It is withdrawn.
they have admitted that I was a tenant. Now, after I became a trespasser, on that point of time, I was a trespasser. 2G scam.
You were there or your father was there then?
My father actually was a tenant. Thereafter, they have admitted me as a tenant. Thereafter, they have filed a suit for eviction. Thereafter, they have withdrawn the suit. Now they have, after that, they have filed another suit declaring me as a trespasser under 2G.
When did your father die?
My father died in 2009.
You are not a dependent of your father.
I was the defendant at the point of time.
Now you are not.
Now I am not. That is the point.
So then there cannot be any extrapolation against the law. The facts are admitted.
Facts are admitted, my lord. I know that. Your lordship has also another judgment. I have consulted that. I could not find it. But the fact remains that this is a mischief they have done. That is all.
This is a mischief which the Act has done.
Act has done.
But it was a protection. So it's a withdrawal of the protection to a limited extent.
Yes,
You cannot say exactly it's a mischief of the statute.
I'm not telling the mischief about the statute. I'm telling the mischief of the landlord, my lord.
Landlord depends on the perspective. To you, they are mischievous and vice versa. No ground substantial question. Sorry. The present second appeal has been preferred against the judgment of reversal. First of the learned trial judge dismissed a suit for eviction of the appellants on the ground that the appellants are trespassers by operation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997 on the demise of the appellant's father, the original tenant. First up, the dismissal by the trial court was primarily on the ground that the plaintiff's respondents have not proved their title in respect of the property. Full stop. Next para, the appellate court, comma, while reversing the judgment and decree of the trial court, comma, arrived at the finding that since the landlord-tenant relationship between the parties has been admitted by the appellants themselves, comma, the appellants cannot now resile from such position and are stopped from challenging such relationship. So next para, learned counsel appearing for the appellants submits that the appellants do not come within the mischief of section 2 within bracket small g of the West Bengal Premises. What was your argument? Sorry, that why don't you come within the mischief?
Because when I was admitted as a tenant.
Previous suit, right?
Previous suit.
Come within the mischief of section 2 within bracket G of the 1997 Act. First up, in support of such contention, comma, learned counsel places reliance on the alleged admission by the plaintiff's respondents in a previous suit for eviction against the appellants, comma, where it had been admitted that the appellants are tenants in respect of the property. Full stop. Next para, it is contended by the appellants that in the teeth of such admission that the appellants are tenants, comma, the plaintiff's respondents were stopped from disputing such tenancy rights. Full stop. Next para, however, comma, we find that the question as to whether we find that the factual aspects of the matter regarding the date of death of the original tenant and the other factual considerations for applicability of section 2 within bracket small g are not disputed here. Full stop. Even if we proceed on the premise that the plaintiffs, comma, in a previous suit which was withdrawn later, comma, had admitted the appellants to be tenants in respect of the suit premises, comma, the appellants have been rendered to be trespassers by virtue of operation of law, that is section 2 within bracket small g of the 1997 Act. Full stop. It is trite law that there cannot be any estoppel against the statute. Full stop. As such, comma, the mere filing of a previous suit on the ground of tenancy of the appellants, comma, which was withdrawn later without any adjudication on such count by any competent civil court, comma, cannot operate as a bar to applicability of section 2 within bracket small g of the 1997 Act to the appellants. Full stop. Thus, comma, we find that no substantial error of law has been committed by the learned first appellate court, comma, nor has any substantial question of law been made out by the appellants for admission of the appeal. Full stop. Accordingly, SAT number 254 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2024 is also dismissed accordingly. No address to cost. Sorry. Next. Mr. Ghosh, you are there. Yes.
Lord, judgment of affirmance. Suit for declaration.
Deficit code fee 100. Let us check up whether we'll just check up if it is there. Paid. Sorry.
Yes.
Judgment of affirmance, yes.
Suit for declaration that the plaintiff is the sole owner of the suit property is co-scheduled property.
You are the defendant.
I'm the defendant. Co-scheduled property is the owner, and Co-1 and Co-2 scheduled property have been enclosed by the defendant.
Co-1 and 2 are part of Co.
Part of Co. Lord, first you will have to establish that he is the owner of Co-1's co-scheduled property. Lord, and defendant has also purchased another adjacent DAG number that is from sister. And what it is, plaintiff's claim is on the basis of a deed of partition among 4 brothers who inherited the said property from their mother.
What about the sister?
Lord, sister, another plot, sister was gifted that plot by the mother. No concern with this plot. Your Lordship, kindly see, both the courts below have held that plaintiff has established his title in respect of the co-scheduled property, and especially when an advocate when a expert commissioner was appointed to survey the plot, he has found that the defendant is possession of more than the property he acquired by purchase from the sister. He acquired 2 decimals, and it appears that
therefore encroachment.
Therefore encroachment. Lord, so far the commissioner's other aspect of the report is that upon measurement he found that almost the area claimed by the plaintiff is there. Solely on the basis of, Lord, the excess area found after measurement of the in respect of the defendant's property, suit has been declared. But Lord, neither the trial court nor the appellate court has found Exhibit 9, which is the base of the claim of the plaintiff. Exhibit 9, Lord, kindly see the plain schedule, your Lordship, kindly see the trial court has stated. Lord, your Lordship, kindly come to the trial court judgment first.
Yes.
Lord, at page 3 of the trial court.
Yes.
Lord, co-scheduled property, your Lordship, get, Lord.
Yes.
In dispute, the dispute is regard to the following schedule as mentioned in the plaint. Schedule co, such and such. Lord, total area 3 decimals. Lord, got it?
Got it, yes.
Lord, next, Lord, the encroachment portion Co-1 and Co-2, the measurements have been given.
Yes.
And Lord, therefore, defendant's property is co-schedule. Lord, your Lordship will get it total area, co-schedule 3 decimals, Co-1, 1 decimal left, and Co-2 is the actual property purchased by the defendant.
Yes.
Lord, Co-2 schedule is 2 cents, 2 decimals. Now, Lord, your Lordship, kindly see the learned trial court has held your Lordship, kindly come to page 6. Second paragraph.
Yes.
Third paragraph. The suit has been instituted for declaration of plaintiff's absolute right, title, and interest over Co-1 and Co-2 scheduled property, and the decree of mandatory injunction along with first possession over Co-2 scheduled property by permanently restraining the defendant from disturbing the peaceful possession of the plaintiff over the same. and the court does not find that this suit is barred by section 34. Under section 34 of procedural, no argument has been raised on this point. Lord, kindly now, Lord, at the bottom paragraph, your Lordship will get that in this respect, it is pertinent to say that necessary party is a party who ought to have been joined in the such and such. I am not skipping over. Now, Lord, your Lordship kindly see the learned advocate for the defendant, while arguing, categorically agitated on the point that the plaintiff filed this suit only against Bharati Chatterjee, while it is evident that the plaintiff's own document are the evidence. Exhibit 9, certified copy of the partition deed for the year such and such, the property mentioned in the co of the plaintiff is duly demarcated, which the plaintiff got by way of partition deed along with other sons. Lord, your Lordship kindly see once the partition deed, which is exhibit 9.
Along with other non-suit property.
Non-suit property.
Yes.
Yes. Lord, your Lordship kindly see the partition deed. Lord, my learned friend should have annexed it with the stay petition. He has not done it. Your Lordship will get in the partition suit. There are 4 schedules for 4 brothers. Lord, Gha schedule was allotted to the plaintiff. Lord, plaintiff's name, your Lordship will get that the plaintiff.
We don't have a copy of that.
Is Suchit Kumar Sandhal.
We don't have a copy of that partition deed.
Lord?
We don't have a copy of that.
Yes, yes.
One copy won't do, Mr.
Lord,
Ghosh.
that is the difficulty, your Lordship. I can say, but and it is difficulty, but it is Bengali. Lord, I have to
No, even then, if it's printed, Justice Kumar can follow.
Oh, then Lord, if your Lordship so direct, I can beat him. Here, Lord, the question is that he has only got out of 3 decimals that has not been read at all. Lord, I am reading for your Lordship.
Yes, read out, please.
Lord, Lord, here, Gha schedule property, which is the allotment of the plaintiff, that is the number 5631, বাস্তু মোট 3 শতক মাই তদুপরিস্থিত যাবতীয় গঠনাদি ও তলস্থ জায়গা যাহা নকশায় তুঁতে রং দ্বারা রঞ্জিত ও প্রদর্শিত স্থান হইতেছে যাহার পরিমাণ 1.58 শতক out of 3 1.58 but he based his claim on the partition 3 শতক and on that basis everything has been done by both the courts below. And my defense is that if I
did you raise the point in the appellate court?
Lord,
did you raise this point in the appellate
court? Is that this is the deed.
Did you raise the point before the appellate court? It had to be raised.
This question, Lord, this is
the factual question. This is not a question of law.
Lord, his claim is based on this deed.
We are asking you, did you raise this question ever?
Lord,
before any court?
It has not been dealt with, but it
but
has
the
been
first time can the appellate court look into a factual question? This is not a question of law. If it's a pure question of law, you can raise it for the first time.
It is a,
they had to have notice of this. They could have dealt with this in the courts. This is you're trying to interpret a deed. That deed was an exhibit in the courts below.
It is their
deed.
Could
have raised this point.
It is their deed. And
their deed, Mr. Ghosh.
But
But
deed has
if you
not
did
been
not
interpreted. Deed shows that it is out of 3 decimals 1.58.
It's a factual question of interpretation of the. This is not a legal interpretation of the deed.
Yes,
This is a pure factual question of how much property they acquired. Yes. If you did not raise this point in either of the courts below, why should the appeal court, second appellate court give
in the written statement you have stated.
You should have argued that. Written statements, many things are stated.
And not evidence also.
You had to raise in argument, show us that you have raised this question before either of the courts. They cannot be taken by surprise for the first time before the appellate court, unless it's a pure question of law. This is not a pure question of law. We have to look into a particular document and see what is the actual measurement.
When the basis of his case goes, on the basis of his document, which has
let us see that document once. Internet. Suchit Kumar Sandhal. Suchit Kumar Sandhal পেজে হচ্ছে সুচিত কুমার এখানে রয়েছে। হ্যাঁ, চতুর্থ পক্ষ। আচ্ছা, চতুর্থ পক্ষ কি দিল দেখি একবার। পার্ট ডি, নকশার পার্ট ডি, খ তপশিলে লিখিত, আচ্ছা, খ তপশিল হচ্ছে এইটা, না, ক না, গ হয়, খ হচ্ছে এইটা। খ, না, ওর খ আলাদা হবে, ওর খটা আলাদা, এটা কিন্তু কটার সময় এটা লিখতে হবে। এখানে 3 ডেসিমাল লিখেছে, টোটাল 3 ডেসিমাল। হ্যাঁ 3 ডেসিমাল, আর এখানে খ, এটা হচ্ছে পার্টিশন ডিড যেটাও পেয়েছিল, সেটা কোথাটা পাচ্ছিল। Of the co-schedule property in the plane.
Yes, kindly see the co-schedule. On the basis of this partition deed.
Paint কেসটা দেখে নিয়ে একবার, পেন্ট কেসটা তপশিল বর্ণিত সম্পত্তিতে একাই 1 আনা অংশের মালিক হয়েছে। অতপশিল, অতপশিলটা ডিসক্রাইব করছে 3 ডেসিমাল, 3 কটা হচ্ছে এই কণা, এই কণা।
Noksa has not been provided. But this is the commissioner's report, not commissioner's, survey commissioner's report. He also says that the co-schedule property has according to measurements, it is 3 decimals.
3 decimals. Therefore, the commissioner report says it's 3 decimals.
No, he has not got any encroachment from co-schedule, but he says that I am in possession of more than 2 decimals. On that basis, it has been decided. In the trial court also, that has been upheld by the trial court.
No, if the commissioner report says that co-schedule comprises of 3 decimals,
yes,
then where is the dispute?
There is no dispute.
No, no.
Cause schedule as described in the plaint. In plaint description, cause schedule is 3 decimals.
3 decimals.
But in fact, it is 1.58. In fact, it is part of 3 decimals. And not from the partition deed,
Commissioner's report says that it is less than 3.
it is almost 3.
Then,
but that is not, it will, from the partition deed, it will appear that said particular plots, other portions have been allotted to other persons.
partition deed says regarding this plot,
Yes.
মোট 3.03 শতক 3 দশক মধ্যে মায় তদপরিস্থিত যাবতীয় গঠনাদি ও তলস্থ জায়গা যাহা নকশায় তুতে রং দ্বারা রঞ্জিত ও প্রদর্শিত স্থান হইতেছে
পরিমাণ 1 point such and such out of 3.
আচ্ছা,
it is clear. And not that rest of the 3 that has been allotted to other allottees. From commissioners, from the report, from the partition deed itself, it will appear.
he also sought a declaration. The declaration has been given that
Yes. He is the owner.
You have to give a copy of this right now.
I am giving. Yes.
The present second appeal shall be heard on the following substantial question of law. Whether both the courts below committed a patent perversity in misreading Exhibit 9, the partition deed, which was the plinth of the claim of title of the plaintiff respondent, inasmuch as by virtue of the said deed, a property worth only 1.58 decimals was given to the plaintiffs, whereas the declaration granted by the courts below is in consonance of 3 decimals, is in regard to 3 decimals as per the cause schedule of the plaint, which creates a variance between the title deed and the suit property. Any interlocutory application?
Yes. Can one?
No caveat?
No caveat. No caveat. Execution case 2 of 2023.
In view of the second appeal having been admitted on a substantial question of law, the appellants have a strong prima facie, the appellant has a strong prima facie case for hearing of the second appeal on merit. First up, accordingly, there shall be stay of all further proceedings in title execution case number 12.
2 of 22.
1 has been inserted.
12. Mr. Banerjee, 12. Execution 12. Here, 12, 2.
Mr. Banerjee doesn't know, you check up.
Lord, it is 2. 2 of 20.
এটা একটু দিন।
Lord, here, Lord, execution application 12.
Mr. Ghosh.
Yes, not 12.
No, that is us.
Lord, in the body it has been written 12.
Yes.
But my
stay of all further proceedings in title execution case number 12 of 2023 pending before the same court, Civil Judge Junior Division, Kalna. Pending before the learned Civil Judge Junior Division, Kalna, District Purbo Bardhaman, till disposal of the application. First of the appellant shall serve a copy of the application on the plaintiff respondent, indicating that the same shall be listed next before the appropriate learned single judge having determination. First up, the appellant shall file an affidavit of service to that effect when the stay application is next called on for hearing. It's of liberty to the parties to mention the matter before the learned single judge, then having determination. Yes. Acta line add kore a copy of Exhibit 9, handed over by learned senior counsel appearing for the appellant today in court, as well as the plaint of the suit, be kept on record. Please immediately ask your learned junior to take out photocopies, ask his clerk to take out photocopies. Both the documents, you have to personally take responsibility for putting these on record. Yes.
Mala, I'm applying for the Mala appellate
27.
27 Mala. I'm filing
Yes.
this affidavit of
What is the defect?
service.
There is a defect.
Defect is Mala the
Affidavit is service of what?
caveator Mala.
Caveator.
Mala full cost title of the appellants and respondents.
In absence of
even
full
also
cost title of impugned degree of the referee, the names of the parties.
the report of the stamp report
Oh,
is correct Mala.
we have to send it down to the trial court for that. But let us hear the order 41. What is, let us see the degree first. Wait a minute. Title suit is of 1959. No, full cost title is not there.
Yes, full cost title, even valuation of the appeal and also cost of the appeal.
Do you have a copy of the plaint?
Yes, Mala. I have furnished in the stay application.
It's annexed to the stay application.
Yes.
Valuation will be evident from the plaint.
Yes, Mala. It's 400.
You have evaluated the appeal according to the plaint.
Yes, I have.
No, in the plaint also there is no valuation statement. Oh, sorry, this is something else. Where is the plaint? Which page?
At page 26. And type page at page 37. Type page at page 37.
Yes, you have correctly well. So we'll send it down to the court below for that correction.
Yes.
But move the appeal first. Yes. You are the
the
defendants.
No, I have plaintiff appellants.
What was the suit for?
Suit for my lord, title of adverse position and confirmation of position and injunction.
Title by adverse person.
Title of adverse.
You lost in both the courts below.
Yes, my lord. But on the ground, my lord.
What is the substantial question of law in adverse person?
No, but the plaintiff, my lord, purchased the land in the year 2000.
But then adverse person could not be used as a sword also in 1959.
No, in the year 1955, the defendant first time claimed that he dig the pond, so the pond is possession since 1935 by way of dakhila and document of settlement possession.
Your claim of title is by virtue of adverse person.
Yes, my lord. Only the plea, my lord, since the pond was not described in the deed, so the defendant denied that the pond is in favor of the defendant since 1935. But according
Defendant is claiming by adverse person, or you are claiming by adverse person?
I am claiming that if he became the owner, so I since 1935 to 1955, the defendant was silent. At the first in the 1955, for the first time, he claims that the pond is in favor of the defendant.
So the trial court, appeal court relied on a Supreme Court judgment which says if the land is submerged, there could not be continuance of possession.
But in the deposition, my lord,
Page 5 of the appeal court judgment.
Yes.
Here it is not submerged, it's a tank.
Yes, tank. This is tank. But tank was not mentioned in the deed. The defendant.
No, in respect of a tank,
yes,
or a submerged land, Supreme Court had held that there cannot be any claim of adverse possession during the period of submergence. That was relied on by the appellate court and held that therefore there cannot be an adverse possession plea in respect of a pond. How do you deal with that?
Accordingly, my lord, when the plaintiff purchased the homestead land, their total land is 1 bigha 7 katas. But they did not deny that this pond beyond the area of the 1 bigha 7 katas. The dependent did not deny. So only the measurement was there, but both the sides remain silent.
No, you say that the pond, the suit property is only a pond.
No, suit property with the homestead, 3 mud walls, including tile shed rooms.
Yes.
Within the area of 1 bigha 7 katas, but in this deed, pond was not mentioned. And the defendant took plea that he is the owner of the pond by way of payment of dakhila and showing the possession.
So you are relying on a title deed then?
Yes, I am relying on the title. I have already annexed. And
if you rely on a title deed, how can there be adverse person?
But because since
these are contradictory, please.
Yes, since the pond was not mentioned in the deed, but the defendant claimed that he is the owner. So in the year 1955, but I am in possession by virtue of deed since 1935. That is why
you cannot be simultaneously by virtue, in possession by virtue of a deed and by way of adverse person. If you say adverse person,
so not claimed on the basis of the deed, since he, but possession, but the plaintiff, as the pond was not mentioned in the deed, but by virtue of the deed.
What is the suit property? The suit property is a homestead land?
No, only pond.
That is what we said, that only the pond is the suit property.
Pond is the suit property.
So you say that you have title regarding the rest of the homestead, but the pond was not mentioned in the deed.
Yes.
Understood.
But pond is in possession since 1935.
What proof did you, the date of commencement, it was openly, who is the true owner of that? Who is the true owner of the land, of the pond?
Since the pond was not mentioned, I cannot claim the true owner. But
if you cannot mention the true owner, there cannot be a plea of adverse person. Adverse person has to be pleaded against the true owner of the land.
Yes, but
it's a prerequisite.
But if the defendant is the, since that defendant claims the true owner, so automatically the plaintiff being compelled file the suit for adverse possession, and Malakali say first at the only main deposition, for the time being.
No, let us see the judgments of the courts below first. Plaintiff purchase and you have shown nothing to prove your position. Rather, the defendants have been paying khajna and rents and recorded their names also.
But I have also the documents which was exhibited already destroyed before the learned court below.
What did you exhibit by way of your position to prove your position?
The payment of dakhila, the same jomindar of the defendant and also the vendor of the plaintiff. I have also furnished the order.
For which period?
Since before 1934.
No, the trial court finds that it is also a fact that since 1935, that is after sale, the plaintiffs did not pay any rent to anybody else. So apparently the entire property was sold to you. The intention was also to sell the pond.
Yes.
But the pond was not included in the sale deed.
Sale.
Therefore, that pond was outside the purview of the sale deed. You say, but automatically that does not entitle you to adverse possession of that pond.
But since
You have said since 1935, you say you are in possession, but trial court finds that since 1935, that is after sale, you did not pay rent to anybody else. On the other hand, the defendants are paying rents in respect of the suit pond since the time of the then zamindar up to this date.
No, the vendor of the plaintiff paid was the thikapoja of the jomindar of the same, and then the vendor of the plaintiff sold the land to the plaintiff.
But the defendant has been continuing to pay the rent
at that point of time.
After 1935 till date. That is the finding of the trial court.
First time he shows in the 1955.
And you show from when to when?
Well, I'm saying that from the deed, my lord, deed itself, 1935.
Deed is a transfer deed accepting the pond.
Yes, my lord.
So from that, how can you show your position regarding the pond? Your case is that the intention was that the pond along with the homestead will be sold to you. But when the deed is executed, the pond is not there. Therefore, the entire homestead minus the pond is sold to you. Pond is sold to you. Pond is only subject matter of the suit. So the pond was never sold to you. After that sale deed, despite the pond not finding place in the sale deed, you did not pay rent regarding the pond or produce any document to show that you are in possession of the pond. Your title deed does not refer to the pond. So how can that be a basis of your adverse possession regarding the pond?
In the can you see the written statement, particular page?
No, we are at the judgment, on the judgment. The appellate court, let us see what the appellate court says. The same confusion occurred before the appellate court. Appellate court says you are yourself confused. You rely on a title deed which does not include the pond and say that I am in adverse possession of the pond. What other document did you produce? What exhibits did you make? What were your exhibits? Let us find from the trial court judgment. Exhibits have not been mentioned specifically in the trial court judgment.
No.
Dependents filed dakhilas all along to prove their payment of rent regarding the pond.
At page 8 of the trial court, learned trial.
In your suit, you have prayed for recovery of possession if you are not found to be in possession.
No, I am not filed.
Come to page 4 of the appeal court.
The learned advocate for the appellate submitted that in the suit they have prayed for recovery for possession. Also,
Read it out in the microphone.
The learned advocate for the appellants submitted that in the suit they have prayed for recovery of possession also if they are found to be in possession.
Not to be in possession.
He also argued that it is the case of the respondent Nibar Chandra Pal was evicted by the Jomindar due to area of rent, and as such the respondents are to establish their claim. According to him, tank was within the vastu comprised in the suit cause schedule property. He also contended.
Your first prayer in the plaint is নালিশি খ সম্পত্তিতে তপশিল সম্পত্তিতে বাদীর খরিদা এবং অ্যাডভার্স পজিশন সত্ত্বীয় দখল ও ক তপশিলের অন্তর্গত সম্পত্তি সত্য সাব্যস্ত পূর্বক উহাতে বাদীর দখল কায়েম অন্যথায় উহাতে 1 নম্বর প্রতিবাদীর দখল থাকা প্রকাশ পাইলে তাহার দখল উচ্ছেদে তাহাতে বাদীকে খাস দখল দিবার পক্ষে বিহিত আদেশ দিতে। So you claim title on the basis of deed and adverse possession, and alternatively if you are not found in possession then recovery of possession. And this appeal is, this suit is litigation is pending. They are litigating from 1959 on this suit.
But in the written statement,
Written statement, what will the written statement do? You fail on your own case?
No, at page 57 regarding the adverse position, my lord, a dispute was arises when the defendants attempt to dig the pond in the year 1955. And in the written statement, my lord, at page 56,
Yes.
I will not take the time. At page 56,
56.
Para 10, last 4 line.
Yes.
নালিশি পুষ্করিণী এই বিবাদী দ্বাদশ
Page 56.
Yes, 56 of the stay application.
11, para 11 of the written statement. In our
para
copy.
10.
After para 10, yes.
Last 4 lines, my lord.
Yes, নালিশি পুষ্করিণী
এই বিবাদী দ্বাদশ বৎসরের বহু ঊর্ধ্বকাল যে শ্রী গলস্টন সাহেবের নিকট হইতে বন্দোবস্ত লইয়া তাতে মৎস্যাদি উৎপাদনের ও পাড়ের বৃক্ষাদি রোপণ ও ফল আহরণ ও
They have also claimed adverse possession.
পুষ্করিণী সংস্কারাদি করিয়া ভগবান.
So adverse possession versus adverse possession cancels out, you get nothing.
But in the deposition, my lord, Kalisi at page
Both sides.
116.
And we had the impression that previously plaints were so solid, precise, golden times. Now that myth is destroyed totally. Nowadays plaints are much better. You claim adverse possession as well as title by virtue of deed, alternatively recovery of possession. What else? You did not claim a divorce only in respect of the suit property. Apart from that, every other remedy has been sought. We will divorce you from the suit property right now. We are affirming the judgment. The present second appeal arises against the The present second appeal arises against the judgment of affirmance. Full stop. The plaintiff / appellant filed the suit for peculiarly contradictory reliefs. Full stop. In the same breath, comma, in the first relief sought in the plaint, comma, the plaintiff appellant, the original plaintiff / appellant, sought a declaration of title on the basis of a title deed as well as adverse possession, comma, alternatively recovery of possession from the defendant in the event the plaintiff was found not to be in possession. Full stop. The appellate court categorically held that the plaintiff was not sure as to whether he was claiming title on the basis of title deed or adverse possession. Also, comma, the both the courts below arrived at a finding that whereas the plaintiff appellant failed to prove possession in respect of the suit pond, comma, the defendant produced rent receipts and other documents, comma, which are exhibited in the suit, comma, to show the possession and payment of rent by the defendant in respect of the suit pond all along. Full stop. Next para. Upon a careful perusal of the judgments and decrees of both the courts below, comma, we are of the opinion that there is no scope of interference with such concurrent findings of the courts below, comma, nor was there any error, comma, either factual or legal on the part of the courts below while arriving at such findings. Full stop. Hence, comma, since no substantial question of law is disclosed, comma, SAT 60 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 stands dismissed as well. No address to cause. প্রথমেই affidavit of service filed to be kept on record করে বাপের জন্য মেরাম সুদ দেবেন বলছি and adverse person alternatively recovery person adverse person এর সুটে কেউ recovery person চায় 4-5 অক্ষরে ফেলা গেল হ্যাঁ ও আচ্ছা আচ্ছা থ্যাংক ইউ দেখে নিচ্ছি appeal not maintainable in this court 64,700 receipt code you should have checked up you do civil matters
Yes, Milord.
that is the and we find that
that's
also
the reason, Milord, it's appearing as defective, Milord.
right so we'll dismiss the appeal as not maintainable on the ground of pecuniary jurisdiction no this is the second yes even no FMAT acha, acha.
FMAT, Milord, from
what is the impugned order
from Order 7, Rule 11, Milord.
no that should have been registered as a regular appeal first appeal in this court but in any event since it is not we would spare you the agony although the appeal should have been classified as a regular first appeal comma since it arises against a deemed decree of rejection of plaint comma since the appeal comma in any event comma is not maintainable in this court due to lack of jurisdiction and lack of pecuniary jurisdiction comma FMAT 90 of 2025 is dismissed for lack of pecuniary jurisdiction with liberty to the appellants to prefer an appropriate appeal before the competent court having jurisdiction. Full stop. The learned advocate on record for the appellant is granted leave to take back the certified copy of the impugned deemed decree upon furnishing a photocopy of the same for the records. There is no connected application. No address to cost. You will take back the certified copy from the department. We'll send it down upon furnishing a photocopy.
Much obliged.
So that you can file that appeal. Yes.
May I please, Your Lordship?
Yes, Mr. Vanand.
Lordship, the appellant herein is an owner of a godown at 17 Zakaria Street.
This is against what?
Against a grant of a ad interim injunction, ex parte ad interim injunction. Now, let me tell you, Your Lordship.
You're obviously the defendant.
I am the defendant in the plate. Now, what has been done, Your Lordship? The legal points are that suppression of material fact. There is an arbitration clause suppressing that suit filed ex parte ad interim.
Then your remedy is in 39(4).
No, Lordship, I will also see that I will also say that the ad interim order has also been passed in violation of the principles of Order 3. Why I say so? Let me tell you, Lordship, these short facts. Then I will come to the point of law. The appellant is the owner of a property at 17 Zakaria Street. He had a godown. He was looking for inducting of tenants so that it can be used for commercial purpose. An agreement was entered into, which has been suppressed by my learned friend in this suit, where he was appointed as the agent. His duty was to find out tenants for me so that they can occupy and carry on business from the godown.
Registered part of attorney?
No, agreement. Only an agreement. And Lordship, the second obligation was that he will repair and renovate the godown, and thereafter he will hand it over to a proposed tenant, which he will find out for me. Now that agreement contained an arbitration clause saying that if there are any disputes arising out of between the parties, the matter will be referred to arbitration. Now, Lordship, the period for finding out the tenants was within 9 months. Agreement is of 2019. That 9 months expired on July 2020. Now he could not find out any tenant within that. He went on occupying the godown.
Oh, why is Mr. Bishwarup Bhattacharya disturbing the court?
No, he's leading me. I thought he's not appearing today. He's in Delhi. He's leading me in the matter. Sorry, very sorry. Sorry, Mr. Bhattacharya. I thought he will not appear. That's why. I'm very sorry, Mr. Bhattacharya.
Yes, Mr. Bhattacharya, you are audible despite you being muted. Yes.
No, very sorry.
Although your microphone was muted, we could hear you. So just imagine. Yes, what is the matter, Mr. Bhattacharya?
I'm very sorry that he's
Zakaria Street, what happened?
Mr. Banerjee is there to assist. The matter is Mr.
So even then, if you have to earn a fee, you have to
there to
prepare
assist
yourself.
your lordship. I was only tempted to make this one.
Make this what? You're
The
already
only predicament is if it can be taken up tomorrow morning, that is the only that I was making. Otherwise, let Mr. Banerjee make his submissions.
I am make his submission. We'll waste our time. This is not a Saturday evening sort of thing.
Lordship, I'm very
We'll
sorry.
make his submission. We'll keep it Monday for you to come.
No.
Just because
no,
you're in
I have
Delhi,
never
Mr.
said that.
Bhattacharya.
Well, I have not said that. Let him make submissions.
We are saying that.
Let him make his
Properly instructed,
submissions.
very sorry to start the
Your
matter.
Lordship will not kindly adjourn it.
Extremely
We'll
sorry.
take it up tomorrow. We'll take
Well,
it
he
up
has
tomorrow.
started the matter. Let him make submissions.
No. This is not a race course. He'll start and he'll finish and all these things.
Tomorrow also some
Tomorrow you'll learn
No.
the adversary has some difficulty, so therefore come back day after tomorrow.
Lordship,
Day after tomorrow will be
Thursday.
Will be decided.
very convenient for us because we take up appeal hearing matters first.
What I say, actually, I'll be traveling. Lordship, can you take up next Tuesday, no, Wednesday?
Next Wednesday. Caveat.
Fact is that I'm suffering an interim order in the sense.
That only 1 month.
Suffer till next Wednesday.
What your Lordship is
They're already suffering in the hands of
Order
Mr. Bhattacharya.
39.
Let the
I
matter be
also
taken up
for
today.
appeal under order 40. That I can also come up. Under order 40.
Kindly takes the matter. Kindly takes the matter now. Kindly takes the matter now. Mr. Banerjee is there to assist your Lordship. I am there.
Very well. Then they will continue.
If you,
Yes.
Mr. Banerjee is making submissions.
Yes. Thanks for your magnanimity. Please keep your mouth shut then. If Mr. Banerjee has to argue, you have to keep mum.
If I falter, then kindly allow.
If he falters, then text him. Yes, Mr. Banerjee.
Yes, Lordship, what happened thereafter within the period
Text
of,
is Leonard Junior actually. Yes.
within the period
Zakaria Street, agreement.
9 months he has
purposes,
failed.
he is
9
to
months
repair and give
repair
to
and
tenant.
induct a tenant. Now he
9
has
months
failed.
passed over.
9 months passed, he's
Then
failed
what
in his duty. Now what he's doing, he's using my godown for storing his goods. He's running a restaurant from the adjacent property.
Very good.
He's storing his godown, combustible articles, everything, cylinders, everything. Now the property is under threat of being exploded. Your Lordship will show the clause from the agreement that any proposed tenant is injuncted from storing any goods. Now, Lordship, what has happened in the meantime? A suit has been filed alleging that I am trying to dispossess him from the property. Now he has filed a suit saying that declare me as a lawful occupier when the agreement does not give him any right of occupation. It's only for
What proof has he produced with his injunction application? What is his claim to?
only his statement.
As per
nothing
his
else.
statement, what is that? He
His
claims
state-
title by virtue of what? As per his injunction
He
application.
does not claim title over the property. He says that he does not talk about the agreement. His only allegation, averment that as per there was an arrangement entered into, it does not refer to the agreement.
Mr. Banerjee, as you very well know, at the ad interim stage, we have to proceed on the premise of the injunction application and the plaintiff averments and see whether on those injunction can be granted.
No documents produced to show his title.
Let us see his
Kindly the
averment.
order.
No,
Kindly-
let
kindly
us see the order
Kindly
first.
see the impugned order, page
Yes,
65.
absolutely. He has admitted everything, whatever you said.
Lordship asks that what documents he has produced.
No, whatever you are saying, he has stated.
Correct.
No suppression at all.
He has not referred to the agreement which contains the arbitration clause. It is only mere averment in the plain that this
No, but
is
he
the-
admits that it was given to him for renovation
Correct.
and giving.
But the fact is that he has not.
Now let us see how he has.
Yes, correct.
Let us continue with this.
He has not referred to the agreement which contains the arbitration clause. That he should have disclosed.
Arbitration clause is not an automatic bar.
No, I admit the only
You
exception.
have to file section 8, you know that.
The only
It's a waivable right.
It's the only exception is that if the agreement is a product of fraud, it is
No.
null and void.
Suppose you don't file your section 8 application before the first written statement.
Correct.
Then you give a go by. So the civil court will hear it.
That stage will arise if I file a written
Right.
But this
That is your answer.
correct. But Your Lordship, this
If
is
the written statement we filed, then we'll
this
consider
is,
that.
no, this is an appeal from the ad interim stage under order 43. I'm entitled to. Apart from order
Yes,
30,
you are entitled to file an appeal. Under order 43 itself, we are entitled to dismiss it. In fact, that is read with order 41 rule 11.
if I can satisfy Your Lordship,
Yes,
that is,
let us see the order first.
yes. Jitesh Sharma judgment available.
না কিন্তু রাইট কিন্তু কিছু এখান থেকে বেরোচ্ছে যেটা বলছে
Lordship, a particular wrong statement has been made on the basis of which the court has passed the order that the petitioner was given the right to occupy. That I will show from the agreement there is no right of occupation. That is the wrong statement and the suppression of fact, which I will show.
Oh, and the petitioner shall use and occupy state godown as a lawful occupier. এটা এভাবে করেছে। But at the ad interim stage, you have to proceed on the premise of their
Lordship,
aversions.
that
You
is-
go and file with
Lordship,
39
that was the law
or
or the
written
division
objection.
bench. I will like to rely upon an honorable division bench judgment. There was an earlier judgment of Justice Bhaskar Bhattacharya, which I have looked into.
Justice Ashok Ganguly's judgment is also there.
Yes, this says that if you file an appeal, the aberrance is in the plaint and the injunction has to be taken on true as correct. From that, you have to show to the appeal court if there is any ground for granting prior injunction or not. Now, so that judgment has been distinguished in the Bengal Club.
Bengal Club.
Yes, that says that no, in the appeal court can look into everything, even if there is suppression of fact, additional documents can be looked into in appeal.
Side Bengal Club?
Yes, yes.
Along with Bengal Club, give us a copy of the agreement also.
Yes, I will. Lordship will kindly take the agreement, page 67. Kindly have a look.
We have annexed here.
Yes. Lordship will look at clause 3 and 7. Page 68 and 69. Please says, Your Lordship, the second part, that is the defendant, the plaintiff, shall within a period of 9 months hereof arrange induction of tenant in respect of the said godown on the terms and conditions appended thereto. 5. The party of the second part shall reconstruct, relate the following said godown in RCC for up to 6 inches from the road level, and also second party may also cause the soil to excavate. 7. The proposed terms of the condition tenancy. This is an agreement regarding the proposed term for inducting a tenant. 7H. That the proposed tenant shall not store inflammable or combustible dangerous materials, whatever in the said godown. And also the arbitration clause, Your Lordship will find that clause Q, page 70. In the event of any dispute and differences arising out of the agreement, such disputes and differences shall be referred to the arbitration, and the award of the arbitration shall be final, binding upon the parties. So, any dispute arising out of this agreement between me and him will be referred to arbitration. So, in the plaint, Your Lordship will find the terms of the agreement on the basis of which the parties entered, the facts has been stated that this is the arrangement, but it does not refer to any agreement being executed or there being an arbitration clause. That is the suppression. Your Lordship, he should have. Your Lordship knows that if someone comes to court while for an equitable relief,
clean hands.
Do equity and with clean hands. Now, Lordship will kindly come to the pleadings in the plaint. Refer to, there is no whisper of the agreement. Then he should have said why the agreement is not applicable. Normally, when we file a suit, if there is an arbitration clause, we say that there is an agreement, but this arbitration clause, why it is not binding, we give pleadings on the plaint. That has not been done. Now, kindly see, the plaint starts from page 26. There is no right of occupation given, but he files a suit for occupation, being declared as an occupier. On the basis of that, injunction obtained. See, kindly see from paragraph 5, page 27. Paragraph 3. To at least state the correct facts. Then the court, if the court would have been satisfied, court would have granted an ad interim injunction. Or if not, then order would have been refused. But coming to a court by suppressing material facts, that is Your Lordship, then Your Lordship, the equitable relief should not be granted. Page 27, kindly see the amendments in the plaint.
Audit 2022 দেখা।
Yes, yes. I will. 2022 suppression. The lordship is on the plane.
Oh, give us some time.
Yes,
We'll going through the agreement. What is the consideration for this agreement? Because
55 lakhs. As that
but
is
is that stated?
recorded in the order. It is not stated in the agreement, but they have annexed the consideration memo at page 28. That is also recorded in the order. There is no denial to the fact. Now, whatever advice, your lordship, he is holding on to the property because he has given money. Advice, if your lordship, if he has given money, he can at best have a money claim. If he has a money claim, at best, I am saying that, at the highest, if he has a money claim at best, he should have filed a suit for recovery of the money. Why injunction? He does not have any right over the property. 41H, if your lordship.
Appeal admit kori, kore appeal application action fix kore di.
Lordship, only in the, if your lordship is willing to admit only one order I am seeking for, they should not create any third party rights in respect of the property, because that is my property admittedly, and will not store any combustible materials.
What do you say there?
That your lordship,
They are running a restaurant. How can we restrain them at this stage?
They are not running a restaurant from the godown. They are storing the cylinders.
Combustible material that will interfere with their business.
Lordship, but the agreement is very clear, and your
at this stage, no.
We have issued notices to KMC.
You have no possessory right as per this agreement.
Lordship, he has said the fact, but something to be added, Lordship. Lordship, in Zakaria Street, premises number 16 Zakaria Street, I am running a eatery there under the name of Delhi 6, very famous. So many reels were there. This is 17 Zakaria Street, that is opposite to 16 Zakaria Street. Now, this defendant is the owner. That is no doubt. Defendants in the 2019, if you see the date of the agreement, that is on page 67
yes.
of your application. 2019, he enters into an agreement with me and he grants me authority to look for a proposed tenant. And the terms and conditions mentioned in the agreement is with the proposed tenant. Proposed tenant will not do this, proposed tenant will not do that, proposed will not store.
This does not confer any possessory right also.
No, I'm not on that, Lordship. Now
you have to renovate and give it in tenancy.
Lordship. No, I was authorized to bring the proposed tenant. That is the agreement.
Yes, bring the proposed tenant and reconstruct also.
Reconstruct.
That
now,
part.
if you see, Lordship, clause 3 of the agreement, it says the second part shall within a period of 9 months hereof arrange induction of tenant in respect of the said godown, which expired in September 2020. I have taken the position since 2019. Now, after the execution of this agreement, then the landlord takes 55 lakhs from me. That is a receipt on page 25. Which they have not denied in their entire application of before.
Page 20?
25 of their stay application.
25 is the affidavit portion.
Oh, page 60, I'm so sorry. The entire page 25. I'm so sorry. 60.
This is a salami out of such and such for induction of tenant.
Correct. He has taken that money. This was not the part of the agreement. This is taken with me separately, 55 lakhs rupees. 51 is mentioned here. We have also awarded in my application that 4 lakhs we have given in cash in presence of 2 witnesses. This is whole entire cash transaction.
Date of agreement is not mentioned in the agreement.
It's not mentioned there. And in the agreement,
it appears to be contemporaneous. This is also 15th of December 2019.
Correct. And there is no disclosure of this money in the agreement. There is no whisper in the agreement.
You have spoken about this receipt in your plaint and
Yes.
So was that paragraph?
That is in paragraph, Lordship, may kindly see.
Just either the plaint or wherever.
But in the entry model,
yes, para 6.
The court has also relied upon this thing. Now, I am running the retiree and I'm using his godown since 2019 December. After paying the money, they have never raised any objection. The period of 90 days crossed in September 2020 where no proposed tenant I have brought in or they have been able to arrange it, but they are enjoying my money. And I'm enjoying the go down, no doubt, Lordship. We are storing my chair.
You have to have a legal right to get an
Still,
injunction.
So I have played for declaration for being lawful occupier. Number one, Lordship may kindly also visualize that.
Lawful occupier on the basis of what?
Because they have taken the money from me, 55 lakhs rupees. They have kept the money for 6 years and they have not even lodged a complaint against me or not a single notice given to me that why have you not brought the proposed tenant? We are waiting for 6 years. Now what happens?
This is only for salami. For
What
he
is
will
salami?
intact
But you have taken money, sir.
justice against the tenant
I
rent.
have not interjected, sir. Please.
That is
We
what
are,
everybody says.
we'll dispose of the appeal right now, if both of you consent.
No, no.
Lordship, huh? Now the
You're
second
not
point
consenting.
is
No, no, I want the appeal to be heard.
second point.
I want the
Second
order
point,
to go.
Lordship. If the agreement says 9 months, it starts from the cause of action starts from September 2020. Let us assume that there is an agreement, there's arbitration clause there with the proposed tenant.
Arbitration, we are not bothered at this
Lordship.
stage because there is no section.
So Lordship knows 3 years. They have not taken any initiative of any application, any section 9 or any section 11 against me for the last 6 years. Now today, when during the month of Ramadan, when my business boomed up for the selling of this product in Zakaria Street, what he did, he put a chain in the collapsible gate so that I will not be able to bring my articles from the godown. So my 10 days business was hampered, which compelled me to file this suit. And I've taken the plea that is I'm the lawful occupier there. Now these are the matter to be adjudicated by the trial court. They are holding the money and in their stay application, they have not denied.
202, 204 ingredients of contract actor do also come in because this is an agreement contract actor.
He was to induct tenants
coupled with a right because you took money.
Money, Your Lordship, the agreement also says that this will be adjusted against the rent, and I will not
Agreement
charge
does not
any
mention any
additional.
money.
No, no, it's not
Sorry,
mentioned.
Your Lordship.
The agreement says so.
No, no. Agreement says that the 2,000 rupees will be the rent. That
Agreement does not speak about any
no,
payment
the
of money.
55
Nothing mentioned.
2,000 rupees rent it says, which is also
That is for proposed
It
tenant.
does not speak anything about he's paying any money to you.
that
When
it
he
does not
gives
say.
that tenancy, then
But the agreement says that 2,000 will be the rent, which is also
that is a
reflected
different
in the-
aspect. That is when he gets a tenant. He has
correct,
not yet
memo of
got a tenant.
consideration. Your Lordship,
All
till-
these restrictions are against the proposed tenant. And for 6 years, I never objected.
No, we'll read 202, 204 of Contract Act into this. No admission of the appeal.
Grateful. Your Lordship will
We'll
hear
give our
me out.
reasons.
Your Lordship will hear me out. Your Lordship kindly also.
What do you?
Your Lordship will also kindly see the order. Your Lordship, apart from the fact that they have no right of occupation under the agreement.
No, we'll consider your documents, which you are.
Your Lordship, I have not placed the entirety of the facts, Your Lordship, with the judgments and all. Your Lordship, I have
Judgment on what proposition?
the judgment on the ground that when there is a suppression material fact, what should be the consideration and of the court, whether the ad interim injunction should be continued or not. When the
No,
suppression.
no, we'll say we'll consider your whatever document you are producing, which you say they have suppressed. We'll say that even if they suppress this is not material because of the other reasons. Because they're also relying on a receipt, which is contemporaneous with that agreement, which is not mentioned in the agreement. And they claim a right on the basis of that receipt also, that payment also.
Your Lordship, payment
is
at
independent.
best, they can have a money claim. Your Lordship will
And they have not denied in their
consider
application.
section 41
They
H
have
of
not
the
disputed
specific
this money. They have not disputed this
He
receipt.
has a money claim.
If it is contemporaneous with the agreement, Mr. Banerjee, then a question arises whether they have a right under section 202, 204 of the Contract Act. Whether you can terminate that agency if a right has accrued in favor of the agent.
Your Lordship, with regard to the 202 and 204 point, Your Lordship will kindly allow me to come back because this is a point taken by the court. Your Lordship, I need to satisfy
Don't
this
come
court
back.
about this. Your Lordship will kindly allow me to give a judgment on this because since this
You have heard you substantially.
point has come from the court, Your Lordship, I was not ready regarding 202 and 204. Your Lordship, agency, he was not.
Sections of law can always come from the
No,
court, Mr. Banerjee.
always.
This is not a factual thing we are
Your
asking.
Lordship will give me one chance to come back.
We are
on
giving you the chance, right or no?
this. Lordship will give me one chance or
No,
no. Senior to argue on this. Lordship will give me one chance on this.
No, not after hearing you at length.
No, Lordship, Your Lordship, this point of agency, kindly allow me to submit that this point of agency, he was never appointed. In that sense, no right was created.
You are relying on that agreement. We are also relying on that
Relying upon
agreement. We say that even if you rely on that agreement, we find that they have made out a prima facie case in view of the receipt which they have annexed to their plaint.
Lordship, this agreement was not disclosed before this.
We proceed on that agreement, Mr. Banerjee. You don't understand us.
Yes, Your Lordship,
We
I'm
say
saying
even if
what
the
you-
agreement was produced, we proceed on the premise of the agreement itself. We take your contention to the fullest. We agree with you that the agreement, even if the agreement is taken, whether it is German, that we can always consider.
But will a money receipt give right of occupation with regard to the property?
We don't answer advocates' questions.
No, no,
We
no.
answer those in
It's asking it. I am asking this to
No, Mr.
myself.
Banerjee.
Will a right of memo?
The
Your lordship
present
will- your
appeal
lordship
has
will
been
kindly
preferred
give me one
against the
chance to
grant of an ad interim injunction. Pushed up the plinth of the case of the plaintiff respondent in the court below was that the plaintiff respondent is that the plaintiff respondent is a lawful occupier of the premises and a consequential permanent injunction has been sought in support of such claim. Whose of next para, learned counsel appearing for the appellant contends that there was gross material suppression of an agreement entered into between the parties, pursuant to which the respondent entered into possession. Fusap, it is submitted that the respondent does not have any right, title, or interest in the suit property by virtue of the said agreement. Fusap, it is contended that due to such suppression of material facts itself, the ad interim injunction ought to be set aside. Fusap, learned counsel submits that the appellate court, while hearing an appeal against an ad interim injunction, can look into German documents if there is a material suppression by the plaintiff who took advantage of the impugned order. Fusap, next para, by placing reliance on the agreement in question, which is annexed at page 67 of the stay application filed in connection with the appeal, learned counsel argues that no possessory or other right has been granted to the respondent within the four corners of the said agreement. Pushed up, the said agreement was entered into only in the context of the plaintiff, in the context of the appellant, who is the owner of the property, intending to let out the suit property, which is a go down. For such limited purpose, authority was given to the plaintiff respondent to search out a prospective tenant, to renovate the property and to let out the property to such tenant on behalf of the appellant. Full stop. Learned counsel takes the court through the provisions of the agreement. It is highlighted that in terms of clause 3 of the same, the appellant was to arrange for induction of tenant in respect of the said go down within a period of 9 months. Such 9 months having elapsed long back, the appellant does not have any right even in terms of the agreement. Next para, that apart, learned counsel for the appellant points out that in clause 7 within bracket small q, an arbitration clause has been incorporated in respect of disputes and differences arising out of the agreement. Thus, the appellant divorced the law in approaching the civil court without first referring the matter to arbitration. Next para, upon hearing learned counsel for the parties, we find from the annexure at page 60 of the stay application of the appellant that the same is a receipt purportedly dated December 15, 2019, indicating a payment of rupees 51 lakh as salami out of 57 lakh within double inverted for induction of a tenant in respect of the suit property. Full stop. The remaining amount of rupees 6 lakh was to be paid by the appellant to the respondent as per the said receipt within 30 days thereafter. Full stop. Next para, as per the plaintiff case, the plaintiff claims possessory right on the premise of not only the agreement but the said receipt as well. In order to consider whether the non-mention of the agreement in question amounted to suppression of a material fact, we have to look at the effect which the agreement might have had on the outcome of the ad interim prayer of injunction, comma, if produced in the trial court. Full stop. We find from the materials on record that although the agreement was not cited, comma, the receipt showing payment of rupees 51 lakh by the appellant was placed before the trial court. Full stop. Next para. Even if we consider the agreement and take the clauses of the same into account, comma, the provision regarding arbitration does not per se act as a bar to the jurisdiction of the civil court in taking up the disputes referred to in the arbitration clause, comma, unless, comma, before the filing of the first written statement on the merits of the case, comma, the defendant in the suit files an application under Section 8 of the Arbitration and Conciliation Act 1996 and seeks a reference to arbitration. Full stop. Thus, comma, the right to have a reference to arbitration is not an absolute right, not an absolute bar to the civil court, but a right which can be waived by the defendant at a later stage. Full stop. Hence, comma, at the stage of grant of ad interim injunction, comma, the existence of the Arbitration Act could not operate as a bar. Full stop. We find from the agreement that there is no mention of any payment of amount by the appellant to the respondent. Full stop.
Respondent by the appellant. Respondent.
So to the by the respondent, thank you. To the thank you. To the by the respondent to the appellant. Full stop. Next para. However, comma, the receipt is prima facie proof that the payment was made contemporaneously with the agreement. Full stop. Hence, comma, even if the agreement was produced before the trial court, comma, read in conjunction with the money receipt, comma, it would tantamount to a prima facie case having been made out by the plaintiff stroke respondent insofar as the valuable rights accrued in favor of the respondent by virtue of the said payment. Full stop. Next para. Since the said payment is beyond the scope of the agreement, comma, we have to take into consideration the legal effect of sections 202 and 204 of the Indian Contract Act, comma, which provides that an agency cannot be terminated if a valuable right has been accrued in favor of the agent, or any authority has been any authority granted to the agent has been partly exercised. Full stop. In part exercise of the agreement, comma, as per the pleadings of the plaint and the injunction application in the code below, comma, some renovation work has allegedly been done by the plaintiff respondent and the plaintiff respondent is now in occupation of the property. Full stop. Even an illegal occupant cannot be evicted without due process of law. Full stop. As such, comma, we find that even if the agreement in question was produced in the trial court, comma, it would not have made a material difference in the outcome of the prayer for ad interim injunction. Full stop. Thus, comma, the non-production of the agreement does not tantamount, comma, in our opinion, comma, to gross suppression of a fact which is material for the adjudication of the ad interim prayer. Full stop. That apart, comma, the learned trial judge was justified in proceeding on the premise of the documents before him and before her, and as such, comma, we do not find any scope of interference at this stage with the impugned order of ad interim injunction. Full stop. Accordingly, comma, FMAT 116 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 stands dismissed as well. Full stop. There will be no rise to cost. Next para. However, comma, we make it amply clear that the above observations have been returned only in the context of considering the admission of an appeal against an ad interim order and shall not be considered to be binding at any further stage of the injunction application or the suit in the trial court or before any other forum. Full stop. It is made clear that it will be open to the learned trial judge to independently decide all further stages of the suit, including the injunction application.
Lordship, in many places, in case of appellant, it will be responded.
It will reverse that.
I'm grateful to your lordship.
Chop.
I'm grateful.
Grateful.
But kindly do not rebuke me like that.
I will rebuke you like anything. You're lucky that you are not within my arm's range.
That right your lordship always had. And we'll
No,
always
Mr.
have
Bhattacharya,
it.
sorry, but we did not find anything to interfere
No,
at
no,
this
no.
stage.
Your lordship is Milord. I told Milord. I'm grateful to your lordship.
Yes. Yes, Mr. Rai. Today we are facing stalwarts. Mr. Chatterjee, Mr. Bhattacharya, you.
Milord, I am not a
The others
stalwart.
are
Milord, kindly do not.
falling into insignificance. They are waiting for
Milord,
you.
We are the disciples
Milord, kindly do not put me on the same pedestal, Milord. Kindly do not.
Wrongly classified.
Wrongly classified. My lord, there are certain defects are there.
What did?
The preamble of the memo of appeal also not been properly been.
Second appeal. Then memorandum of appeal from a judgment and order.
Sir, I'll take care of the.
This is against what?
This is against appellate court judgment degree. It should be second appeal. And one thing, when a trial court judgment degree not filed. But I'm praying for some time, so I.
Excellent. You correct the memorandum, preamble of the memorandum, the caption of the memorandum.
And the
Preamble need not be. The caption should be correct.
preamble, my lord, the trial court defect number 3, my lord, probably, my lord, your lordship file. The trial court particulars have not been. I'll take care of it.
The memorandum has to be filed, Mr. Rai.
Practically.
So we'll give you the liberty to leave to correct the
Yes,
memorandum. What else?
And also
If classification has to. And
to file the trial court judgment and degree.
we find several defects in the memorandum of appeal. First up, the judgment, the certified copies of the judgment and degree of the trial court have not also been filed. First up, on the prayer of learned counsel for the appellant, we grant how much time? Fortnight? Grant a fortnight apostrophe time to the appellant to file the certified copy of the judgment and degree of the trial court. First up, leave is granted to the learned advocate and record for the appellant to carry out the necessary corrections in the memorandum of appeal in consonance with the report of the additional stamp reporter by tomorrow. Try to do it by today.
Yes,
By tomorrow, full stop, next para, upon such corrections being carried out, no, do it during the course of the day. By tomorrow, during the course of the day, full stop. Upon such corrections being carried out, the file shall be sent to the concerned department for reclassification of the appeal as a regular second appeal. Full stop. Upon such reclassification, an SAT number shall be allotted to the appeal. Full stop. Liberty to the appellant to mention the appeal for inclusion in the list afresh upon such defects being cured. এটা উনি কারেকশন করে দেবেন, তারপর পাঠিয়ে দেবেন ডিপার্টমেন্টকে, একটু বলে দেবেন যে যেন রিক্লাসিফাই করে। মিস্টার রাই, পার্সু দ্য ম্যাটার ইন দ্য ডিপার্টমেন্ট অলসো সো দ্যাট ইটস ডান কুইকলি। আপনাদের কিছু বলতে হবে না, হয়ে গেলে কারেকশন হয়ে গেলে পাঠিয়ে, এন্ড দেন মেনশন ইট এন্ড উইল টেক ইট।
41, my lord, I appear.
Yes, Mr. Chaudhary.
I don't know.
But you have Mr. Chatterjee as your adversary, so it's a difficult case. From the morning, he has infested the court.
It's easy for him, my lord, because I'm the adversary. But why adversary? I'm not adversary.
It's an adversarial system. For that only.
Not at all.
Mr. Chaudhary, sorry.
I have a, I don't know what
preliminary objection.
What your lordship's view is on this. Because, Esho, Bulu. Sir, to only ke jao.
Apart from the appellant, we have heard everybody.
Yes, yes. I don't know whether I'm to speak now or not.
Whether you will be given the permission to speak by Mr. Basu. Then he's gone. Then you are gone. There's the least chance there was, it's lost.
There was a divergent view, my lord, on this. I don't
What is the
know
objection?
what the
Yes.
lordship's view is. My lord, this interim order, which was granted, was till the 7th. That was yesterday, and it's
No.
been extended. This matter, my lord,
Our view is against your contention.
this is pending before the larger bench. whether my lord,
The Supreme Court in several judgments says it just because it's pending before a larger bench or the Supreme Court, we can.
whichever is my lord,
We have to take a view, Mr. Chatterjee. Our view is that the parent order needs to be challenged only.
Lord,
If this goes, the others are mechanical extensions.
that is, my lord, there are,
Those
that
are
is
not
Supratik-
fresh orders passed under.
Supratik Ghosh's case.
Yes, yes, we are
There-
of that.
There are 4 honorable judges,
Divergent views are there.
4 honorable division benches, which have held just the opposite. Now that was at
We
the
stick with
occasion-
Supratik because that's the parent order. That is the only adjudication which happens before the final hearing. Or if there is an order 39 rule 4 or final hearing of injunction, then we can appreciate. Extensions.
The larger bench, Mr. Mukherjee was appointed below as the amicus curiae. Justice Tandon was hearing the matter. As usual, Mr. Mukherjee was he finished his argument. What he said, of course, it's going to be heard again. What he said was that if the judge, while extending the interim order, applies his mind, then it becomes an appellable order, completely different from the earlier order. But if
The
he
presumption
doesn't-
is that judges generally don't
Yeah.
apply their minds.
it was only pending for my reply to that. I started one day, but there was no time required for that. What usually is done, my lord, in these situations and all other honorable courts is that little bit of time is granted and they are given a liberty to challenge the next order, and both of the appeals are heard together. That's usually done. I'm not saying that, my lord, it is what it is, whatever it is, but usually it's done. But apart from that, my lord, I am.
We'll deal with that objection, Mr.
I'm
Chatterjee,
not-
but we'll take a
it's not
contra
an
view.
objection, my lord. It is basically what I'm telling your lordship.
No, you're right.
what
You're absolutely right. There's a
situation-
divergent view on that. If you take that as a formal objection, we'll
I
have
am
to.
informing your lordship that this is a situation and it is pending before the larger bench. The arguments have commenced. Usually what is done, my lord, in the other honorable court, Mr. Basu is here. I'm sure my learned senior friend is also here. Usually it was being done even by Justice Tandon, was that they were given a taste time and
Usually means by Justice Tandon only.
yes.
What is so usual about? Justice Madhuresh Prasad.
Because there was after that your lordship came. So this is what it is.
No,
apart
Justice
from-
Tandon's view is one of the valid views, definitely.
Because it's
Definitely,
there,
this is a solid view.
my lord,
But-
it was referred to by Justice Hiranmaya Bhattacharya.
Yes, definitely. All of the people who have
All-
passed orders, all.
Have all taken that view.
But this is my view. But if you take it as an objection, I'll have to decide. I will decide. We will decide that.
Your lordship, my lord, takes up the appeal. I have got no problems on that as well at all. But this is what my lord, when my time comes to submit, my lord, I
Yes,
will-
because at this stage, probably even if we admit we don't, we
is
won't
no
be
scope
granting
for
stay of operation of. What is the case, Mr. Chaturvedi?
Lord, before I start, Lord, I have a small reply to what Mr. Chatterjee said. Day before yesterday, possibly the interim order has not been extended.
Not been extended day before yesterday.
No, I found out. I was
Yesterday.
thinking that
Yesterday, not extended.
it was not extended, then this anyways goes. This anyways. But I took the instruction, my lord, that it was extended.
No, if it is. Yes, Mr. Chaturvedi, what do you say to that? Yes.
Lord,
What is your argument on?
yes. Lord, a trust enters into a memorandum of understanding.
I'm sorry. We are sorry. Who?
A
Trust, right.
Lord, enters into a memorandum of understanding with, my lord, a vocational institute. The memorandum of understanding, among other things, provided for that the representatives of this vocational institute would be inducted into the trust and an academic institute would run in the name of the trust. This academic institute would be managed by these representatives of the trust as well as the vocational institute. So the dispute arose with regard to management and affairs of this institute, in as much as the vocational institute had the expertise, so it was managing the affairs. Insofar as the funds were to be sourced, checks were sent to the representatives of the trust who used to sign these checks.
You are the vocational institute or the trust?
But I appear for the trustees of the trust.
The original trustees.
The original.
Some of them, yes.
The trustees of the original trust. Mr. Basu is not appearing for the trust. But the dispute arose in as much as these trustees, they asked for the accounts, they asked for the employees on roll of the institute,
Yes.
and they asked for the details of the checks which are being sent to be signed. That is where the dispute started from.
Who asked? You are asking.
I asked. Now, but the suit was filed immediately after this. And this suit, is camouflaged as a suit under section 92. But I raised the preliminary objection as regard to whether the management and affairs of this institute being under dispute could be camouflaged as a dispute with regard to the management and affairs of the trust and can be brought within the ambit of 92. I'm sorry. And can be brought within the ambit of 92 or not. But the interim order was prayed to the extent that they should be permitted to operate the bank account.
The bank account is designated only in the name of this institute, or it's a trust's account.
It's a trust's account.
Then your first ground goes.
But
it's management of the trust.
It is not with
financial management at least.
But the dispute is with regard. Kindly see me, it is with regard to the dispute of the institute. But the funds can come from elsewhere. It is not, the funds are not in dispute.
All right.
It's a management and
it's on a much narrower conspectus. I mean, regarding that institute.
Yes.
So not management of the trust as such.
No.
All right.
As to who are on rolls, you are asking for salaries. Injunction was prayed because there was an emergent situation.
Institute is a registered organization. A separately registered.
George Telegraph.
So it's a society.
George Institute. Yeah, George.
Whatever under that George umbrella. This is under registered under the Societies Registration Act.
Yes.
It's a separate society then.
But,
the institute you are referring to.
But it is.
The trust is separate from this institute.
Yes, yes.
It's a separate registered society.
It is registered by Macau University, and the emergent situation was that the students' admission fee is to be paid, and the last date is about a week thereafter. That was the emergent situation shown in the injunction application. A caveat was filed on behalf of the managing trustee of the trust. Kindly now comes to the impugned order. My lord would find at page 187 of my stay application.
You can refer to the internal pages, Mr. Chodudhury. We are looking at the memo. Yes. So, just first page of the impugned order.
My lord. So this is order dated 7th March 25.
Yes, yes.
Kindly sees the fourth paragraph starting with the words, it appears that.
One caveat has been done.
It appears that one caveat being number 2074 of 2024 has been filed in connection with the instant case. However, though there is a caveat pending, but on careful perusal of the same, it appears that it is lodged by one Mrs. Anjana Maharia on behalf of Gayatri Chetna Foundation, but there is no resolution and authority of the said foundation. Furthermore, from the caveat, it appears that the caveatees are related to George College and not with Gayatri Chetna Foundation. As such, considering the urgency of the matter, I find that the record may be taken up for hearing of the interim prayer of the plaintiffs. So, the caveat is read down on two grounds. One, that there is no authority. And second, that the plaintiffs are the representatives of George. Kindly number turnover.
We don't understand the second point of the court.
Blood.
Caveatees may be anyone. Caveatees may be anyone.
Anyone.
Caveator was
the caveator must be an interested party. That's all.
Yes. Anyway.
This is a suit.
George College has not filed the suit. That is the
no.
That is what the court is probably referring
Yes,
to.
yes, and I
Caveat is that George College, which has not filed this suit.
I shall show from the plaint.
All right. Your client is?
The trust.
Yes, caveat by your client, right?
Who was the pro forma defendant?
The question is, who are the caveatees? Caveatees means is the plaintiff. Yes. So plaintiff is if you have not filed a caveat against them, that is what apparently is the second premise. Anyway, Mr. Chaturvedi, please.
This is a suit under section 92 of CPC praying for decree of perpetual permanent injunction. The suit relating to a charitable trust, and as such leave under section 92 is hereby granted. By filing instant application injunction petition, the plaintiffs have prayed for an interim injunction order directing the respondents number 1 to 5 to sign the required checks of Bank of Maharashtra.
Mr. Chaturvedi will admit the appeal and hear it out on a day, because we cannot grant stay of operation of the impugned order at this stage.
Lord, kindly sees what interim order has been granted at ad interim stage. Lord, kindly have a look. Lord, kindly sees that the next paragraph, having considered the submissions of the learned advocates for the plaintiffs and the documents annexed with the application, it appears from the copy of documents that there was huge transaction of so-and-so deposited by the students in the concerned bank account, but only 136 has been debited from the said, and the present balance is so-and-so. It also prima facie appears from the documents that in spite of repeated reminders, the amount was not released from the respective academic institution. The tentative last date for form fill-up is 13th March 2025 to 18th March 2025. The order is being passed on the 7th March 2025. Prima facie, it appears that there is a letter for non-payment of salary for the last 4 months. It also appears that if injunction is not granted, then future of many students would be ruined. As today it's 7th March and the last date for form fill-up is 18th March. It is also submitted that the amount of 3 months is immediately required to run the institute. So I am of the considered opinion that an interim order of injunction should be granted so that the future and academic career of many students would be hampered. Now kindly see the ad interim. The respondent defendant number 1 to 5 are directed to sign the required checks of Bank of Maharashtra.
Mandatory form.
Yes. For disbursement of examination fees and semester charges in favor of Macaut. Now the statement which we have obtained, because they were to furnish a statement, we obtained a bank statement. Not a penny out of the amount which they have secured from the bank has gone to Macaut.
This has been implemented.
That is a later development also.
This has been implemented. They have withdrawn that amount.
Yes, yes. Now, the respondent 1 to 5 are directed to sign the required number of checks Bank of Maharashtra for disbursement of the examination fees and semester charges in favor of Macaut. And also respondent number 1 and 2 are directed to execute all checks for disbursement along with petition number 1 for effective and smooth running of the pro forma defendant, and further in event of failure, the petitions number 1 and 2 are permitted to operate the bank account of the pro forma respondent.
You have executed the checks. You had executed the checks.
No, we have not. They have, because if we
Respondents were directed to execute.
If not, then they would do it. The respondents, defendants number 1 to 5 are directed to sign the required checks.
Yes.
Of so and so and semester, and also respondent number 1 and 2 are directed to execute all this so and so along with the petitioner for effective and smooth running of pro forma, and further in the event of failure.
All right.
So now everything is with them at interim stage. At interim stage, a caveat is filed. The caveat is read down. I am directed to comply.
It's of a mandatory nature. We can consider stay. I mean, subject to it.
Page number. Now, kindly will not see is page 283.
What about you say that the injunction has not been extended? Then what is the urgency of taking up today? I mean, we cannot finish today. That's why you are saying.
Mr. Chatterjee says that it has been extended.
Has been extended. Page 230?
280. But this starts from page 280. Kindly, my lord, sees page 280 first. This
Yes.
is, my lord, the Bank of Maharashtra account. And my lord would say, my lord, of all the checks, my lord, there is none which has, my lord, gone in favor of Makaut. Yes. That. And then, my lord, kindly comes to page 283. Mr. Basu is vocal because above all the funds belong to Mr. Basu. Trust.
Why doesn't he prefer an appeal?
Lord, kindly, Lord, kindly see, Lord, 26th March 2025, self. Kindly see above that, 19th March, self. These are self checks. And not, Lord, in terms as the urgency made out to be.
Right.
And at ad interim stage, my lord, this is something, my lord, which I have suffered, my lord, whether page, page. Lord, kindly come to page 282, my lord.
Target. 119, serial number 119.
Lord, kindly see serial number 119, 119.
Yes.
Lord, serial 119, self
1,63,2.
1 lakh.
Yes.
And a total amount of 29 lakhs, my lord, have been withdrawn. In
Right.
terms of this ad interim order, which, my lord, I, with the deepest of respect, Lord, say is final in nature. Lord, in so far as, my lord, reading down the caveat is concerned, Lord, could I? Huh?
Caveat was there. Caveat is not for a caveat, it should have already go immediately.
CW 90 CW and 288. This was what you were going to submit us.
No, Lord, I was showing, Lord.
Your appeal is also before us. Since we are here, yes.
Lord, kindly sees, Lord, Rule 40, capital A, sub Rule 10 of the Civil Rules and Orders.
Then Rule 40A.
Rule 40, capital A, sub Rule 10.
10.
When a caveat is not in proper form or is otherwise defective, Lord, I say, assuming that the caveat was, Lord, within the otherwise defective, Lord, the officer receiving the same shall forthwith place the matter before the presiding judge of the court concerned. The presiding judge may allow the defect to be removed within such time as he may direct. It could not have been ignored and let the hearing being proceeded with.
Yes.
ভালো লিখবে দেখো।
Yes.
Lord, the second objection, why, my lord, the learned trial judge, Lord, did not think it fit and proper to entertain the caveat was because the plaintiffs were the representatives of George and not of the trust. Lord, kindly sees the plaint at page 231. Kindly see the first paragraph, the fourth line. I'm sorry. But
This is the injunction application. Page 231.
yes, but in the injunction application, this is a photocopy of the first few paragraphs. But kindly sees the fourth line starting with the words, the petitioners and the respondents are the present trustees.
Yes.
This was an application on which the finding is returned to the effect that
No, court does not say that caveator is the George, not Georgian. Court says caveatee. Caveatee is the plaintiff.
Yes, yes, and this is
Plaintiff is Manoj Joshi and others. Court apparently proceeded on the premise they are not George. Your caveat was against George.
No. My caveat was against the individuals as well.
The caveat copy we want to look into.
Kindly sees Manoj Joshi, trustee of George.
That's hyper technical. We do you have a spare copy of the caveat? We want to keep it on record. Yes.
But I have a copy, spare copy.
Oh, then we'll keep it on record. We are asking.
But just one copy, Milord. I'm sorry, I should have brought two copies.
এদের আছে এদের বলছে ট্রাস্টি মনোজ যোশী ট্রাস্টি বলেই বলছে কিন্তু ফার্স্ট প্যারাগ্রাফে যেটা পিটিশনার বলছে সেটা হচ্ছে যে ট্রাস্টি বলেই তো ওদের সেই ক্যাপাসিটিতেই করে yes prima facie satisfied. What about the other ground you are not authorized duly to lodge the caveat and all? First ground of
I'm the managing trustee. I'm the managing trustee in the original trust deed, which is not at page 40. This is relied upon by the plaintiffs also. Page 40.
by
This
pen
is a trust
by
deed
pen, that pagination by the pen.
by the pen. This is not a trust deed which begins at page 28.
Yes.
Kindly see the date, Milord, of this trust deed, 4th December 2018, which was, Milord, to be found at page 231, which I just showed to my lord. So they are relying on this trust deed, the plaintiffs. And at page 40, in paragraph 17, Milord, the caveator's name is there as a managing trustee. This trust deed, Milord, has not been altered. Only thing is that the representatives of the George have been inducted in the trust in terms of the memorandum of understanding. So at the stage of Lord injunction, Lord, as I have Lord understood and learned law from my lords, Lord, that only the documents,
Really?
my lord's court.
Really?
This court. Yes, Mr. Chaudhary, we get your point.
That the documents, Milord, on record, Milord, will be looked into.
Yes, but we cannot look into further documents today.
Yes.
So we'll continue tomorrow with this one. Day after tomorrow is the appeal hearing day.
As a continuing matter, if
Tomorrow
it would
we
be.
have already, there is a resolution.
Again, resolution why? We are not defying resolutions, particularly if taken by Mr. Basu. That's why. That's why we can defy. Particularly if it's taken by you.
No, Justice
You are the
Banerjee-
architect of this mission.
Justice Conrad Banerjee's,
That we have.
remains are coming. So tomorrow.
Remains are coming. Remains today, the cremation was today.
No, no, no.
11:30 tomorrow. Oh, acha, তাই ঘাবড়ে গেলাম। So we'll
As a
keep.
continuing matter on Thursday, if it could be.
No, tomorrow morning this will be taken up.
There is no urgency anymore.
10:30. Oh, 10:30.
I'll tell your lordship, there is no urgency anymore. What my learned senior friend doesn't tell your lordship.
You have swindled whatever is there from that.
Doesn't tell your Acha, Acme Raman,
Half of it is in your pocket.
my pocket.
Yes, as council fees.
Not a thief. Tell.
Not a thief. You are not a thief. You're not a thief.
Now what
You're the
happened?
beneficiary of a theft.
Well, what has happened here is this institution is affiliated to Macau. That's Maulana Abul Kalam Azad University.
No,
of
but
Technology.
we cannot pass. We have to adjudicate if we have.
Lordship, I'm saying why there is no urgency. What happens is the university takes money directly from the
দরজাটা খোলা রেখে দিও দরজাটা ভিজিয়ে রাখো যদি শুনি তাহলে তারপরে গরম আছে হালকা
takes money directly from the students. When there was the admission going on, my lord, we had taken the money from the students to give it, my lord, to the university. Now, second now, then we gave the money back to the students, and that's what he has shown your lordship.
Self checks.
Same.
1,63,000.
Yes, it's all there.
What's all there?
Those are for maintenance. We can give accounts on that. We've been asked to give accounts. And we
Self
filed-
checks.
Yes, yes, we filed it in the court below, the accounts. Nothing at all. There is no problem at all. Lord,
We
they're
will
trying
look
to
into it.
find out something, Lord, which is not there. And with respect to the other point, Lord, I'll answer that on the next. But with respect to urgency, Lord, this has already been complied with. The interim order which was granted, that's already been complied with. So that today, my lord, there is absolutely no urgency.
Anyway, although we commence hearing of the matter, comma, the same cannot be concluded today due to paucity of time. Let the matter be listed tomorrow under the same heading. It will appear in the list tomorrow if there is a resolution.
Resolution is already taken.
Taken.
Could it be, my lord, Thursday, my lord, to ameliorate
Thursday we
difficulty?
take up hearing matters first.
As a continuing matter, my lord, this will take just, my lord, about 15 minutes of my lord's valuable time.
Really?
No, tomorrow you have some difficult. Otherwise, if it is on tomorrow's list, if there is a 10:30, if you both of you are not there, will not take up. Then it goes to Thursday automatically. First,
If it is,
if there is another resolution, then we'll definitely reach these matters and dismiss it.
if it is listed as a continuing matter, my lord, subject to my lord's.
We are not
consent.
marking matters part heard unless substantially heard.
No,
On
no,
the
not-
first date, we are not.
Not as part heard. It's only as a continuing, under the heading continuing matter.
There is no such heading in our. Okay. Tomorrow original side at 10:30. So in any event. No. Introductions. We have decided not to introduce any new thing and not to keep matters part heard normally unless it's really part heard. Order for 10 stage part heard. No. That hits our status as a high court. We have heard substantially, Mr. Chaturvedi. We have said that we have commenced hearing for other purposes.
Because he gets, my lord, the money out of the other trust. Wants to record that.
Anyway, we recorded something. So
You might not have purchased that.
we have
but you
indicated
might
that we have heard.
purchased other
the
things
comments here.
as big as that.
This is, my lord, my lord, this is relevant for those on my left side, my lord.
Yeah, no.
And he's the richest one.
We won't comment on that.
And deeply obliged.